In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons acting individually or in combination with others in the presidential election of 1972, or any campaign, canvass, or other activity related to it.
From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC senior correspondent Robert McNeil.
Good evening. Today was the 5th day of the Watergate hearings, and today we got back to the main narrative. For the past 2 days, the evidence has strayed into the question of attempts to cover up the Watergate operation and into contradictions in the evidence of James McCord and his former attorney, Gerald Alch. This morning, Alch got the most rigorous cross-examination of any witness so far, and one senator threatened perjury proceedings if the discrepancies could not be resolved. This afternoon, the hearings returned to the original game plan, the stories and motives of 2 more of the men connected with the Watergate break-in. Because progress through the original witness list has been so slow, the committee today announced an additional 3 days of hearings in the first week of June.
Senator Sam Ervin, the man from North Carolina who is running this spectacular, took a stronger personal role in today's session, and as you will see, he demonstrated 2 of his most famous qualities, tenacity and charm. After the day was over, the senator sat down with NPAC's Peter Kay to discuss the progress of the hearings thus far.
We have learned, gotten evidence which indicates that some persons have formed a conspiracy to try to disrupt the process by which presidents of the United States are selected. We haven't established identity of all of these persons, but we do have evidence indicating that was the purpose of those who broke into the Watergate, or at least the ones that sent them in there, whomever they may have been.
You've added 3 more days of previously unscheduled hearings week after next. Why is that?
Because we decided that as long as that it'd be well for the interests of the country for us to get these hearings to as speedy an end as possible, because I think that they are upsetting the economic situation of the country, and a lot of people are bringing a lot of concern. And I might add, the reason I asked questions today, I tried to bring out what I considered the salient points on the witnesses' testimony in a fashion where they could be understood readily.
Now, that wasn't all Peter and Sam Ervin discussed, and we'll run a longer version of the interview at the conclusion of the hearing playback later tonight. Robin?
Watching the hearings with us are veteran Washington journalist and author Alan Barth and Adrian Fisher, Dean of Georgetown University Law School. Gentlemen, what points fascinated you most in today's hearings, Alan?
I think that what disturbed me most and shocked me most, too, was a sense of amorality that pervaded the testimony, a denial of individual responsibility, if you like. I jotted down something that one of the witnesses said. It is not customary in a hierarchy to question your superiors. Now, that, I submit, is a profoundly un-American observation. And I think this country needs to return to a kind of morality which obliges every individual to judge the quality and the character of his own conduct. I think there's been revealed in these hearings a terrifying kind of abdication of personal responsibility.
Dean Fisher?
Well, I would look exactly the opposite side of the coin. Mr. Barker is a man who, by his own lights, is a moral man. He is quite probably prepared to make the supreme sacrifice, die what he believes in. Yeah, this man, obviously sincere to the point of being a zealot, misplaced sense of loyalty, obvious courage, participating in a paramilitary organization, operating under CIA sense of rules. I find it very difficult to listen to a person on television. I was frightened by this, who says we operate under the old rule that if you're caught, we'll rescue you, and don't deny everything. We'll get you out. We'll get you out of the enemy's custody. When the enemy turns out to be here, either the Democratic Party or the district police. And the notion that this sort of a thing is applied to U.S. domestic politics, I find absolutely appalling. Unless we can do something about it, we're all in trouble.
Thank you, gentlemen, and we'll be talking to these two distinguished gentlemen later tonight at the conclusion of tonight's playback. All right, the new witnesses today offer two different portraits of men whose lives were drastically altered by the Watergate affair. The first new character today was Bernard Barker, who remains unashamed about being caught inside Democratic headquarters. Barker, who was born in Cuba, said he resents implications that he was a mercenary, a man who did what he did just for the money.
Resent, very emotionally, the word that we were hired. There was no need to buy our silence. We are not for sale. And that this must be said because this represents our feelings. By this, I don't mean that we are perfect, that we're not full of all sorts of defectious persons, that we consider ourselves superior beings to anyone. We're just plain people that very deeply believe that Cuba has a right to be independent.
The other man you'll meet tonight is Alfred Baldwin, the former FBI agent who served as Martha Mitchell's bodyguard and listened to those Democratic telephone conversations. Unlike Barker, Baldwin is upset about his role.
I have attempted to tell the whole truth of this incident to the government. I believe then, as I do now, there is only one government, and I have talked truthfully to the United States Attorney, as I will do to this committee. I do not regret this decision, although my life was that time shattered. I cannot now find employment, and I have been without funds. My family has been disgraced. I believe that since I was working for the former Attorney General and White House officials, I would not question to do what I was asked to do. Now I regret only that decision. Regardless of this, I shall now follow through with my commitment to tell the government and the American people the truth.
Well, in case you want to plan your viewing, not to speak of your bedtime, here's a hour-by-hour rundown of what you'll see tonight. Testimony came in hour number 1 from Gerald Alch, the attorney who said his reason for being there was to refute false accusations made by his former client, James McCord. Alch added that he never suggested the CIA be brought into the trial as a defense for McCord. In hour number 2, Alch suggested that a lie detector test might be used to resolve conflicts between his testimony and McCord's. Under further questioning, he said McCord's calls to bugged embassies did not amount to a contrived defense for McCord because he was told the calls were relevant to the case. In the third hour of grilling, Alch is pressed about talk of executive clemency. He said he could not have passed on any offers of clemency because he did not know anyone at the White House. Also in the third hour, convicted burglar Bernard Barker testified that he undertook missions for E. Howard Hunt because he hoped that Hunt would aid in the Cuban liberation movement. Barker said his mission during the break-in was to find documents to photograph. In the next hour, Barker says that Hunt did not pressure him to plead guilty or offer clemency, but he did suggest there was overwhelming evidence against the 7 men indicted. Barker maintained that his decision to plead guilty, despite his attorney's advice, was entirely his own. But under questioning in hour number 5, Barker says he did not question the legality of the break-ins because he had faith in his superiors, especially Hunt. He also did not question the arrival of unknown attorneys at the jail because, as he put it, I wasn't there to think. And in the final hour, when Alfred Baldwin took the stand, he told of surveillance work outside the offices of anti-war senators and congressmen. When he was hired, he was told to identify himself as an employee of the former Attorney General John Mitchell. He did so when asked by police about an unlicensed revolver he carried. And now to the 5th day of testimony, and Senator Sam Ervin with his gavel.
Gentlemen, I hope you can desist very speedily about taking pictures because we're a little late getting started. The committee will come to order. The committee has had a meeting this morning and decided to hold hearings in addition to those previously scheduled for the 12th, 13th, and 14th of June, to hold hearings on the 5th, that is Tuesday, the 5th day of June, Wednesday, the 6th day of June, and Thursday, the 7th day of June. The committee has received requests from Mr. McCord and Mr. Fensterwall for opportunity to be heard before the committee. The committee is going to pursue the list of its scheduled witnesses. The committee will extend to Mr. McCord and Mr. Fensterwall an opportunity to furnish statements in writing what they wish to testify to, and under oath, and under sworn statements on affidavits, and also give them an opportunity to meet with the staff and see what it is they want to testify to. But the committee does not intend to get bogged down with a controversy between lawyers, neither of whom, according to the evidence for the committee, have any personal knowledge of the matters the committee is investigating, except insofar as they may have gained them through the trial. But so we'll proceed at this time on the assumption that if Mr. Fensterwall and Mr. McCord wish to testify further for the committee, they first give us a sworn statement as what they propose to testify to and consult with the staff. We see no reason to put Mr. McCord on the stand to repeat anything he's already said before, and we see no reason to try to decide a controversy between the two lawyers with respect to their personal conversations at this time, unless they can show it. We'll proceed with the
Mr. Chairman, thank you very much. I might say I entirely concur with the statement that the chairman has made. I think it would not serve the purpose of moving these hearings with expedition to get into rebuttal, surrebuttal, and re-rebuttal. I do think that it's important that the rights and the reputation of every witness be protected. Therefore, I'm delighted that the staff will conduct a further interview with Mr. McCord and will now interview Mr. Fensterwall in order to advise this committee, for the staff to advise this committee on the desirability of having them as witnesses under oath at a later time. But I think we ought to proceed, and I'm happy to concur in the statement of the chairman that we should proceed with the ordinary witness list. And I'm especially pleased that in the interest of reaching the facts as soon as possible that we are going to have this extra session so that we can proceed quickly. Thank you very much, Mr. Chairman.
Mr. Chairman, just one further comment. Mr. Fensterwall did inform me just before the committee convened that he would immediately after Mr. Alch's testimony file a sworn statement before the committee. Now, Mr. Alch,
yes, sir.
First, could you again tell us, you indicated what fee you received from Mr. McCord. What was that fee?
$25,000 plus expenses, which expenses have not been received.
Yes. Now, could you tell us in what form you received that money?
Periodic payments in cash, with the exception of the last two installments, which were in the forms of cashier's checks in relatively smaller amounts of $1,700. The bulk of the money received was in cash in $100 bills.
In $100 bills. Now, did you have any knowledge or information or belief as to where the money was coming from?
No, sir, and I believe that in one of Mr. McCord's depositions, he stated that at the time he paid me my fee, he did not tell me where it came from, except that it came from him.
Did you, in October 1972, ever meet with Mr. McCord and urge him to urge the Committee for the Re-election of President to give him more money so that you may have any additional fee?
No, sir. There was a conversation where, as I explained yesterday, the original payment of fees, the schedule of the original payment of fees, was not being adhered to by Mr. McCord. And I asked him whether or not, when I might expect more money in accordance with the schedule that he had told me. He told me that to bear with him, that it would be forthcoming, and I told him that I would.
Now, it was obvious, Mr. Alch, from the length of your statement and the manner in which you delivered it, that you were quite upset with your former client's statements. And what I would first like to do, and I think would be helpful, is to isolate the specific statements made by Mr. McCord which you find and did find objectionable. And correct me if there are additional ones, but I think there are two main areas that I have isolated from his statements and your statement. One, his statements in his memoranda of May 4, 1973, that on two occasions, one in the Monaco restaurant and another time in Boston, that you suggested that he based his defense on CIA involvement. And in that, the reference to what you might be able to do with Mr. Schlesinger in terms of forged documents and things of that nature. And the second area of complaint is his statement that you participated in having him exposed to an offer of executive clemency. These appear to me to be the two main areas of his statements which I think you find objectionable and was covered by your statement.
Yes, sir.
Right. Now, as to Mr. McCord's first complaint, that you suggested he use a CIA involvement as a defense, it is true, is it not, that the question, at least of CIA involvement, was the subject of discussion between you and Mr. McCord on two occasions in December, one at the Monaco restaurant and another time in your office in Boston.
In this way, Mr. Dash, I specifically asked him whether or not there was any factual basis to the contention that the CIA was involved.
Yeah, but there was that discussion. You did raise that.
I said it just that way.
Right. Now, did you on either occasion show Mr. McCord a statement from a D.C. police officer, Gary Bittenbender, indicating that Mr. McCord had told Bittenbender that Watergate was a CIA operation?
Yes, sir. That statement had been provided to me pursuant to my discovery motions filed in the case by the government. It was a report in which it quoted a District of Columbia policeman, Mr. Bittenbender by name, as saying that at the time of Mr. McCord's arrest, I believe at the District of Columbia jail, Mr. McCord said, referring to the other four men that had been arrested with him, "These are all good men, ex-CIA men." I naturally called that to my client's attention because there loomed the distinct possibility that that statement might be introduced against him at trial. In fact, it was not.
All right. Now, Mr. Alch, in the statement that you submitted to the committee, as you read it, that was not included in that statement. Is that true?
It was not.
There's no reference to your mentioning to Mr. McCord that you did have that statement from Officer Bittenbender.
It was not, sir. I believe I mentioned it when I met with you the night before my testimony.
Well, that is true, but was there any reason why that was left out of your statement?
No, sir.
Now, did you ever mention during either of the two meetings in the Monaco restaurant and in your office in Boston when you asked Mr. McCord about the CIA involvement, did you ever mention during either of these meetings the name Victor Marchetti, who might be a witness on CIA training?
I did mention the name Victor Marchetti, not in the context of his being a witness. It came up this way. In the course of discussing Mr. McCord's background with the CIA, I mentioned to him that I had recently heard that a man by that name had come out with a book about the CIA. I mentioned that to Mr. McCord. He said to me words to the effect that Mr. Marchetti was not in good grace with the CIA or any ex-members of the CIA, said he didn't think highly of the man, and that was the extent of the conversation.
Did you know Mr. Marchetti at all?
Never met the man in my life.
Was there any discussion as to whether Mr. Marchetti would be a good witness on CIA training to indicate that CIA men are trained to disavow any relationship with the CIA?
There was a discussion with Mr. McCord with regard to his background of the CIA. And in that context, I mentioned to him whether or not Mr. Marchetti's book might be a good reference point. He said it would not be.
Now, after your meeting in December of 1972 at the Monocle Restaurant with Mr. McCord, did you call your partner, Mr. Bailey, and raise the question of the CIA defense?
I did.
And what was the nature of that call, and what did Mr. Bailey have to say?
I would constantly keep Mr. Bailey advised of the developments of all cases that I was working on. In the course of my conversation, and this conversation took place after the meeting at the Monocle, but prior to my meeting with Mr. McCord in Boston, I told him of the conversation that had taken place in the lawyer's office, and told him that I had asked Mr. McCord whether or not there was any factual basis to the CIA involvement. As I told you yesterday, Mr. McCord did not specifically respond to that question. It was my impression that that topic was going to be raised at our next meeting in Boston. Mr. Bailey told me that unless Mr. McCord or anyone else could come up with any factual evidence of any CIA involvement, that if Mr. McCord wished to pursue that defense without any such factual evidence, that I was to withdraw from the case and that I was to tell that to Mr. McCord. When Mr. McCord met with me in Boston at our next meeting, he initiated the conversation by saying to me, there is no CIA involvement, and I'll have no part of anything that's going to put the blame on the CIA. That rendered my withdrawal direction from Mr. Bailey moot.
Right, but that was a significant discussion with Mr. Bailey, was it not, concerning the CIA involvement or the defense of the CIA involvement?
I wouldn't say it was significant in the sense that I keep Mr. Bailey advised of all cases that I'm involved in which he's not involved in. He's the head of the office, and his policy is that I let him know what I'm doing at all times.
But it did raise the possibility, from Mr. Bailey's suggestion to you, that you might withdraw from the case if it was pushed.
Those were his words to me.
Yes.
If there was no factual foundation presented to me for it.
And that discussion was not included in your statement before the committee. Is that true?
It was not.
Right. Now, in your statement on page 10, you say that during a meeting with counsel for defendants in December, and prior to your Monocle meeting with Mr. McCord, that, quote, the question arose as to whether the CIA was involved, unquote. Could you tell us how the question arose, who raised it?
This was at the meeting in Mr. Bittman's office, attended by the lawyers. It was at that point that I wanted to announce to the other defense counsel what my contemplated defense would be. I did so. I told them that I was contemplating the defense of duress based upon what my client had told me. The reaction seemed to be that this would only be applicable to Mr. McCord, in view of his being the chief of security, and that this particular defense could not inure to the benefit or could not be utilized by any other defendant. My response was, well, that's my contemplated defense. That's what I'm going forward on. It was at that point that the question was raised of whether or not there was any CIA involvement.
Now, could you know how that was raised is the question? Who raised it?
I'm not sure. It may have been Mr. Bittman. I can't be positive. That's a possibility. But may I stress that when it was raised in this type of way. Is there any CIA involvement in this thing? And at that point, it was pointed out the fact that all defendants had some prior connection with the CIA, and at least one of them had been found with documents which purported to be, or were alleged to be, forged CIA credentials.
Now, and then, as I understand from your statement, that each of you were going to contact your clients and ask that question of them.
Yes, sir.
Yes. Now, were you aware, Mr. Alch, of every contact that may have been made with your client by others who may have suggested the defense of CIA involvement to him?
No, sir. I only knew what he told me.
Therefore, that any pressures that could have existed on Mr. McCord, you might not have been aware of. Is that correct?
Entirely. As I pointed out yesterday, Mr. Dash, I do not come before this honorable committee to offer any judgment or opinion on allegations of Mr. McCord which pertain to activity not involving me. I don't know about those things. I came here to refute what he said about me.
Well, now, for example, were you aware, for example, that in December, which is the very month you raised the question of CIA involvement with McCord, that Mr. McCord sent Mr. John Caulfield a note complaining of a White House effort to blame the CIA for Watergate and threatening, quote, that all the trees in the forest will fall if this effort continued. Were you aware that note was sent?
I was not.
So that, so it was no fiction, really, that Mr. McCord was deeply concerned over what he believed was a conspiracy to have him implicate the CIA in the Watergate case.
I have no knowledge to contradict that statement by Mr. McCord.
Actually, according to your own statement, when you first raised the CIA involvement with Mr. McCord at the Monocle restaurant, you said he did not really respond to it, but launched into a complaint about how the White House was treating the CIA. I think that was
is correct.
And therefore, Mr. Alch, when you raised the question of CIA involvement with him for the very first time, after the meeting with Mr. Bittman and the other lawyers, it is likely, is it not, taking into consideration the entire circumstances of Mr. McCord's concerns, that Mr. McCord could have concluded that you had joined in the conspiracy he honestly believed existed to blame the CIA in the Watergate case.
In my judgment, that would be giving him the benefit of a doubt to which I don't believe he's entitled, for this reason. I suppose, hypothetically speaking, that it's possible for a man to misinterpret a question put to him as to whether or not the CIA was involved on the one hand, and a suggestion that it was on the other. That's a point of discrepancy which, in answer to a hypothetical question, could possibly be the subject of a misinterpretation. However, on his allegation that I said to him words to the effect that I could cause his personnel records to be doctored and that the director of the CIA would go along with it, it escapes me how that type of allegation can be a misunderstanding. I didn't say it. You can't infer words of that nature unless they were said, and I didn't say it. And most fortunately, there was a third person present at this meeting.
Now, let us move now to the next area of complaint, and that's Mr. McCord's indication or implication of you that you participated in having him exposed to the pressures to accept an offer of executive clemency.
Yes, sir.
Now, it is true, is it not, that you might have also been not aware of pressures from other sources or from Mr. Hunt or of any contacts from the Committee for the Re-election of the President of the White House concerning executive clemency, and therefore might not have been aware of all that might have been going on concerning that subject.
That's true. I may not have been aware of it because I had no knowledge of it, if it in fact happened.
Now, were you, for example, aware that Mr. Hunt may have been in frequent contact with the Committee for the Re-election of the President officials or with White House officials?
I was not. I rarely saw Mr. Hunt, and as you know, when the trial started and his plea of guilty was accepted by Chief Judge Sirica, he was out of it.
It is true, though, is it not, that you did go to the office of Mr. Bittman, Mr. Hunt's lawyer, with Mr. McCord on January 8th, the first day of the trial?
Yes, sir.
And I think you've explained in your statement the reason you went.
Yes, sir.
Now, and that you had a private meeting with Mr. Bittman while Mr. McCord was in another part of the office.
I had a meeting with Mr. Bittman, a discussion with Mr. Bittman. I hesitate to call it a private meeting because, as I explained yesterday, we walked into the office, came into the library of the office where other lawyers were seated. Mr. Bittman was not there. I walked back to his office to see if he was there. He was.
But was anybody else in the office?
No, sir.
All right, so that you were alone with Mr. Bittman?
That is correct.
Now, in your statement, you acknowledge that Mr. McCord was incensed, and I think in your words, paranoid, because he believed that the other defendants were, including Bittman's client Hunt, were trying to make him the fall guy. Now, did you think, or didn't you think, that you were only adding to his concern by meeting with Mr. Bittman alone and not in Mr. McCord's presence?
No, because I had told Mr. McCord why I was going to Mr. Bittman's office instead of immediately going back to my hotel where it was arranged that each day after trial, he, I, and local counsel would meet to discuss what had happened that day and what was going to happen the next day. I told him why I wanted to speak with Mr. Bittman. I wanted to find out the ramifications of the proposed change of plea by Mr. Bittman's client, Mr. Hunt, which I felt could possibly be the predicate for a motion for mistrial, which I eventually filed.
How long did that meeting with Bittman last?
Approximately 15 minutes at the most, maybe less.
And after that meeting, or at the conclusion of it, I understand that your statement that Mr. Bittman told you to tell Mr. McCord that he would receive a telephone call from a friend that night.
That is correct.
Did you ask Mr. Bittman who would call your client, or what the message would be?
I did not.
Why not?
I felt it was of no importance to me. I surmised in my mind that this call was in connection with Mr. McCord's fears that his co-defendants were plotting against him. If I had to guess at who I thought was going to call, I thought it may have come from Mr. Bittman's client, Mr. Hunt. In any event, the remark was made as I was walking out of the office, and I said, okay, went back to the library, and relayed that message to Mr. McCord.
You did relay the message to Mr. McCord that he would get a call that night.
No, not that night. I just said, Mr. Bittman said you'd be getting a call from a friend, and I also told Mr. McCord, I said I went in there and I told him at your request about your feeling that you were being ganged up on, so to speak, by your co-defendants. And Mr. Bittman said, you'll be getting a call from a friend.
Now, this committee has already received evidence, actually just prior to your testimony, that a call, in fact, was made and was received by Mr. McCord, and that it originated from Mr. Dean in the White House to Mr. John Caulfield, to Tony Ulasewicz, and set the stage for a meeting on the George Washington Parkway between Caulfield and McCord, in which Caulfield extended an offer of executive clemency to McCord from the highest levels of the White House.
Yes,
that
sir.
testimony has come before the committee.
Yes, sir.
Did you know of that call or that meeting?
I did not.
Then, therefore, since it was you, Mr. McCord's lawyer, who transmitted to Mr. McCord his first notice of a telephone call he was to receive on the night of January the 8th, and that Mr. McCord knew you were conveying a message from Mr. Bittman, and it was that call which ultimately resulted in a meeting where an offer of executive clemency was made to your client, presented as coming from the highest levels of the White House. Really, was it so unreasonable for Mr. McCord to conclude that you were involved in setting him up for such an offer of executive clemency?
If he made that conclusion, it was factually false. But let's suppose he did make that conclusion. This was in a period of time, as the trial was just about to commence, where I enjoyed with him what I considered to be a very fine relationship. Why wouldn't he have come up to me and asked me about it, or told me something to the effect that, pursuant to your message to me, I got a call last night? That never happened.
Well, at that time, perhaps he had begun to distrust you, Mr. Alch. Perhaps he needed you as counsel for his trial, but after that call, perhaps he had lost confidence in you.
In response to that, Mr. Dash, from what I know of Mr. McCord, it would seem to me rather or highly unlikely that he would go to trial with a lawyer whom he did not trust.
He actually mentioned to you that he had received a call by a man you will recall named Caldwell.
Not the next day.
Not the next day. But,
yes, sir.
And then he refused to discuss that with you any further.
That is correct.
Now, also, Mr. Caulfield, in his testimony before this committee, stated that at one of his meetings...
Mr. Dash, may I add one thing
yes.
to the last question, if I may? When Mr. McCord told me that he had received a call from a man named Caldwell and specifically refused to tell me who he was or what the nature of the conversation was, what I did was to see whether or not there would develop any tampering or modification or interference with my advice to Mr. McCord as his counsel, or whether or not that I was suddenly going to be met with suggestions to change the trial strategy that Mr. McCord and I had already agreed upon. Mr. McCord was free to see whomever he pleased, but at no time did any indications come to me that either Mr. McCord, of his own thinking, or potentially as a result of being talked to by others, was either disregarding my advice, modifying my advice, or introducing a new approach to the trial. That never happened.
In your relationship with Mr. McCord, did you find Mr. McCord a suspicious individual?
I hesitate not to use the word suspicious. There were times when I would communicate with him and ask him for positions or information on particular topics, and he would not give me immediate responses. His attitude would be, or his response would be, well, let me think about it, or words to that effect. And days would pass, and then I would get a definitive response. Whether or not that can properly serve as a predicate for a conclusion of one being suspicious, I hesitate, or I'm not going to say.
In your testimony and on your statement, you've indicated that he really didn't give you all the information that has now come forward. That he did not confide to you concerning everything about the case.
That attitude commenced from my very first meeting with him. But I might say that in my experience as a criminal defense attorney, complete disclosure by a client is not something that happens in every case.
Right. Now, Mr. Caulfield, in his testimony before this committee, stated that at one of the meetings that he had with Mr. Dean during the time he was making offers of executive clemency to Mr. McCord, that Mr. Dean told him, Mr. Caulfield, that Mr. McCord was, quote, not cooperating with his attorney, unquote. Now, could Mr. Dean have referred to or been referring to anyone other than you?
Well, the fact is that I was Mr. McCord's attorney at that time, to my knowledge. And the only reason I add that caveat is this. I was informed that when I read I was not informed, when I read a transcript of, I believe, Mr. Caulfield's testimony, I believe he said that in one of his meetings with Mr. McCord, prior to the completion of trial, that the subject of bail came up, and Mr. Caulfield stated, maybe your lawyer Alch can handle it, or words to that effect, to which, according to Mr. Caulfield, Mr. McCord replied, well, I'm negotiating with another lawyer. Maybe he can handle it. Now, this was before the trial ended. His present lawyer is Mr. Finstewall. I had no contact or even knowledge that such a man existed until after Mr. McCord's incarceration. So I now think and ask myself, was Mr. McCord in any contact with any other attorney during the trial? If that statement about you're not cooperating with your attorney or get close to your attorney was directed towards me, I can't explain it. Because as I've explained to the committee yesterday, Mr. McCord was cooperating with me. Every day.
Well, could it be explained, and again, having already testified, I think twice this morning, that you were not aware of all contacts that might have been made by others concerning your client or other defendants with the White House, that could it be, or would it be likely, that some contacts by other defendants or their counsel were being made with the White House during which your representation of your client could have been discussed?
Mr. Dash, it's possible only because I don't know.
Don't know, and therefore...
I am in no position to refute or confirm.
And you have no other explanation of why Mr. Dean might have made that statement?
I do not. As I told the committee yesterday, I've never met the man, nor spoken to him in my life.
I have no further questions.
Mr. Thompson.
Thank you, sir.
Will the police escort the lady out? Our police will suppress the disorder. I'll remove this gentleman from the audience.
What? That I announce for the presidency of the United States of America.
The chair would announce that this is not a political forum in which candidates are to announce their candidacy.
Mr. Alch, let me ask you a few questions going back through your original testimony concerning the sequence of events as you described them. What evidently was going on in Mr. McCord's mind as he related these things to you, his thoughts about his own defense and those matters. First of all, as I understand your testimony concerning the matters which Mr. McCord considered to be important to his own defense, he raised the matters of the tapping of his lines or the bugging of the lines of the Chilean or the Israeli embassies. Now, how did he explain that to you? How did he indicate that that could or would be a defense for him?
He analogized that to a situation which he said had arose in the Ellsberg case, that if I made a motion for disclosure of such intercepted telephone calls, which he thought were intercepted, that the government, because of embarrassment or national security reasons, would refuse to divulge it and would therefore, in lieu of divulging it, dismiss the charge against him.
According to what he told you, did he consider this a complete defense for him, that this would extricate him from the situation and cause his case to be dismissed?
Yes, sir. He didn't say it was a complete defense. He described it as a means of effectuating the dismissal of the charges against him.
Did he indicate whether or not he placed the calls to those two embassies specifically for that purpose?
He did.
I believe you stated that he also furnished you materials concerning the Mafia and the DNC, Israel and the Mafia, Jack Anderson and government contracts, these matters. Did he indicate in any way that this could possibly be used as a defense for him or could help his defense in any way?
When he gave me that material, he said, let's get on the offensive. Let's make the Democrats, put the Democrats on the defense. He said, let's stir up something. When he told me that and when he sent me the memorandum, I simply took no action on it.
What did he tell you his purpose for wanting to publish his book, Counter-Espionage Agent for the Republicans, I believe you said was the proposed title he had. What was his reason, according to him, for wanting that book to be published before the election? Was it because he wanted the dissemination of the information?
No, sir.
What was his reason, according to what he said?
I have been advised by my associate, Mr. Johnson, who attended the arraignment of Mr. McCord in Washington, that Mr. McCord said to him, wouldn't it be better monetarily for me if this book were published before the presidential election?
As time went on, you indicated that he had suspicion of his co-defendants, that he thought that he was going to be a fall guy, that he wanted to shift the focus of publicity.
Yes, sir.
I believe in December you had your conversation when the business of the CIA was first broached. And in January, I believe you said you heard of a dismissal letter.
That's correct.
That he had filed.
That's correct.
And he gave you were his attorney at that time, is that correct?
I was and technically still am.
You were attorney of record at that time.
Yes, sir.
Did he give you any notice of the fact that he was filing a dismissal letter against you?
None whatsoever.
During the trial, you had a discussion, things were worked out, you went to trial. You say during the trial he praised you.
Constantly.
That you never urged him to plead guilty.
Never did.
All right, now getting down to after the trial. Your first contact, as I understand it, with Mr. Finsterwall was when the bond situation arose. Is that correct?
That is correct.
And he, first of all, indicated that he could take care of the entire $100,000.
That is correct.
And finally came up with $40,000 of the $100,000.
That is correct.
Mrs. McCord taking care of the remaining part of it.
Yes.
Did Mr. Finsterwall indicate to you whether or not this was his own personal money or whether or not he was raising the money from other sources?
He indicated that he was raising the money from other sources which he did not designate.
Do you know to this day where he got that money for that?
No, sir.
For the posting of that bond? And the first time you met him was March 23rd at court?
That was the day, whatever the day was that Chief Judge Sirica read Mr. McCord's letter.
And again, the letter to Judge Sirica, you had no notice concerning that.
None whatsoever.
Correct? All right. And then your conversations with Mr. Finsterwall. You, as I understand it, as he explained it to you, the reason for his releasing this statement concerning you're trying to get him to blame it on the CIA, which, again, you had no notice of, as I understand, the release of the statement until it was about to be, the decision had already been made to release it.
That is correct.
Was that an L.A. Times reporter had been given the story back in December?
Let me explain just exactly how that happened. The day before the memorandum was published, on one of my office secretarial notepads, my secretary advised that a call had come in from a Mr. Jackson of the Los Angeles Times to the effect that a story was about to break, a memorandum alleging or talking about the CIA, Mr. McCord, and me.
That's the first you heard of it?
The very first. I called up Mr. McCord. Could not reach him. The next day, the memorandum appeared in the newspapers. I got a copy of the New York Times, read it, put another call into Mr. McCord. I was told he was at a meeting and that the message for him to return my call would be given to him, and that's when I called up Mr. Finsterwall. When I asked him about this, Mr. Finsterwall said, I had told Mr. McCord to tell you. I'm surprised that he didn't. I asked him to explain the reason for this memorandum, which contained false allegations. Mr. Finsterwall told me something to the effect that Mr. McCord had given this story back in December.
Of course, before the trial.
This was before the trial. He had given this story back in December, and when Mr. McCord heard that the story was about to be published, Mr. Finsterwall said that Mr. McCord wanted to beat the newspapers to the punch and submit his own memorandum in advance of publication.
When Finsterwall told you that he was out to get that they were going after the President of the United States, and repeated that statement, did you ask him if he had any information that McCord did not have that would implicate the President?
I did not. My only response to him on the telephone was, as I stated yesterday, I'm not interested in any personal vendettas. At that point, after I ended the conversation, taking Mr. Finsterwald's statements at face value, he obviously was, to say the least, antagonistic towards the President. It appeared to me, and this is a surmise, that Mr. Finsterwald might be using Mr. McCord as a means for this particular goal or objective which he stated to me. What I proceeded to do, as best I could being on trial in Chicago, was to keep abreast of the newspapers to see the nature of the memoranda and the testimony that Mr. McCord was giving. The first mention, to my recollection, of Mr. McCord referring to the President was when he referred to an alleged executive offer of clemency coming from the President last Friday.
That's the first time in all of your dealings with Mr. McCord throughout the trial and otherwise of his mention of the President?
Yes, sir. And I was in contact with one of Mr. Dash's assistants that night.
Let's see. Do you know how long Mr. McCord has known Mr. Finsterwald?
I do not.
Was there ever any discussion in your presence between the two of them as to when they might have met, any previous contact that they might have had, and so forth?
The only discussion which might be embraced by that question was the one I referred to yesterday in my hotel room the night before our last in-court appearance, where Mr. Finsterwald said that reporters had been asking him if he had any prior relationship with Mr. McCord, and he said I told him I had. Mr. McCord looked up with a surprised look on his face, and Mr. Finsterwald said, sure, don't you remember there were checks that you donated to the committee to investigate the assassination of the President? Words to that effect. And Mr. McCord countered by saying, oh, yeah, that's right. Period.
Do you know what relationship Mr. Finsterwald has to the committee to investigate assassinations?
No, sir.
Didn't it appear strange to you? Didn't it cause you to inquire about this, any previous relationship, or just what exactly Mr. Finsterwald's role was supposed to be? You were the attorney of record. You were supposed to be handling the case. Here's a man coming forth who indicates that he's a stranger to Mr. McCord, but he's willing to try to raise $100,000 for him. He evidently has some association with the committee to investigate assassinations. Didn't you inquire into this situation?
My first inquiry was when the name was mentioned to me, and Mr. McCord told me that he was a friend who could help with bail. Mr. Finsterwald himself later told me that the reason for his motivation or for his actions were to justify what he termed an outrage. He was referring to the $100,000 bail. At the point where this conversation came about, to which I have just referred, the very next morning, it did bother me. Consequently, the very next morning, I called them both together outside the corridor in the courtroom. And I said, look, if you want me to remain as attorney of record, you have got to keep me abreast of everything that you're going to do. I don't want to be embarrassed again. I had been when the letter to Judge Sirica was delivered. That was when Mr. Finsterwald said to me, I will call you every single day, even if I have nothing to tell you. Keeping in mind that prior to this, Mr. McCord had called me and said, you're away on trial, I need someone local, do you have any objection if I retain someone in Washington? I said I had none.
All right. Let me ask you one series of questions in a specifically isolated area. It has to do with your visit to Mr. Bittman's office.
Yes, sir.
I'm not going to second guess your trial technique or whatever. From the record, I think it appears that you did a very fine job with a client who was caught red-handed. But there's some things that just don't seem to fit together with regard to this visit. For example, would you tell the committee, when you came out of Mr. Bittman's office and spoke to Mr. McCord and told him that he would receive a call, what other conversation did you have? What did you say? Where did you go? Did you leave together?
we went back to my hotel room, as we did, perhaps with maybe one or two exceptions, every day after the trial. That was the type of relationship we had. I insisted that each day after court he'd come back with me to discuss what went on. I would have the discovery material for the next day as far as witnesses were concerned. Other matters that may come up, I would discuss this with him. It was that type of thing. At that point, we were talking about jury selection. And I recall the discussion that particular afternoon, after we left Mr. Bittman's office, over my displeasure, respectfully as far as Chief Judge Sirica is concerned, at the proposed manner of jury selection. I didn't think there was enough time being given to newspaper books.
You didn't need your client to sit down with you and Bittman and the other lawyer to discuss this, did you? Couldn't you discuss this with him privately? Couldn't he wait at the motel room or whatever while the lawyers talked? Why didn't you send him on? Why did you have to bring him with you to Bittman's office?
He had no car with him. We had gone to the courthouse in a cab. As the custom turned out to be, we would go back to my hotel room in a cab. I said to him, Jim, I want to go back and talk to Bittman about this matter of his client's change of plea. Come on with me, and as soon as I'm through, I'll tell you about it, and we'll go back to my hotel for further discussions. That's the way it happened.
And Barker just happened to get in the cab? He didn't indicate the reason he was getting into the cab?
That is exactly the way it happened.
What happened to Barker? Did he go to the office with you? Did he leave with you?
He walked into the building in which Mr. Bittman's office is. I did not. Mr. McCord, I, and Mr. Shankman went across the street to get a drink. When I came up to Mr. Bittman's office, I didn't see Mr. Barker. As to why he was going there, as to how long he stayed there, as to whom he saw there, I simply have no knowledge.
Who was Barker's lawyer?
At that time, it was Mr. Henry Rothblatt.
Was Mr. Rothblatt's office in that building?
I'm not sure. I know Mr. Rothblatt had an office very close to Mr. Bittman's office. I know that because when it was decided, since there were out-of-town lawyers involved, where we would meet whenever we would meet, Mr. Rothblatt agreed to meet in Mr. Bittman's office because he said that he had an office either in the same building or very close to it. It may have been in the same building. I don't know.
If you were going in to discuss this situation which concerns you with regard to Judge Sirica's ruling with Bittman, which is essentially a conversation or a problem which addresses itself to lawyers, why didn't you take Mr. Shankman, your associate, in to talk with him?
No particular reason. Mr. Shankman was privy to all of my trial strategy. What happened was we walked into the library, put our briefcases down. Other lawyers were there. I just got up and said, I want to go back and see if Bill is in his office. And I did.
Found him there, and you left your co-counsel in the library with Mr. McCord.
That's right.
Did he ever see Bittman, as far as you know, that day?
Did whom? Mr.
Shankman.
Mr. Shankman?
Yes.
I believe he may have said hello and goodbye to him. It was not a long stay at Mr. Bittman's office.
There was no particular reason why you wanted to talk to Bittman alone, out of the presence of anyone else?
Absolutely not.
As
a matter of fact, I told Mr. McCord what the discussion was with Mr. Bittman, so there was no...
When Bittman said that he would receive a call from a friend, didn't you ask who that friend was?
I did not.
Doesn't it concern you as a criminal defense lawyer when anybody is making contact with your client, whether it's another lawyer, whether it's a third party, whether it's another defendant? Isn't that something that concerns a defense lawyer during the trial of a case?
Mr. Thompson, as I say, in the context of that remark, my assumption was that it could very well have been a call from Mr. Hunt, or perhaps some of the other co-defendants.
Well,
I don't know.
Would that not concern you? Co-defendants sometimes have different interests, don't they?
At that point in the trial, I was not aware of any conflict.
But there's always a possibility, isn't there?
Well, when you're beginning a trial and your client and you are in complete agreement on a presentation of a defense, that was my main concern.
And then, coincidentally, he did receive a call.
So I am informed.
So other testimony has...
So other testimony is told me.
Do you know how we can make this jump from Bittman's statement to you about the call of a friend to the fact that he evidently, according to other testimony, did receive a call shortly after that? Do you know whether or not Bittman called Dean, or what's the answer to it, if you made any inquiry
No,
as to that?
and I can't answer the question because I have no knowledge of it.
Thank you. No further question.
I believe so, Edward Koch.
So the senators are still trying to sort out the conflicting testimony offered by James McCord from that given by the attorney Gerald Alch. Alch maintained he wasn't aware of any political pressures on his client. The senators will each take a crack at separating the different versions of the conversations. As we take a short break now, let you go and make a cup of coffee, we'd like to thank the 25,000 of you who've written us already expressing your opinions about this kind of gavel-to-gavel coverage. If you still would like to write us, and we'd welcome that, you can do so at NPACT, P.O. Box 300, Washington, D.C. 20044. We'd like to know if you think this is the kind of coverage that public television should be doing on occasions like this. NPACT's coverage of the hearings will continue after we pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
As the hearings continue, Attorney Gerald Alch is being questioned by Committee Chairman Sam Ervin.
I believe so, Edward Koch. Keep time on me, 10 minutes only, strictly. All sentences 10 minutes. I believe so, Edward Koch said that one scratch of a pen is better than the slippery memory of a multitude of witnesses. Hasn't that been proven true in your practice as trial lawyer?
I'm not sure I understand the significance of the remark.
Well, isn't there a hazard where two men communicate with each other by word of mouth? Isn't there a twofold hazard in that communication? And first, that the man who speaks may not express himself clearly and may not say exactly what's in his mind. And if he does, the man that hears it may put a different interpretation on the words than the man who spoke them.
Yes, sir.
Yeah. Now, and that's very well illustrated by something that came out here this week. Mr. McCord testified that Mr. Caulfield told him that the president was interested in this order of executive clemency. And Mr. Mr. Caulfield said he never mentioned the president's name. He merely said the highest levels of the White House. So Mr. Caulfield meant one thing, and Mr. McCord understood another, the words.
Yes, sir.
And I believe you made a little mistake yourself in your statement. You talked about, said that you understood Mr. McCord to say Caldwell when he was obviously talking about Caulfield, which is quite a natural mistake.
Yes, sir. Yeah. That's my recollection.
Now, I think you're a little irritated with the client, and I don't blame you. I got irritated with my clients when they didn't take my advice and when they went around talking to other people.
Senator,
me.
Senator, if I may, you as a lawyer can well appreciate the fact that you do your best for your client. If he's pleased, that's the ultimate goal. You can't guarantee whether he's going to get convicted or acquitted. What upset me is how the man turned on me with what I have alleged and believe with all my heart to be false accusations in the manner and the framework of which he did. Of course I'm upset.
Well, the thing you offended, as you stated to Mr. Dash, you were offended by his apparent charge that you had suggested to him that they lay this on the CIA. Now, let's see if there wasn't a little justification for him maybe making a mistake on that. You testified that you attended a meeting of all of the lawyers involved in the case. Yes. As I understand it, Mr. Bittman was appearing for Mr. Hunt. Mr. Henry Rothblatt was appearing for Sturgis and Martinez and Gonzalez and Barker. And you were appearing for McCord. And who was appearing for Liddy?
Mr. Peter Maroulis.
Yes. Now, there was a meeting of most of these lawyers, and it had been pointed out in the press that Mr. Sturgis had apparently CIA credentials issued in the name of Mr. Martin, I believe.
Yes, sir.
It was also apparent that came out in the press that other members of those of the group that broke into the Watergate had false credentials.
That is correct, sir.
And the press had suggested, since McCord had been involved in the CIA, and Hunt had worked for the CIA, and Barker had been in the Bay of Pigs operation, CIA, and possibly others, that perhaps there was a CIA involvement. Wasn't that speculated in the press?
In the press, yes, sir.
And at this meeting, of course, the first thing a lawyer tries to find out from his client is what kind of a defense, if any, he's got. Isn't that true?
Of course.
And so the lawyers were discussing at that time what possible defense they had. And it was suggested by one of the other counsel that perhaps they could get evidence that would sustain a defense that would lay this break-in on the CIA, wasn't it? At the meeting of the lawyers.
But, Senator, I don't mean to split hairs, but I do wish again to point out that it did not come out in the sense that let's make this a CIA defense. It didn't come out that way. It wasn't presented that way. The way it was presented was, could this be a CIA defense because of all of these things? Let's go back and ask our clients. Well, that's the way it happened.
Well, the only way that lawyers can find out whether their clients have a defense is to discuss matters like this and try to investigate them.
Of course.
And it was suggested in this meeting of lawyers by some attorney other than yourself.
Yes, sir.
That all the lawyers involved should try to ascertain from their clients whether the CIA was involved, whether they had any knowledge that would implicate the CIA, wasn't it?
That is correct.
And so immediately after that, you went and talked to Mr. McCord about it, didn't you?
Yes, sir.
Asked him.
Yes, sir.
Now, don't you think that it's possible that a man who had read in the newspapers about the alleged involvement of the CIA or suggestion of involvement of the CIA, who's asked by his attorney about the matter, might think that his attorney was indicating to him that that was a possible defense?
No, for this reason. If it was that type of potential if it was that type of potential misunderstanding, assuming arguendo, that may be so. But in Mr. McCord's statement, he brought this out under the general heading of pressure, my bringing pressure upon him, which to me negated or diminished the chances of it being a misunderstanding. To me, it implied more, it sounded more of intentional misrepresentation.
Well, the word pressures used by different people. There's all kinds of pressures, aren't there? There are heavy pressures and light pressures.
True.
Now, it's in evidence here that Mr. McCord in December, previous to the time of the trial, had become so much concerned about the possibility of the involvement of CIA that he had written a letter to Mr. Caulfield saying that it would be, in effect, it would be a mistake to involve the CIA, that if he did that, all the trees in the forest would fall and it'd be a scorched earth. Now, don't you know that Mr. McCord showed extreme loyalty to the CIA?
Don't I know it now?
Yes.
I know that's what he says, yes.
And can you not, didn't you tell Mr. McCord when you met with these other lawyers that y'all were discussing the possible defenses?
I did.
Now, in all fairness to Mr. McCord, don't you think it's possible Mr. McCord thought that you thought he ought to see if he could involve the CIA? Just in fairness to him.
I'll answer it as fairly as I can in this manner, Senator. I do not enjoy coming down, asking to appear before this honorable committee, for which I'm most grateful, and in effect calling a man a liar. My nature is such that I don't enjoy doing it. What you are suggesting is that there may have been, if I may take the liberty of interpreting your remark, that there may have been a misunderstanding on Mr. McCord's part about that particular aspect of it. With the exception of my objecting to him categorizing that as pressure, that may be. I am not looking to bury Mr. McCord. My presence here is a reaction, not an action. But I keep going back to this. You can't interpret a lawyer saying, I'm going to forge CIA documents with the assistance of the CIA director out of my saying, what do you want for lunch, or see you in Boston, or we're discussing a CIA defense. Either those words were said or they were not. Now, when I watched television last night, Senator, I heard and saw Mr. McCord again reiterate that I said those words. I have already advised the committee that at this meeting there was another lawyer present. I invite you to contact him. However, I also saw Mr. Finsterwald deny that he said to me on the telephone, we're out to get the president.
Well, now, wait a minute on that. Did Mr. McCord ever mention the president to you at any time in any conversation he ever had with you?
No, sir.
Yeah.
No, sir.
And Mr. McCord was not present, so far as you know, and didn't overhear any phone conversation between you and Mr. Finsterwald on that point?
Not to my knowledge, but
yeah.
my reference...
And so far as it appears down to this day, there's no evidence here that Mr. McCord ever mentioned the President of the United States, except that he said that Mr. Caulfield mentioned the President of the United States in conversations with him. So let's...
that is correct, except that when the remark was made to me by Mr. Finsterwald, well, he was Mr. McCord's counsel, and he said we. He used the word we.
Now, I don't recall, I don't have the minds of human beings are very fallible, I have found from a long practice of law and also in legislative bodies. And I've heard about a lot about this, read a lot, trying to prepare it. And I've got much information, misinformation about this matter. And I don't know the precise source of all of these things. Now, Mr. McCord said that someone, I believe, said you suggested, that if they changed the records at the CIA to show he'd been called back to duty, there might be a chance to have a defense act signed. You say you never said that.
Mr. McCord said...
But it is possible...
Mr. McCord said much stronger words than that. He said I told him that I could effectuate the forgery of his CIA records with the cooperation of the CIA director. That's
Well,
pretty
now, he
strong
was-
talk.
I don't believe that's the testimony Mr. McCord gave this.
The record, of course, will
But
bear
the
it
record
out.
will speak for it. Now, my recollection, I don't guarantee, but my recollection, he said that you, or somebody, said that by letting the records of the CIA show. No, wait a minute now. Here, this is McCord. Here's McCord's statement. He said that if so, that is you, my personnel records CIA could be doctored to reflect such a recall. He stated that Schlesinger, the new director of CIA, whose appointment had just been announced, could be subpoenaed and would go along with it.
Yes, sir.
He didn't accuse you of anything except saying that the records that you advocated that, you were just expressing the surmise.
Well, Senator, perhaps through a lawyer's and an experienced lawyer's eyes, looking at it really close, dissecting it, that conclusion might be proper, but not to the average person that reads it on the street.
Now, let's see. You also, if I infer from your statement, you also took offense at the fact that Mr. McCord had stated that you had recommended he enter a plea of guilty. Am I correct in that?
No, sir. I specifically pointed out that in response to your question, he said I did not.
Well, let's talk about this plea of guilty, though, a minute. You stated in your statement that you learned from Bittman that Hunt was contemplating pleading guilty.
Yes, sir.
And you also learned that a short time later, that Henry Ross of Blatt's clients were contemplating pleading guilty.
Yes, sir.
And you discussed with McCord the fact that this would be a very bad thing to happen to his defense.
No, sir. I told him that I was of the opinion that it would prejudice him because of the reaction to the jury.
Yes. Well, that would be prejudicial to his case, wouldn't it?
His case, but not his defense.
Yeah. Now, as a matter of fact, the assistant district attorney in charge of the case 3 times approached you with a view to negotiating a plea of guilty on the part of McCord.
2 times to my recollection.
Yes. And I wouldn't criticize you a bit if you recommended he plead guilty, because you had a client that was caught red-handed in the act of burglary, and the defense was on very precarious grounds at the best. And so if he did say that you urged him to plead guilty, I think it would be a compliment to your intelligence as a lawyer rather than a reflection on it.
In all due respect, I reject the compliment. For this reason, Senator. First of all, he specifically said to you, I never suggested that he enter a plea of guilty. The reason that when this proposition was put to me, or this offer was put to me by the government, I practice this way. That's too important a decision for me to make. I simply take it back to the client and say, here it is.
Yeah.
What do you say? He said no.
Well, you never recommend to a client?
When I get an offer?
I'll have to confess that I have recommended to many clients that they plead guilty, and I felt like I served in their cause the best.
I'm not saying anything of that is improper. All I'm saying in this particular instance, Senator, I just brought it back to him and said, here's what's available to you.
Maybe we are discussing things that have no thing. You don't take any offense. You don't claim that he said that he urged you to plead. I get it back. Let's get started again. You're not taking any offense at any possibility that McCord may have said that you recommended to him that he should plead guilty.
No, because he said just the opposite.
Yeah. Well, good. So we'll have no controversy. So you're not falling out with him on that, right?
Not on that point.
Now, let's go to executive clemency. You did attend a meeting with Mr. Bittman.
Yes, sir.
Now, Mr. Bittman was representing Hunt.
Yes, sir.
You knew that Hunt had been a consultant in the White House. or the executive office?
I honestly was not sure of just what Mr. Hunt's position was.
Well, you knew he'd been working for the committee to re-elect the president.
That I know.
And you don't know what contacts that were had between Mr. Hunt and any of his former associates in the committee to re-elect the president, or between his counsel, Mr. Bittman, and those people.
No, sir.
But you did have a discussion with Mr. Bittman in which Mr. Bittman mentioned about executive privilege, didn't you?
Yes, sir. In the context
in other words,
yesterday.
When Mr. Bittman was discussing with you the fact that his client, Mr. Hunt, might plead guilty, or
Yes,
had
sir.
determined to plead guilty, I don't know which, but anyway, discussing it.
Yes, sir.
You asked him something not about executive privilege, but something about what kind of sentences they might look forward to.
No, sir. I tried to make that very clear yesterday, that my discussion with Mr. Bittman, where the words executive clemency came up, did not happen on January 8th. It happened sometime in late 1972. And it happened when I said to him, just in a casual conversation, what do you think our clients are liable to receive for a sentence if they're convicted? Just like that. And that's when he said to me, in a not a very authoritative tone, I might add, you never can tell, Christmas time rolls around, executive clemency might come into the picture. I said, forget it, the president won't go near it.
Well, you know, you participated in the trial and heard the evidence.
Yes, sir.
And you know that it was proved on the trial, or shown on the trial, or at least the evidence tended to show, that the notebook of Mr. Hunt, which was introduced in the evidence, had the White House phone number in it, don't you?
If it was, I simply don't recall.
You don't recall?
Because Mr. Hunt was, I see. I don't recall.
Well, anyway, when you asked Mr. Bittman what kind of sentences you thought your clients might get if they were convicted, he said, well, it might be executive clemency, didn't he?
He didn't say it that way.
Well, he said Christmas was coming.
That's right.
Yeah. And he at least indicated he thought that the hearts of executives became kinder around Christmas time than any other season of the year, didn't he?
Senator, let me say this. He did not respond in this type of way. He did not say, now look, Christmas is coming, they're going to get executive clemency. It wasn't that type of a conversation. What he said to me was, in a sort of a theorizing way, well, Christmas time comes around, who knows, there may be executive clemency. I immediately responded, as I told you yesterday, that there's no chance of that happening, in my opinion.
Now, you said I had, on page 16 of your statement, you said I had occasion in late 1972, during one of the pretrial meetings of defense lawyers in Washington, I had occasion to say to Mr. Bittman, Bill, what do you think our clients will receive as a sentence should they be convicted? Mr. Bittman responded in substance as if theorizing. You can never tell. Christmas time rolls around and there could be executive clemency.
Yes, sir. Those are his words to the best of my
So
recollection.
I did have sort of right have an idea Christmas did have some relation to Mr. Bittman's remarks.
In the context of the way he uttered it.
Now, you left that meeting, and then you saw Mr. McCord. Well, later you discussed the question of executive privilege with Mr. McCord, didn't you?
I didn't discuss the question. I relayed to him the conversation I had with Mr. Bittman.
And you relayed the conversation in which Bittman had said, in effect, that you can never tell Christmas time rolls around and there could be executive privilege. Clemency, rather.
I did with a singular addition of my own.
Yeah. And you said that it was absurd to expect executive clemency. The president wouldn't touch it with a 10-foot pole or something like that.
That's what I said.
Yeah. And McCord agreed with you.
He did.
Now, you, on one occasion, you told Mr. McCord that Mr. Bittman told you in one of these meetings of the lawyers that Mr. McCord was going to receive a message, a telephone call.
Yes, sir.
And didn't you ask Mr. Bittman what business other people had? You'd been talking about the case, hadn't you?
At that particular point, we had been talking about my client's apprehension that his co-defendants were conspiring against him.
Well, anyway, he told you your client was going, somebody else was going to communicate by telephone with your client.
Yes, sir.
And it was a short time after that, according to the evidence, your client did receive the telephone calls and had three conferences with Mr. Caulfield.
Not to my knowledge.
Well, the evidence shows it. I know you don't know it.
Yeah.
Yeah. But you conveyed the message which Mr. Bittman gave you about Mr. McCord going to receive a telephone call to Mr. McCord, didn't you?
I try to tell my client everything.
Yeah. So, well, don't you think it's reasonable now he got a call, and you told him in advance he's going to get the call, and then he received a call and had some negotiations or conversations at least about executive privilege. Do you think Mr. McCord is liable because in his mind he associated those conversations he had as pursuant to this telephone call with you? Can't you see why he would reasonably draw the deduction that the telephone call which resulted in this indicated that you knew something about executive clemency?
No, for this reason. I again reiterate how close we were in our contact and what we would tell each other. If he thought, and he has now labeled this as improper conduct on my part, the question I keep asking myself is that if he did make the surmise and conclude that I was engaged in improper conduct, this was before the trial began, or was it before the trial began, or whenever it happened, why wouldn't the man come up to me and confront me with it? That's what I don't understand.
Well, you go and tell him that he's going to receive a phone call.
Yes, sir.
And he does receive the phone call.
Yes, sir.
And as a result of receiving the phone call, he has an offer of executive clemency made to him.
Yes, sir.
And you say that it wasn't reasonable for him to infer from those facts that you knew about the offer of executive clemency?
I say it was not reasonable for him to infer or assume and later allege that that was in any way the basis of improper conduct on my part.
Well, I don't infer it was, Mr. Alch.
What, sir?
I was always interested. When I had a client, especially one that had no defense, I was always glad of any prospect of getting any kind of clemency. And I don't see it reflects on you. It would be to your glory if you'd known about it to have tried to pursue it further. It's no reflection on you. It's to your credit.
No, sir. I didn't know about it. If any type of legitimate legal offer came from the government that would benefit my client, I would put it to him. I certainly wouldn't keep it from him.
Just one more question about the book.
Yes, sir.
You know, it's got to be, the scriptures say that much study is weariness to the flesh, and the making many books there is no end. It seems everybody gets in jail nowadays wants to write a book about it. Mr. McCord, at the time he talked to Mr. Johnson about writing a book, was out of a job, wasn't he?
Not to my knowledge.
You don't know that your client was out of a job?
No, sir. He had his whether it was surveillance, McCord Associates.
Yeah. But don't you know he'd been fired by the committee to re-elect the president?
Yes, sir, but he told me he also had income from McCord Associates.
Yeah.
I would call him sometimes at the office.
Well, notwithstanding the fact that he was paying your fee rather slowly, you didn't think he might be in financial impecunious circumstances?
That was possible?
Yeah. Well, I'd say this. If somebody would write a book unraveling the mystery of the Watergate, it'd make A. Conan Doyle turn green with envy. Senator Baker, excuse me. Go ahead.
Mr. Chairman, thank you very much. Mr. Doyle is off to a good start because in his next Sherlock Holmes, Mr. Watson has already been identified. I thank the chairman for the opportunity to proceed now to inquire of this witness about matters that concern me very greatly. The chairman has alluded a number of times to his distinguished career in North Carolina as a trial attorney and as a judge. I must say, Mr. Alch, that you are now in the position of having been interrogated by one of the best. I'm not sure which interrogation it was, that of a lawyer or a judge, but you know that you've been interrogated.
I deem it an honor.
Now, not to try to emulate the sterling example of the chairman, but I also recall that when I tried cases in Tennessee, that when the proof was concluded and the judge charged the jury, he said something to this effect. He said, "Ladies and gentlemen of the jury, you will now take the evidence as adduced in the hearing room from all of the witnesses. If you find the testimony of witnesses in conflict, you will reconcile it if you can. If you cannot, then you will look to the testimony of other witnesses, to circumstantial evidence if available, to documentary evidence or demonstrative evidence if appropriate, and then you will weigh and balance that evidence and make your judgment as to where the truth actually lies." Now, while that is a charge used in essence by the courts in my native state of Tennessee, I think it fairly summarizes the dilemma that we're faced with here as committee members. We're not judges, and we're not a jury, but we most assuredly are after the facts, the truth. And it's now apparent that we're going to have to try to reconcile differences in testimony if we can. And if we cannot, look to the testimony of other people, to demonstrative evidence, to circumstantial evidence, to try to find where the truth lies.
Yes, sir.
Now, in the time I have before me, still remaining to me, Mr. Alch, I want to suggest two or three things that appear to be in conflict. And I want you to suggest to us how we might go about reconciling those apparent discrepancies, or how we might go about shedding additional light on the subject matter. Begin with the allegation, as I understand it, of Mr. McCord, as stated on page 2 of his testimony, as follows. There followed a suggestion from Mr. Alch that I use as my defense during the trial the story that the Watergate operation was a CIA operation. This is Mr. McCord speaking.
Yes, sir.
I heard him out on the suggestion, which included questions as to whether I could ostensibly have been recalled from retirement from CIA to participate in the operation. He said that if so, my personnel records at CIA could be doctored to reflect such a recall. He stated that Schlesinger, the new director of CIA, whose appointment had just been announced, could be subpoenaed and would go along with it.
Yes, sir.
You have previously testified that you did not say that to Mr. McCord. Is that correct?
That is correct.
Did anyone say that to Mr. McCord in your presence?
No, sir.
Do you have any knowledge of anyone saying that to Mr. McCord?
No, sir.
Then there is a conflict between your testimony and that of Mr. McCord. Do you have any suggestions as to how this committee can reconcile that apparently irreconcilable difference in proof and give us some indication of where the truth lies?
2.
Tell us.
1. Speak to the third party that was there.
Who was there?
Mr. Bernard Shankman.
Is he under subpoena, Mr. Counsel?
No, we've been interviewing Mr. Shank.
Would you make a notation that I'd like to speak to Mr. Shankman? Would you go ahead, sir?
If that should prove inconclusive, with regard to this discrepancy and with regard to the discrepancy that Mr. Finsterwald denies that he told me that he was not going after the president.
No, we'll get to that in a minute.
Very well.
Confine yourself, if you will, to the allegation made by Mr. McCord contained on page 2 of his written statement with respect to a defense of a recall to the CIA and the doctrine of his records to reflect that. Is there anything else except Mr. Shankman's possible testimony that you can suggest to us that might shed some light on that apparent conflict in the testimony between you and Mr. McCord?
Yes, sir. I suggest that both Mr. McCord and I, if he's willing, submit to a polygraph test conducted by a
example of the chairman, but I also recall that when I tried cases in Tennessee, that when the proof was concluded and the judge charged the jury, he said something to this effect. He said, "Ladies and gentlemen of the jury, you will now take the evidence as adduced in the hearing room from all of the witnesses. If you find the testimony of witnesses in conflict, you will reconcile it if you can. If you cannot, then you will look to the testimony of other witnesses, to circumstantial evidence if available, to documentary evidence or demonstrative evidence if appropriate, and then you will weigh and balance that evidence and make your judgment as to where the truth actually lies." Now, while that is a charge used in essence by the courts in my native state of Tennessee, I think it fairly summarizes the dilemma that we're faced with here as committee members. We're not judges, and we're not a jury, but we most assuredly are after the facts, the truth. And it's now apparent that we're going to have to try to reconcile differences in testimony if we can. And if we cannot, look to the testimony of other people, to demonstrative evidence, to circumstantial evidence, to try to find where the truth lies.
Yes, sir.
Now, in the time I have before me, still remaining to me, Mr. Alch, I want to suggest 2 or 3 things that appear to be in conflict. And I want you to suggest to us how we might go about reconciling those apparent discrepancies, or how we might go about shedding additional light on the subject matter. Begin with the allegation, as I understand it, of Mr. McCord, as stated on page 2 of his testimony, as follows. There followed a suggestion from Mr. Alch that I use as my defense during the trial the story that the Watergate operation was a CIA operation. This is Mr. McCord speaking.
Yes, sir.
I heard him out on the suggestion, which included questions as to whether I could ostensibly have been recalled from retirement from CIA to participate in the operation. He said that if so, my personnel records at CIA could be doctored to reflect such a recall. He stated that Schlesinger, the new director of CIA, whose appointment had just been announced, could be subpoenaed and would go along with it.
Yes, sir.
You have previously testified that you did not say that to Mr. McCord. Is that correct?
That is correct.
Did anyone say that to Mr. McCord in your presence?
No, sir.
Do you have any knowledge of anyone saying that to Mr. McCord?
No, sir.
Then there is a conflict between your testimony and that of Mr. McCord. Do you have any suggestions as to how this committee can reconcile that apparently irreconcilable difference in proof and give us some indication of where the truth lies?
2.
Tell us.
1. Speak to the third party that was there.
Who was there?
Mr. Bernard Shankman.
Is he under subpoena, Mr. Counsel?
No, we've been interviewing Mr. Shankman.
Would you make a notation that I'd like to speak to Mr. Shankman? Would you go ahead, sir?
If that should prove inconclusive, with regard to this discrepancy and with regard to the discrepancy that Mr. Finsterwald denies that he told me that he was not going after the president.
No, we'll get to that in a minute.
Very well.
Confine yourself, if you will, to the allegation made by Mr. McCord contained on page 2 of his written statement with respect to a defense of a recall to the CIA and the doctrine of his records to reflect that. Is there anything else except Mr. Shankman's possible testimony that you can suggest to us that might shed some light on that apparent conflict in the testimony between you and Mr. McCord?
Yes, sir. I suggest that both Mr. McCord and I, if he's willing, submit to a polygraph test conducted by a competent examiner accredited by the American Polygraph Association. I state my willingness so to do.
Do you have any other suggestion?
No, not at this time.
It is further suggested by Mr. McCord that on a number of occasions, intense pressure was brought to bear on him to involve the CIA. I do not have that page reference before me, but I hope that's a fair summation of the thrust and burden of Mr. McCord's testimony. You have denied the suggestion that you consider fabricating a defense of recall to the CIA. Can you shed any further light on whether there were other or different occasions on when you suggested that we pack it off on the CIA?
I never did.
Did you ever bring intense or any pressure to bear on Mr. McCord on this or any other subject?
I did not.
Do you have any suggestion on how this committee might reconcile that apparent conflict, how we might find the testimony of other witnesses, circumstantial evidence or demonstrative evidence, or other information that might try to tell us where the truth lies?
As to pressure that I put upon him?
Now, tell us if you know of any other information save and except the testimony given to this committee by Mr. McCord and by you that might shed some information on who's telling the truth, you or Mr. McCord.
As to what particular point?
As to the point that intense pressure was brought to bear on him repeatedly to try to make it a CIA operation.
To my knowledge, the activity of my activity to which he points was that meeting at the Monaco restaurant. You can correct me if I'm wrong, but in my reading of Mr. McCord's testimony, that is the only instance in which he says that I pressured him with regard to CIA activity. I've already given you my two suggestions as to how to find out who's telling the truth. To my knowledge, he has not cited any other examples of my allegedly pressuring him to adopt a CIA defense falsely.
Moving then to another subject, it would appear to me that a material conflict between your testimony and the statements of Mr. Finsterwall given publicly after our hearings on yesterday may produce for this committee a similar dilemma if, in fact, Mr. Finsterwall makes a statement or testifies. And that relates to your allegation that Mr. Finsterwall said we're out to get the president.
Yes, sir.
I understand that this question is premature, therefore I saved it to last. But in anticipation of the fact that Mr. Finsterwall may deny that, and I rather suspect that he may.
I believe he already has.
I believe he has not here, but I believe he has publicly outside this hearing room.
Yes, sir.
Would you now tell us what method you could suggest to bring the testimony of other witnesses to bear, or other circumstantial evidence, or any evidence to try to find who is telling the truth in that respect?
Polygraph.
Can you suggest anything else?
It was a head-on conversation. To my knowledge, I know nobody was listening in on my end. To my knowledge, nobody was listening in on his end. I don't know.
Did you tell the committee that you turned immediately and spoke something to an associate?
Yes, Mr. John McNally.
How soon did you do that? Was it immediately after the conversation?
Yes, sir.
You're familiar with the term res gesta?
Yes, sir.
As an exception to the hearsay evidence rule.
Yes, sir.
We aren't trying a lawsuit, and I don't mean you to self-serve your own purposes, but does it fall within the scope of that?
Could very well.
Mr. Alch, there are other implied conflicts, but I won't go further with them at this point. We can't try the lawsuit with one witness, and certainly not the testimony of a lawyer. I've never in my life been in a proceeding where two lawyers were potentially at least in a swearing contest, but that looks like that's where we're headed. Now, I want to move on to a more general subject matter in the time I have remaining to me. The chairman suggested that it might be a glory to your competence as a lawyer and your good judgment as counsel had you advised Mr. McCord to plead guilty, that after all he was caught, as the chairman put it, I believe, red-handed in the Watergate. He was indicted on what, 7 counts or 8?
7, I believe.
Did you ever consider advising him to plead guilty?
I did not, for this reason. He told me from the beginning he did not want to. He told me he wanted to go to trial and told me the defense he wanted to use based upon what he claimed to be the true motivation of his actions.
What did he tell you to be the true motivation of his actions?
His attempt to obtain advance warning of planned violent demonstrations by radical anti-war groups, as he put it, which would, in his opinion, lead to violence to prominent Republican officials.
And he said that in relation to the entry into the Democratic National Committee?
He did.
Not into the headquarters of the Weathermen or any other group, but to the DNC, the Democratic National Committee.
That's what he told me was his reason for doing what he did.
Did you advise him that that was or was not an available defense?
I told him I would look into it. I did. He was talking and submitted memoranda to me under the topic of defense of others. My research told me, or showed me, that this particular defense did not permit the one claiming it to know that he was breaking the law. I told him so.
Well, did you then tell him that the defense was not available?
That particular one, but I also told him that there was a similar, related defense, which particularly allowed the perpetrator to know he was breaking the law. That was a defense of duress. That defense was presented in his behalf. When Chief Judge Sirica ruled as a matter of law that it was not applicable to the facts, I made my offer of proof.
Did the U.S. Attorney's Office, did the Justice Department, or anyone else contact you to try to induce or even to discuss the matter of your client pleading guilty?
Yes, sir.
When?
As reflected in my statement, there were 2 times. The dates appear in my statement.
One, to plead guilty on one charge of the indictment.
And become a government witness.
And the second time to plead guilty to 3 or 4 counts of the indictment.
And become a government witness.
Were there any other offers?
From the government? No, sir.
Were there any suggestions of executive clemency?
No, sir. The only other, and I don't want to characterize it as an offer. It was not an offer, but as a result of a meeting in chambers with Chief Judge Sirica during the trial, I came out and advised my client that it was not too late to go before the grand jury.
Mr. Alch, you've previously stated that the way you practice law, the decision on whether to plead innocent or guilty is too important for you to decide. It must be left to your client, and I admire your rectitude in that respect, but I doubt your judgment. And I really wonder, and I put this to you in a very blunt and a very, very cruel way, I really wonder if there isn't a balancing judgment to be made in the minds of the expert retained by counsel to advise him on the trial of his rights. On the one hand, the likelihood of prosecution and conviction, and on the other hand, the advantages of pleading guilty on 1 or 4 counts of the indictment.
Senator, I was not moot on that point at all. In my discussions with Mr. McCord, as we were talking about the defense which we ultimately used, I pointed out to him that, number one, it was the only possible legally recognizable defense I could think of, and also told him that, in my opinion, the chances of success were less than 50-50.
All right. At that point, what was Mr. McCord's reply?
I want to go to trial on that defense.
On that defense?
On that defense.
When did he then bring up the matter of his contrived conversations with embassies where he suspected or knew of wiretaps? Was it before or after your conversations with him about the possibility of pleading guilty either to 1 or 4 counts of the multiple count indictment?
I'm not sure.
All right, skip that.
Tell
me what your reaction was when Mr. McCord told you of the 2 embassy phone calls.
I asked him what the phone calls were about. He told me they were phone calls relative to the case, no more.
Did he tell you that he suspected they were tapped?
He did.
Did you ask him how he knew that?
I did.
What did he say?
I know they are.
I know they are.
I know they are.
Did you ask him anything else?
I asked him, well, how do you know? He said there was a similar situation in the Ellsberg case.
Well, when was the Ellsberg case tried and dismissed? That was a long time after this.
No, he gave me a memorandum. I think it's one of the papers I submitted to the committee in which he cited the Ellsberg case.
When was that? Do you have, Mr. Counsel,
I have got the copy with me, but it's one of the documents I submitted.
Okay, but now you are a lawyer. You're a member of the Bar of the District of Columbia?
No, sir.
Of the state of Massachusetts?
Yes, sir.
You understand your obligations as an officer of the court?
Of course.
Did you have the impression that your client was trying to manufacture and contrive a method by which the government would be required to dismiss this case notwithstanding his guilt or innocence?
No, sir. I did not take this to be a frivolous attempt or action on his part. When he told me that these calls were relative to the case, at my client's instruction, I presented the motion.
Had he not told you the calls were relevant to the case, what would you have done? Would you then have had an ethical dilemma as an attorney?
Yes, sir. If I had thought in my own mind that, number one, the calls were not made, or that, number two, they were made for frivolous purposes and of no consequence nor relation to the case, I certainly would have.
I have here a letter styled Dear Gerald, dated August 23rd of what year?
It would have to be 72.
I'm going to read it for the record, Mr. Chairman. It won't take a few minutes. Dear Gerald, and the letter is signed Jim in hand. This case of Russo and Ellsberg versus Byrne was filed about an hour before I picked it up at the Supreme Court today. It appeared directly on target for us, so made a copy. Petitioners are making a pitch, of course, for government dismissal of the case rather than disclose the Chilean embassy foreign wiretap in which Bodine's conversations were recorded. Petitioners' reasons for granting the writ are directly relevant to our situation, that they are arguing that, one, on constitutional grounds, the determination of the relevance of wiretap conversations be made in adversary proceedings rather than in camera. Two, the refusal of the lower court to compel discovery and to conduct an adversary hearing is in conflict with the provisions of the two wiretapping statutes, the Omnibus Crime Control and Safe Streets Act of '68 and the original Crime Control Act of 1970. Three, wiretaps for foreign intelligence purposes and their constitutionality without a court order are at issue, and their legality needs to be determined by the Supreme Court in its October session in order to set this case to rest one way or the other. Though Justice Douglas is in the minority, his comments set forth in the appendix are a pretty fair summary of the thinking of the court as expressed in two recent decisions on the wiretapping issue. Skipping over some parts of it, in any case, I would bet my last dollar that the Supreme Court will rule that a determination of the relevance of wiretap conversations to be made in adversary proceedings rather than in camera, and the identity of the person or organization on whose phone was tapped was made to be made known to the defense counsel. The refusal of the lower court in the Ellsberg case to compel discovery and to conduct an adversary hearing is in conflict with the two wiretapping statutes cited above, and so forth. In my own case, there are three possibilities relevant to the above. One, in the spring of this year, telephone calls were made by my office phone from a young Chilean employee of mine to the Chilean military attaché's residence in D.C., and calls were received from Chile and from members of his family to him at my office phone at night. As an employee of mine, he would appear to stand in somewhat the same situation as the petitioner's consultants in the Ellsberg case, if those calls were tapped on national security grounds for the government. Two, if taps were placed on my phone or office phones with the government on the authority of the Attorney General without court order during the first week after my arrest on June 17th, they would be illegal, according to the Supreme Court decision on June 26th, the case of U.S. versus U.S. District Court of the Eastern District of Michigan. There's a fair chance that there were such taps during that period on my phone because at that time, the stories in the press of the bond hearings were full of innuendo that the Watergate operation may have been a Latin American or anti-Castro operation of some type. A tap on domestic security grounds on the Attorney General's authorization only, now illegal, would be a fair likelihood. Three, any calls by me subsequent to the June 17th to any organization on whom there were national security wiretap would on motion have to be disclosed to the defense if any of the three arguments set forth in the Ellsberg writ, under reasons for granting the writ, proved successful before the Supreme Court. If not disclosed, then prosecution would have to be dropped. The two slip opinions of the Gelberg case and the U.S. District Court case from Michigan were mailed to you about 3 weeks ago. I'll be copying the rest of the appendix to the Ellsberg writ tomorrow and mail it to you. Hope you find some encouragement in this. There are two things about that, Mr. Alch, if I may. It's an extraordinarily thorough and succinct legal document. Would you agree with that?
If it came from a layman, yes, sir.
And second, that it would appear to you that your client was conveying to you the possibility that those telephone calls that he made to the Chilean embassy could form the basis for a dismissal because of non-disclosure of wiretaps on those embassies with the United States government.
That's what he was conveying to me.
Did you then, or do you now think of that as an effort to contrive a defense?
No, sir, because I asked him if these calls were relative to the case. He told me that they were. When a client comes up to you and says, I've been making calls which I believed were tapped, I think if the government refuses to disclose them, it may result in a dismissal of the charges. After having been told by him that they were relative to the case, I felt it my duty to present a motion.
I won't proceed further except to say, Mr. Alch, are you telling this committee that the only thing that saves that situation from being a contrived defense, which you should have objected to as counsel and as an officer of the court, was the single representation by your client that the material was relevant?
Not at all. Let's suppose those calls were intercepted. Let's suppose the divulging of those interceptions would have led to very, very material evidence, or evidence which led to other evidence that the government was going to introduce. That can only be ascertained by, number one, having the government come forward and saying, yes, we did intercept some calls. Then, according to my understanding, the judge looks at it, sees its relevancy, sees if it taints any other evidence.
I understand.
It's quite important.
The distinction you make then is that on the basis of filing a motion for discovery, the representation of your client that the calls are relevant to his defense was sufficient. But to go forward beyond that, you needed the substance of the messages as intercepted if they were in fact intercepted.
I had to know what they were in order to see what, if anything, could be done with them.
Thank you, Mr. Alch.
You're welcome.
Mr. Talmadge.
Mr. Chairman, it's perfectly obvious, of course, to all members of the committee that the testimony of Mr. Alch varies significantly from that of Mr. McCord in any number of instances. I want all witnesses to be put on notice at an appropriate time. Wherever there's any evidence of perjury, I expect to ask the staff of this committee to submit a transcript of that possible perjury to the appropriate prosecuting attorney for action as the situation may arise. Now, Mr. Alch, how did it happen that Mr. McCord selected you as his attorney?
He called my office and requested an appointment. That's all I know about it.
You had never met him before?
Never in my life, sir.
You don't know who suggested that he call your office?
I do not, sir.
And when he called your office, you gave him an appointment?
I did not, but whoever he spoke to set up one, and I kept it.
And then he came to see you in Boston?
Yes, sir.
And employed you at that point?
Yes, sir.
Now, did Mr. McCord ever tell you at any time that he thought he was acting legally in this matter because of the involvement of Mr. Mitchell or Mr. Dean?
No, sir.
Now, in a statement that you gave to the members of staff of our committee on May the 22nd, 1973, in the presence of Mr. Sam Dash, Mr. Thompson, Mr. Silverstein, Mr. Shure, Mr. Hamilton, Mr. Edmonston, I read the following. As the trial progressed, a decision began to loom as to whether McCord would take the stand. I asked him what he could testify to. At that point, he said that the Watergate operation had been approved by John Mitchell. I asked him how he knew this, and he said Liddy told him,
yes, sir.
Unquote.
Yes,
how do you explain that discrepancy in your evidence?
I respectfully submit it's not a discrepancy. When he told me that, he did not tell me that in any way implying that that justified the operation and made it legal. He never told me that because Liddy told him that Mr. Mitchell was involved that it was legal. He merely told me that that's what Liddy told him. At no time when he told me that was it in the context of him saying to me, and therefore I think it's legal.
As a good lawyer, why didn't you pursue that question at that time? As to whether or not Mr. Mitchell was involved, and if it had been approved by him, it would have been legal, wouldn't it?
Because, I don't know, because from the very beginning I had specifically asked Mr. McCord in discussing the defense we ultimately arrived upon whether or not he acknowledged the fact that he knew he was breaking the law when he did what he did. And he said he did understand that he was breaking the law.
Now, does the Attorney General have authority to authorize a wiretap?
I believe he does through appropriate court order.
Does it have to have a court order?
I believe it does.
I don't believe it required one at that time. I think if the Attorney General had authorized a wiretap and had directed Mr. McCord to carry it out, I think his action would have been legal. I think the authority to authorize a wiretap also carries with it the authority of breaking and entering. You didn't further investigate that point that Mr. McCord suggested to you at that time, did you?
No, sir, because as I say, when he did give me that information, it was not in the context of him saying what I did was legal.
I have no further questions, Mr. Chairman.
Mr. Alch, we've plowed and replowed about every...
Gerald Alch discussing a legal possibility with Senator Talmadge about whether the Watergate break-in and bugging could have been legal had they been approved by John Mitchell before he resigned as Attorney General. There's more Alch testimony to come, and Impact's continuing coverage of the hearings will resume after station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
Now Senator Gurney will begin his questioning of Gerald Alch, one-time defense attorney for James McCord.
Mr. Alch, we've plowed and replowed about every point of contradiction between you and Mr. McCord many times, so I won't go into those. There's one thing we haven't discussed yet, though, and that's Mr. McCord's letter to Judge Sirica. That actually touched off the Watergate affair.
Yes, sir.
So I think we ought to discuss that perhaps just a moment or two here. I have the letter before me. I won't read it all, but I will take up the various points that he brought out as to why he wanted to talk to the judge. First point, he mentions there was political pressure applied to the defendants to plead guilty and to remain silent. Now, of course, we have touched upon that to a certain extent here in the questioning of you, but can you give us any further light on that?
I cannot, sir.
Did he ever discuss with you at any time, either from the time he first engaged you as his lawyer until the time he dismissed you as his lawyer, anything about any political pressure brought against any defendant in the Watergate affair?
He did not, as I believe he stated in that letter.
One thing that Mr. McCord did testify to earlier was that he had some conversations during the trial with Mr. Barker and also with Martinez, Gonzalez, and Sturgis. As I understood the testimony, it was during recess periods or after the trial. He would see them in the corridor, he would talk to them, and that's when this business of political pressure came up. That is, the other defendants saying that political pressure was being brought on them, they didn't know exactly what to do about it, and his testimony seemed to indicate they were trying to find out what he was going to do. Were you with your client most of the time during this trial? What I'm trying to find out was, of course, were you present at any of these talks, and were you with your client most of the time?
I thought I was, but as I review his testimony, there apparently was a great deal of activity on his part to which I was not privy, either by being present or having knowledge.
Well, on that score, Mr. Alch, would you describe to the committee how you and your client were together during the trial, from the first time that you met in the morning or whenever the trial began until you parted at the end of the day? Would you describe that?
Yes, sir. On most occasions, he would pick me up at my hotel. We would drive to court. I can't say that during every 5 or 10-minute recess I stayed by his side. I'm sure there were many occasions when I conversed with others. At lunchtime, we would walk over to, I believe it's the museum near the courthouse. We'd have lunch there. I did not always have lunch with Mr. McCord. On some occasions I did, on some occasions I didn't. When the court would adjourn for the day, he and I and Mr. Shankman would take a taxi cab to my hotel. Sometimes Mr. Shankman would come right up with us. Other times he'd go up to his office, which was directly across the street, to check on phone calls. We'd have a discussion on what happened that day and what was about to happen the next day, and Mr. McCord would go home. My next contact with him would be to repeat that procedure the following day.
Were you with him at any time that he had discussions with Mr. Barker or these other men?
No, sir.
And at no time did he mention to you anything about political pressure, either before or during or after the trial?
The first time he mentioned it to me is when, well, he didn't mention it to me when I turned to him about that letter and asked him not specifically about political pressure, but why he had done this without telling me.
And what did he say to that?
He orally repeated what he said in the letter. He had not told me because of my own protection.
Why did he think that you needed protection by
I don't know.
Confiding you as his attorney?
I don't know.
Then the next point he makes here, number 2, perjury occurred during the trial in matters highly material to the very structure, orientation, and impact of the government's case, and to the motivation and intent of the defendants. Did he ever discuss any perjury that he thought had been committed at the trial?
No, sir. The closest he ever came to that was when Mr. Magruder was testifying, and he leaned over to me and he swore at Mr. Magruder, period. When I cross-examined Mr. Magruder, this is why it sticks out in my mind, in trying to support my defense, asked Mr. Magruder if he knew Mr. McCord, if he could observe his duties. He said he could, and I asked him to give me his opinion or describe the manner in which Mr. McCord carried out his duties, and he had nothing but superlatives for him. That's it.
In his testimony before the committee, as I recall, Mr. McCord had mentioned either before or during the trial that he was afraid perjury was going to be committed, but he never discussed this with you at any time.
No, and again, I referred to that admission of his in his letter.
What about the motivation and intent of the defendants? Did he ever discuss that with you?
No, sir. Keeping in mind...
Except his own, of course.
Of course, but keeping in mind that after the first 2 or 3 days of trial, there were only 2 defendants.
Yes, but he never discussed the motivation and intent of any of the people who were arrested in the Watergate affair.
No, sir.
Then he goes on to say, number 3, others involved in the Watergate operation were not identified during the trial when they could have been those testifying. Did he ever say anything about that?
He did, in this sense, during the trial, as I said yesterday, when we were talking about whether or not he would take the stand to testify. I asked him what the nature of his testimony would be, and that's when he told me that Mr. Liddy had informed him that Mr. Mitchell had known and or approved of this operation.
Now, on that score, why do you think he brought that up? I remember that you had discussions with him about it as to whether he would testify or not, but why do you think he brought this up? What was his motivation?
I can only guess. It happened when I asked him, when we were trying to decide whether or not he would take the stand. I said to him, now tell me, when you get up there, you're going to have to tell all that you know. Just what do you know about this thing? Our defense of duress had been turned down by the court. That's when he told it to me. Why he chose that time to tell it to me, I honestly don't know.
Well, did you ask him? Well, now, if Mr. Mitchell is involved in this, how is this going to help you in the defense that we're presenting to the court here? Was that ever discussed?
I did tell him. First of all, I asked him, who told you? He said, Mr. Liddy. I said, do you have any other corroboration of this? He said, no. I said, well, you know that this is not a part of our defense. The defense of duress it was not a part of, and the only actual defense we had was just to argue a general lack of criminal intent, which I had told him wasn't going to amount to much. It was in that respect that I told him that, but I did tell him that despite the relevancy or lack of relevancy to his preferred defense, that was going to come out in response to questions put to him if he elected to take the stand. He elected not to do so.
Number 5, he says, some statements were unfortunately made by a witness, which left the court with the impression that he was stating untruths or withholding facts of his knowledge, when in fact only honest errors of memory were involved. Who was he talking about there? What was that about?
I'm not sure. I believe that he was talking about Mr. Baldwin. I'm not sure. I believe he was talking about Mr. Baldwin when Mr. Baldwin said that he could not or thought that the letter or the man to whom he was to deliver the logs at the committee to re-elect the president had a German-sounding name. And at one point, whether it was before or after trial, Mr. McCord mentioned to me that the log had in fact been addressed to Mr. Liddy, and that this was an honest mistake in recollection on Mr. Baldwin's part. That may be what he was referring to.
I see. That was not discussed during the trial with you?
Not to my knowledge.
This was afterward?
It may have been. I'm not sure. It could be that when Baldwin was testifying to that effect, Mr. McCord may have turned to me and advised me of that I think he's mixed up, because I remember that the name on the envelope was Liddy, and that there was a guard there with a German-sounding name, and he's confusing it. He may have told me that at the time of Mr. Baldwin's testimony.
Apparently it isn't a very important point, but something that he remembered about the course of the trial.
Apparently.
Number 6 in his letter to the judge says this: my motivations were different from those of the others involved, but were not limited to or simply those offered in my defense during the trial. This is no fault of my attorneys, but of the circumstances under which we had to prepare our defense. What can you tell us about his motivations being different from those of the others?
I can only tell you two things. Number one, he told me that his motivation, that is, the protection of others, was peculiar to him. As to his reference to other areas which we did not pursue through no fault of my attorneys, I don't know, but I can only surmise he was making references to areas of which he had made no disclosure to me.
Do you know if he wrote the letter or if anybody else wrote the letter?
The letter to Chief Judge Sirica?
Yes. What I'm reading from.
The only information that I have that could in any way be interpreted as an answer to that question is this. When I called up Mr. Finsterwald, the night of the day that the memorandum came out alleging that I had told him about the forging of CIA documents, and I asked him why this had been done, he made a reference, Mr. Finsterwald made a reference in the telephone conversation that this was a bomb just like the one we dropped on you back before Judge Sirica. It stuck out in my mind because of the use of the word we. Whether it was intentional or non-intentional, I don't know. That's what was said.
And I take it what you're saying is that in your own mind, you surmised that together they had drafted this letter, which went to the judge.
At that point, I had.
Of course, at that point, Mr. Finsterwald was not Mr. McCord's attorney, was he?
No, sir.
I mean, to your knowledge.
Well, I know this much. I don't know whether or not he was in contact with him, but he had not yet entered his appearance as attorney of record.
Yes. Speaking of that, you mentioned, I think, at one time, and I can't remember now, but it was in the courtroom, or you were coming out of the courtroom, that this unknown man rushed up and said to McCord, you can use my office. When did that occur?
In the 20-minute recess that Judge Sirica allowed us to more or less react to his reading of the letter. I stayed in the courtroom with Mr. McCord. It was at that time that Mr. Finsterwald came up and whispered to Mr. McCord, if you need an office after this is over, use mine.
And this was during the letter affair?
Immediately after it was read in open court.
Well, why would he do that?
I don't know.
I would think he might offer an office to you.
That could be more appropriate, but as to why he made the offer to Mr. McCord, I don't know.
Did he, McCord, identify Finsterwald as Finsterwald at that time?
When I asked who this gentleman was, Mr. McCord said, this is Mr. Finsterwald. Mm-hmm. I turned around and said, oh, I've talked to you a great deal on the telephone. How do you do? Mm-hmm. And that's when Mr. McCord said to him, the only thing I'm sorry about is pulling this surprise on Jerry. Mm-hmm. Mr. Finsterwald said, surprise hell, let it all hang out.
The testimony before us shows, as you know, that McCord and Caulfield met on some occasions and talked about executive clemency between them. Did McCord ever discuss this with you? any meetings or conversations he ever had with Caulfield?
Other than to say that he had received a call from a man whose name I recall to be Caldwell, that he would not tell me who he was or what he was talking about. I told him that was his prerogative, and as I explained this morning, my concern was to see whether or not there would be any indication that my counsel to him was being disregarded, tampered with, or modified.
But he never mentioned that Caldwell, as you call him, ever discussed executive clemency with him?
No, sir.
One final question, Mr. Alch. Back to the Bittman meeting and Barker going with you in the taxi cab to the meeting. Did you ever have any discussion at any time with Mr. Barker about what came out of this meeting with Mr. Bittman?
No, sir. I never saw Mr. Barker that day after he got out of the cab. And the reason in my statement I put down there was no significant conversation is because my recollection is that there was no conversation, and then it dawned on me I must have said hello and goodbye to him, so I put down no significant conversation.
But you never had any discussion with him either at any other time?
No, sir.
That's all, Mr. Chairman.
Thank you very much. Mr. Alch.
Yes, sir.
You have described Mr. F. Lee Bailey as the head of your law firm, isn't that correct?
Yes, sir.
You've also testified that as a matter of practice and procedure, you consult with Mr. Bailey on every step, every development in any case under your jurisdiction?
Well, I wouldn't say every step of every case, but we do confer, and I give him more or less of progress reports on the case.
Does he also advise you as to what you should be doing?
On occasion, he tells me what, in his opinion, would be the right thing or the wrong thing to do.
And is this a partnership?
No, sir.
Are you an employee of Mr. Bailey?
Yes, sir.
Does the fee that was received from Mr. McCord, the $25,000, going to the law firm or going to you?
Unfortunately, it goes to the law firm.
It goes to the law firm. You've testified, if I recall, that Mr. McCord really wanted Mr. Bailey to represent him. Isn't that correct?
That's what he told me.
And that Mr. Bailey had indicated that he did not want the case.
That is correct.
But you decided to take this.
When I told Mr. McCord that Mr. Bailey didn't want it, he said, well, you look all right to me, you impress me enough, will you represent me? And I said yes.
Do you know why Mr. Bailey didn't want this case?
No, sir. It may have been his commitments, his lack of time, I don't know.
Under ordinary circumstances, or shall I say in normal times, I would not be asking you the following questions. However, because of the bizarre nature and circumstances of the matter before this committee, I feel compelled to ask you these questions.
I understand, Senator.
Number one, was Mr. Bailey indicted by a federal grand jury?
Yes, sir.
When did this happen?
To my knowledge, the indictment came down May 18, 1973.
Did you discuss your appearance before this committee with Mr. Bailey?
Only to the extent that I advised him that I had received a telegram from Mr. Dash, marked urgent, asking that I contact him, and I did so.
Has this indictment in any way influenced your appearance before this committee?
I don't see how it could.
Have you been in contact with any person officially or otherwise connected with the committee to re-elect the president or the administration?
I have been in contact, as I explained yesterday, with Mr. Paul O'Brien, who was introduced to me, or to whom I was directed by Mr. McCord, and whom was described as Mr. McCord as counsel to the committee to re-elect the president.
My question is, have you been in contact since Mr. Bailey's indictment?
No, sir.
So the indictment has not in any way affected your testimony?
Absolutely not, Senator.
Thank you very much. Mr. Chairman, I'd like to, if I may, bring up another matter. I concur with your statement, Mr. Chairman, that we should let the chips fall where they may, and the committee's investigation should go wherever the path leads. In the last few days, Mr. McCord has raised many serious charges, especially against several political organizations and members of the Democratic Party. I believe these charges should be investigated and that any Democrat involved in any illegal activity should be prosecuted. Or, on the other hand, if these charges have no substance, the air should be cleared. As we all recall, Mr. McCord in his testimony Friday and Mr. Alch today has maintained that one of the major motivations for taking part in the bugging of the Watergate officers was his knowledge of, quote, calls and conversation and coordination, quote, between staff members of these political organizations and violence groups. Mr. McCord has implied that his daily review of materials from the Internal Security Division may have fit his belief, or at least did not refute his fear. Therefore, Mr. Chairman, very respectfully, I wish to recommend that the committee submit a formal request to the Justice Department, more specifically the Internal Security Division, that it provide this committee whatever evidence and information it has collected which indicates the existence of a criminal conspiracy or the involvement of the Democratic National Committee or any of the Democratic presidential candidates named in Mr. McCord's testimony, to wit, Mr. Muskie and Mr. McGovern, with any violence groups to carry out unlawful acts.
As I understand, the staff of the committee has been trying to find out this. As I understand, the staff of the committee has been trying to investigate this field. Apart from this, I'll make an observation. Ever since I've been in Washington, I've found there's a lot of people in authority in Washington that see subversives and dissenters and ghosts hiding under bed and under every rose bush. And unfortunately, some of them get in security positions. But I certainly agree with you, this should be looked into.
Because I consider
and
this...
I'll ask the staff to prepare a letter to make the request that you suggest of the Internal Security Division of the Department of Justice.
I thank you very much, Mr. Chairman.
Senator White.
I have no questions, Mr. Chairman.
I have a few questions, Mr. Chairman. Mr. Alch, what were the exact words or the mental attitude of Mr. McCord when you confronted him with the offer to plead to one charge in exchange for him being a government witness, assuming that you did not recommend it?
He said in words to the effect, no deal.
And what else did he say?
Just tell them that I am not interested in that type of an arrangement.
Now, this was communicated to Mr. McCord as a result of your meeting in the office of Mr. Bittman. Is that correct?
Are we talking about... I may have misunderstood you, Senator. Were you talking...
Well, as I understood your testimony, you went to Mr. Bittman's office on January the 8th.
Yes, sir.
You went into a private conference with him.
Yes, sir.
And you discussed with him the possibility that Mr. Hunt was going to offer a plea of guilty.
Yes, sir.
Now, did you at that conference ascertain, or did you at that conference receive the suggestion or analyze the suggestion from the prosecutors as to what they might do if Mr. McCord would plead guilty?
No, sir.
Did you discuss it with Mr. Bittman?
I did not.
I understand from your testimony, of course, that these conferences or offers by the prosecutors took place in the courtroom. Is that correct?
Either in the courtroom or at their office.
Yes. Now, did you attend any other conferences in Mr. Bittman's office?
Yes, sir.
When was this?
The exact dates I don't recall. I recall the purposes. One such purpose was to prepare motions, memoranda, affidavits in support of motions. One such occasion, Mr. McCord accompanied me up there. The reason...
But he remained outside?
No. He came in with me on this particular occasion to which I'm referring because we were using Mr. Bittman's office and secretarial help because of logistic problems whenever immediate typing had to be done.
Now, on what date did you and the lawyers for the other defendants meet to work out the strategy for the trial?
There were several meetings. I cannot specifically recall the dates. I could tell you that there were, to my recollection, perhaps 3 or 4 in the late fall and winter, in the late months of 1972.
During what particular conferences did the matter of the CIA involvement being used as a defense occur?
Mr. McCord claims it was December 21, 1972. It could very well be. He may very well be right in that respect.
And with respect to that conference, what transpired specifically?
As I told the other senators, I announced what my defense was going to be. The response was, well, this applies to your man, but it doesn't do us any good. At that point, the question was asked, is this a CIA operation? In the conversation that followed, it was pointed out that some of the defendants, if not all of them, had prior CIA connections, that one of them had been caught with documents which purported to be CIA forged credentials, and each lawyer agreed to ask the client whether or not there was any factual basis for CIA involvement, and then we went on to other topics.
Well, who brought up the matter of using the CIA involvement as a defense?
As I've told the senators, I'm not sure. It may have been Mr. Bittman. It may have been one of the other defense attorneys. I just don't have a specific recall.
Were any of the defendants present at this conference?
I believe that... I believe Mr. Liddy was present.
Did you communicate specifically to the conference and those attending that Mr. McCord would have nothing of that?
Not at that time, because I hadn't discussed it with him. After I discussed it with him and he told me that, at a subsequent meeting, I did say to them, Mr. McCord says there's no CIA involvement and he'll have no part of any allegations to the contrary.
When did you discuss it with him? More or less.
Immediately after the meeting.
Was that in late December?
December 21, I believe. And then a few days later in Boston.
Well, Mr. McCord advised Mr. Shankman, your local participator in the defense, that he did not want to communicate with you for the reason that you were trying to get the CIA involvement in as a defense. That's correct, isn't it?
That's what Mr. Shankman told me Mr. McCord told him.
And that's what you testified to here.
What I said, sir, was that when I confronted Mr. McCord, after the letter of dismissal had been given to Judge Sirica, I told him that Mr. Shankman had told me the reason for his being dissatisfied was this CIA contemplated defense, and I said to him in words or substance, I thought that was laid to rest at our last meeting, to which he replied, that's not my reason. My reason is I don't think you're communicating with me enough, I don't think you're adequately preparing the case, etc.
Did you feel at any time that Mr. McCord was not giving you all the material facts to present an adequate defense?
Well, I knew from the very beginning by what he told me. When I asked him exactly what's involved, he said, I'm just going to tell you what my motivation was.
Well, you indicated in your testimony that he would not give you, in many instances, immediate responses.
That's right.
And there would be days of lapse, and then he would come back with definite answers.
Yes, and mostly in written memoranda.
Well, did this not disturb you in trying to present an adequate defense?
It puzzled me a bit, because
Did it ever occur to you that in view of that attitude by Mr. McCord and his failure to respond to your questions and divulge all the necessary information, that you might consider withdrawing from the case?
No, sir, for this reason. What I would ask him to give to me was corroboration on a lot of things. From the very beginning, he said, this is why I broke into the Watergate. And I would say to him, well, can you give me reasons documenting or corroborating your intention? And he'd say, let me think about it. Then I would get in the mail memoranda, some of which I've made available to this committee, outlining, here's my reasons, here's the information I was receiving.
All right, then during your meeting, and immediately during your meeting of January the 8th, you indicated that Mr. Bittman had told you, when you expressed Mr. McCord's concern about what was going on and that he was being made the fall guy, you indicated that Mr. Bittman had told you, tell McCord that he will receive a call from a friend.
Yes, sir.
Now, did you at that time ask Mr. Bittman what that call would be about?
I did not.
Did it arouse your curiosity?
To the extent that I surmised that it was something to do with his fears or suspicions that his co-defendants were ganging up on him, because Mr. Bittman said it right after I made that remark to Mr. Bittman.
Now, you're known as a very inquisitive lawyer. You didn't ask any question as to who might be calling your client on that night?
I did not. I assumed, without asking, that it was going to be or could have been Mr. Hunt.
And did you ask Mr. McCord, when you told him this, who might be calling him that night?
I did not.
Did you speculate as to what the call might be?
Yes, sir.
What did you speculate to him about?
That the purpose, I didn't speculate to him, I speculated in my own mind that the purpose might be to allay his fears.
Now, after Mr. McCord spoke to this alleged friend, did you ask him the next day what the call was about?
No, sir. It didn't come up the next day. It was some days later, and I don't exactly recall how many days it was.
And you had no curiosity in your mind about this thing at all?
No, sir. I was preparing a case. We were selecting a jury. I had my hands full.
All right, now, when you discussed, or did you discuss with Mr. Bittman the offer of clemency?
In the context that I have described, yes, sir.
Do you believe or have reason to believe that Mr. Bittman was serious about this offer of clemency?
In my opinion, he was not.
All right. Did you discuss with Mr. McCord the possibilities of clemency in the event that he should plead guilty?
No, sir. The only time I discussed clemency with him is when I relayed to him my discussion with Mr. Bittman, and I told him in words or substance, don't rely on it because it won't happen.
Now, at the time that you were advised that Mr. Hunt would plead guilty, did you ever entertain the notion, or was there ever any discussion to the effect that the plea would be in exchange for a later grant of executive clemency?
No, sir, because the reason given to me by Mr. Bittman was that Mr. Hunt was so emotionally upset over the death of his wife that he simply could not stand the rigors of a trial. That's what was told to me.
Were you aware, or did you have any suspicions that Mr. McCord or any of the defendants were being offered clemency in exchange for a plea of guilty?
No, sir.
Were you aware of any interest on the part of any people at the White House that in the event Mr. McCord would plead guilty, that there would be some favoritism with respect or in the direction of clemency from the White House?
No, sir, I don't know anybody at the White House.
Now, I recognize the two positions taken here in the testimony between Mr. McCord and you.
Yes, sir.
Now, Mr. McCord has already pleaded guilty or has been found guilty by the court and jury, and he is up for sentencing. He has nothing at stake now except waiting for the mercy of the judge in the sentencing procedure. Now, there is this obvious contradiction in the testimony, and I see that Mr. McCord's testimony will serve him no further except to say the truth. Now, you have denied his testimony in your statement. My question to you is, what would be the consequences to you as an attorney should the McCord allegations be found to be true?
Are you talking about the allegations that I...
With respect to you.
Well, what specific allegations? All allegations which I have denied, I say are not true.
Now, you have an interest in trying to dispel the veracity of Mr. McCord's allegations in that if they would be found to be true or credible, you would be subject to some ethical, some reprisals from some grievance committee or from a court. Would that not be true?
Perhaps as I look upon it now, my immediate reaction when I heard them, Senator, was that the man is telling things about me that are not true, that accuse me of improper, illegal conduct, and I want an opportunity to refute those allegations.
So you have a very specific interest, with which I do not quarrel, in appearing before this committee to dispel what has been said about you by way of casting aspersions on your integrity.
Yes, sir.
All right, that's all.
A few questions.
Yes, sir.
Mr. McCord told you that he had been furnished information from the Internal Security Division of the Department of Justice and from other sources which led him to believe that there might be some violence practiced against the president or his surrogates in a campaign, didn't he?
Yes, sir.
And that was the kind of defense he wanted in opposed, wasn't it?
Yes, sir.
And you studied that defense and briefed it, and Judge Sirica held during the progress of the trial that he would charge that defense was unavailable, legally speaking.
Yes, sir.
Then the only defense you were left with was a defense of a lack of criminal intent on the part of Mr. McCord.
If it can be called a defense, yes, sir.
Well, it was a very, as you told him, that was a very weak defense, and I think that's because there's a rule of law, is it not, that every man is presumed to intend the natural consequences of his own acts, and the natural consequence of his own acts was that he was caught in the Watergate.
That is correct,
yes.
Sir.
Now, you suggested you might solve some conflict in testimony by a polygraph test.
Yes, sir.
Do you not know as a lawyer that polygraph tests are not admitted in evidence as in any court in the United States?
I believe that in some jurisdictions, Senator, if there is a stipulation by the adversary parties to the effect that whatever the results are, if the judge in the case determines that it's given by a competent examiner under proper circumstances, it's admissible. I also know of recent federal decisions. The reason I say this is because, as a defense attorney, we sometimes utilize that, both for investigation and try to get it into evidence. I'm also cognizant of certain recent federal decisions which have held that under certain circumstances it is admissible.
But don't you know as a lawyer that the overwhelming majority of all judicial decisions in this country are to the effect that the polygraph test will not be received as evidence?
Senator, I was asked by Senator Baker as to any suggestion I could offer as to how to resolve the question of credibility, which understandably to me is most important. I gave the Senator that answer.
Well, my question has got in relation to that. Don't you know as a lawyer that polygraph tests, results of polygraph tests are not received as evidence by any court in the United States?
I do not. I believe that there are certain jurisdictions now, today, that there are opinions which state they are admissible. I believe, and this is just my opinion, that as time goes on, they will eventually be admissible. But I think they are admissible in some jurisdictions today.
My question is this. Don't you know as a lawyer that the overwhelming majority of all courts in the United States hold that polygraph test is not admissible in evidence?
Yes, but the trend, in my opinion, is beginning to go the other way.
Well, of course.
And I think it should.
There are 96.
I have faith in them.
There are 96 different federal judges in the United States and district judges. 96, no, more than that. 96 separate federal districts in the United States. And there's an old lawyer in St. Louis made a speech some time ago and said, don't waste your time looking up the law in advance because you can find something in some federal district court that will sustain any proposition you make. Now,
well, Senator, if I may add, I know from my experience that a great many, if not all, prosecutors heavily rely on them.
Yes, I haven't made a study of polygraph testing. I call them 20th century witchcraft. I think that a brazen liar could pass one without any difficulty, and a nervous person who was truthful couldn't have great difficulty passing, but we needn't pass on that now.
I'd like to say a word about it. I'll say it now, or I'll say it when you finish, Mr. Chairman, whichever way you'd rather.
Okay. Now.
Well, to begin with, I didn't bring up the question of the lie detector test, the polygraph test. I asked for, and the witness very properly answered,
yes, sir,
for any suggestion that we had as to how we can arrive at the truth in a contradictory situation. Now, this isn't a court of law. We're not bound by the rules of evidence. We were, we wouldn't have gotten two-thirds of the testimony we have. It would have been out on the hearsay route. But this is a fact-finding group, and I'm not suggesting that we compel these witnesses to take a polygraph test, but I must say, Mr. Chairman, that if these people who are in conflict want to do that, I think we would do a disservice if we did not permit them to and receive that for whatever it's worth. If I were a sitting judge and had to decide whether the results of that test was hearsay or not, I'd be hard put to conclude that it was not hearsay or was not in violation of the constitutional guarantee against self-incrimination. But I'm not a judge. I hope I never am a judge.
Well, I follow the rules of evidence as far as I can because I think that the experience of the race and the administration of justice shows it's about the best way to ascertain truth in controversial
All right, let me make a suggestion, Mr. Chairman, if you'll listen to me just for a second. If you, and I'd like Mr. Dash to hear too, I don't have any idea what Mr. Fenstervall will say about that, about whether he wants to take a polygraph test or not. And if he doesn't, there's nothing anybody's going to do about it, nor is anybody, as far as I'm concerned, going to make any comment about it. That's yet to be determined. But if we are suddenly going to be bound by the rules of evidence, we have given them only the most glancing pass so far in this hearing, then I would suggest as an alternative possibility, Mr. Chairman, that if it is indeed the embodiment of 20th century witchcraft, which I do not believe, because I think virtually every police department of the United States now uses it in its investigative work, I would suggest instead the possibility that the staff, as a part of its investigative technique, undertake those results, and then this committee will decide whether it has any value or not.
Didn't Judge Sirica state several times during the course of the trial of the criminal charges that the lawyers on either side of the case were asking the right questions in respect to whether the accused were hired to break into Watergate, and if so, by whom they were hired?
My recollection, Senator, is that if those questions were asked by Chief Judge Sirica, they related to the prosecution.
Yes. Well, now, as a matter of fact, didn't it come out in the evidence that Sturgis, Barker, Martinez, and Gonzalez had approximately $4,200 in bills whose serial numbers showed that it came from campaign funds contributed to re-elect the president?
I have no specific recall. That may be correct.
You don't recall that?
Not specifically.
Well, do you recall it otherwise than specifically? Don't you recall evidence to that effect?
I don't recall the exact amount. I remember that there was money introduced.
And don't you know that they were traced in the evidence to the serial numbers from a bank in Miami, taken out of $114,000 in deposit, $89,000 of which came through the Mexican banks, and $25,000 through a check of Mr. Ellsberg.
I believe that was the evidence.
And also came out there, you were told by your client that John Mitchell was involved, and he told you that he'd been told that by Liddy, didn't he?
He did.
Yes. And he knew that Liddy and McCord and Hunt had all worked for the committee to re-elect the president?
I did.
Yes. And Mr. Magruder, was any questions asked of whether anybody, to indicate whether or not anybody other than those three were involved in the Watergate?
By me?
By anybody.
I don't recall. I did not.
Yeah.
The disclosure from Mr. McCord regarding what Mr. Liddy told him came after Mr. Magruder had testified.
Now, as a matter of fact, didn't the Department of Justice maintain, clear up to the Supreme Court of the United States, that the Attorney General had the right to exercise electronic surveillance over persons suspected of domestic subversion without any order of court? Or that the President, acting through the Attorney General, had that power?
I don't recall that. If you are referring, and I'm asking this respectfully, are you referring, Senator, to when there was an appeal regarding whether or not the contents of the monitoring call should be divulged?
But don't you know as a lawyer that there were several that we talked about these district court cases on that point, some of which held that the President had the inherent power to wiretap without an order of court in case of domestic subversion.
Yes, sir.
And others holding to the contrary.
Yes, sir.
And finally, the Supreme Court of the United States, that happens 2 days after the Watergate break-in, handed down a unanimous decision that that power did not exist.
Yes, sir.
Anything else? I don't. Present no objection. Any other further question? We'll stay in recess till 2 o'clock. 2 o'clock.
Am I excused? Should I return, Senator, or am I excused?
Oh, wait. If any sons of them want to ask him any questions? We will excuse you subject to recall.
Thank you.
Take a little break now. We don't cut anything out. We'll just stop the videotape for a while, give you a little breather, have a cup of coffee, or let the cat out, and also so our local stations can identify themselves. We'd like to say thank you to the 25,000 of you or so who've written in expressing your opinions, most of them approving, about this kind of coverage. If any of you would still like to write, we'd like it very much. And you can do so by reaching us at NPACT, P.O. Box 300, Washington, D.C. 20044. NPACT's coverage of the hearings will continue after a brief pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
Well, the committee's reassembled now after the lunch break, and the witness who's to testify is Bernard L. Barker, an aide to E. Howard Hunt during the Bay of Pigs invasion. Barker participated in several break-ins in 1971 and 72.
The committee will come to order, and counsel, Mr. Hamilton will call the first witness.
Mr. Bernard L. Barker, please.
Mr. Barker, you solemnly swear that the evidence you should give to the Senate Select Committee should be the truth, the whole truth, and nothing but truth, so help you God. Now let the record show that the witness is testifying under an order of immunity entered by Judge Sirica pursuant to the resolution and request of the committee under sections 6002 and 6005 of the Title 18 of the United States Code. You may take your seat, Mr. Barker.
Mr. Barker, would you state your full name, please?
My name is Bernard L. Barker.
And where do you reside, Mr. Barker?
At present, I am at cell block 4, District of Columbia Jail.
And where is your home residence?
5229 Northwest 4th Street, Miami, Florida.
Mr. Barker, would you please give us the date and the place of your birth?
March the 17th, 1917, Havana, Cuba.
And were your parents American nationals?
Both my parents were American nationals. My mother was an American national of Cuban descent.
Now, Mr. Barker, did you serve in World War II?
That is correct.
And were you a prisoner of war?
That is correct.
Mr. Barker, do you now stand convicted in regard to your role in the break-in of the Democratic National Committee headquarters at the Watergate on June 17, 1972?
I do.
And did you also participate in a break-in of those headquarters on the Memorial Day weekend of 1972?
I did.
Mr. Barker, who recruited you for these activities?
E. Howard Hunt.
And was Mr. Hunt your supervisor in the Watergate operations?
That is correct.
And had Mr. Hunt also been your commanding officer in the Bay of Pigs operation?
The word commanding officer, I was Mr. Hunt's principal assistant in the Bay of Pigs operation.
And Mr. Barker, was the first Watergate-type affair that you participated in the break-in of the office of Dr. Ellsberg's psychiatrist in September 1971?
That is correct.
Now, for these activities, the Watergate operations and the Ellsberg affair, were you paid by Mr. Hunt for your participation in these matters?
No.
Well, if you received no pay, Mr. Barker, what was your motivation for participating in these operations?
The original operation was the Ellsberg operation. It was explained to me that this was a matter of national security. After this operation, the second operation was on Mr. Hoover's death, and this was an operation to give assistance and to infiltrate a group of persons that were at the Capitol stairs.
Mr. Barker, would you put the microphone a bit closer to your mouth, please?
Yes. Third operation was the first entry into the Watergate. There was a second entry at the Watergate when we were captured. At no time was I told any different from the original motivation for which I had been recruited.
Mr. Barker, is it correct that part of your motivation for participating in these operations was to gain later assistance from Mr. Hunt and others in high places for a Cuban liberation operation? Is that correct?
Our team, which was composed of myself and three, Mr. Martinez, Mr. Sturgis, and Mr. Gonzalez, to us this was our prime motivation.
Mr. Barker, in the two Watergate operations, was it your job to search for documents to be photographed?
That is correct. That was my only job.
And was it Mr. Martinez's assignment to handle the photography?
Mr. Martinez's assignment, he worked as a team member with me. His assignment was to photograph the documents I gave him.
What sort of documents were you primarily looking for in the Democratic headquarters?
I was looking for documents that would involve contributions of a national and foreign nature to the Democratic campaign, especially to Senator McGovern, and possibly also to Senator Kennedy.
Were you looking for documents that reflected contributions from any particular foreign government?
The foreign government did not exist in the island of Cuba.
Were any documents of this particular type found during the first entry?
No.
Now, after your arrest and transportation to jail, did lawyers eventually arrive at the jail to assist you?
Yes, a lawyer arrived at the district jail.
And would you tell the committee, please, the names of these attorneys?
Mr. Caddy and Mr. Rafferty.
Now, are those attorneys Douglas Caddy and Joseph Rafferty? Is that correct?
That is correct.
Had you called these lawyers to come to the jail?
No, sir.
And to your knowledge, had any of those arrested called these lawyers on the telephone?
Not very well, no, sir.
Do you know who supplied these lawyers to you?
No, I do not know.
Now, did there come a time when you, for yourself and the others arrested, received certain monies from Mrs. Hunt?
That is true.
And would you tell the committee the total amount of the monies that you so received?
The total amount of the monies that I received, to the best of my recollection, included approximately $17,000 for bail bond money, of the between $10,000 and $12,000 for expenses during the period to cover from that time until trial, and I received the amount of, to the best of my recollection, of $18,000, of which $5,000 was for, I think it was Mr. McCord's civil suit fee to Mr. Rothblatt, and the other $13,000 was to cover for Mr. Rothblatt's fees of the 4 Cuban Americans involved.
And Mr. Barker, when was the last payment that you received from Mrs. Hunt?
From Mr. who?
From Mrs. Hunt, the last payment that you received.
I think the last payment I received was the money, to the best of my recollection, was the money for the attorney's fees.
And when was that, Mr. Barker?
I would put it at the month of October, approximately.
1972.
That is correct, sir.
And Mr. Barker, were there any conditions attached to this money received from Mrs. Hunt that required you to either plead guilty or to remain silent?
There were absolutely no conditions, And the answer to either a plea of guilty or to remain silent is negative.
Mr. Barker, were any offers of executive clemency transmitted to you or threats communicated to you in order to induce you to remain silent?
No.
Would you tell this committee why you chose to plead guilty?
I was guilty. I was caught inside of the National Democratic headquarters at 2:30 in the morning.
Mr. Barker, my final question. Do you have any knowledge that anyone higher up than Mr. Hunt or Mr. Liddy was involved in the Watergate operation?
I knew Mr. Hunt by name, although I dealt with Mr. Hunt under the code name of Eduardo in this operation in the same way as we used that code name in the Bay of Pigs invasion. I knew the person I know now as Gordon Liddy. I knew him as George Leonard. I did not find out Mr. Liddy's name until after I was in jail, and he was, to the best of my understanding, Mr. Hunt's superior. This can be indicative to this board that I knew of no one absolutely connected with this above Mr. Hunt by person and Mr. Liddy by the name of George Leonard.
Mr. Chairman, no further questions at this time.
Yes. Mr. Barker, was it your opinion at the time of the break-in of the Democratic National Committee headquarters at the Watergate that your operation was a CIA operation?
I do not know the answer to that
Was
question.
it your opinion at that time that it was a CIA operation?
The only opinion that I can intelligently make is that it's a result of the first operation in which I was involved. In the first operation in which I was involved, I was told, and I am speaking of the Ellsberg operation, that it was a matter of national security, of high sensitivity, that it involved a traitor to this country who had given information to a foreign embassy, he or his associates. And I proceeded on that assumption at that time. Since then, I have been told nothing different of any other organization. I was explained at that particular time and place that national security was above FBI and CIA.
Haven't you stated that the manner in which the operation was carried out, the person to whom you were responsible, your former superior, Mr. Hunt, the manner in which you were taken care of financially, all pointed toward the fact that it was a CIA operation?
The methods utilized in the operation were the same methods utilized when I worked for Mr. Hunt in the Bay of Pigs invasion. This training I received with the rest of the Cubans from a government agency. This does not mean that this was a CIA operation.
But wasn't it your opinion at that time that it was, and wasn't it your opinion even after that time when you were receiving this money, that it was a natural thing, that it was ordinary thing?
The monies that were received for the attorneys, for expenses, and for the family support was received in the same spirit and under the same conditions that would have been similar in a CIA operation. Comparatively, it is based on the following philosophy. If you are caught by the enemy, every effort will be made to retrieve you. All expenses will be taken care of, and you're... That is correct, sir.
And Mr. Barker, were there any conditions attached to this money received from Mrs. Hunt that required you to either plead guilty or to remain silent?
There were absolutely no conditions, and the answer to either a plea of guilty or to remain silent is negative.
Mr. Barker, were any offers of executive clemency transmitted to you or threats communicated to you in order to induce you to remain silent?
No.
Would you tell this committee why you chose to plead guilty?
I was guilty. I was caught inside of the National Democratic headquarters at 2:30 in the morning.
Mr. Barker, my final question. Do you have any knowledge that anyone higher up than Mr. Hunt or Mr. Liddy was involved in the Watergate operation?
I knew Mr. Hunt by name, although I dealt with Mr. Hunt under the code name of Eduardo in this operation in the same way as we used that code name in the Bay of Pigs invasion. I knew the person I know now as Gordon Liddy. I knew him as George Leonard. I did not find out Mr. Liddy's name until after I was in jail, and he was, to the best of my understanding, Mr. Hunt's superior. This can be indicative to this board that I knew of no one absolutely connected with this above Mr. Hunt by person and Mr. Liddy by the name of George Leonard.
Mr. Chairman, no further questions at this time.
Yes, sir. Mr. Barker, was it your opinion at the time of the break-in of the Democratic National Committee headquarters at the Watergate that your operation was a CIA operation?
I do not know the answer to that question.
Was it your opinion at that time that it was a CIA operation?
The only opinion that I can intelligently make is that it is a result of the first operation in which I was involved. In the first operation in which I was involved, I was told, and I am speaking of the Ellsberg operation, that it was a matter of national security, of high sensitivity, that it involved a traitor to this country who had given information to a foreign embassy, he or his associates. And I proceeded on that assumption at that time. Since then, I have been told nothing different of any other organization. I was explained at that particular time and place that national security was above FBI and CIA.
Haven't you stated that the manner in which the operation was carried out, the person to whom you were responsible, your former superior, Mr. Hunt, the manner in which you were taken care of financially, all pointed toward the fact that it was a CIA operation?
The methods utilized in the operation were the same methods utilized when I worked for Mr. Hunt in the Bay of Pigs invasion. This training I received with the rest of the Cubans from a government agency. This does not mean that this was a CIA operation.
But wasn't it your opinion at that time that it was, and wasn't it your opinion even after that time when you were receiving this money, that it was a natural thing, that it was an ordinary thing?
The monies that were received for the attorneys, for expenses, and for the family support was received in the same spirit and under the same conditions that would have been similar in a CIA operation. Comparatively, it is based on the following philosophy. If you are caught by the enemy, every effort will be made to retrieve you. All expenses will be taken care of, and your family will be provided for. This was true of the Bay of Pigs invasion. To my knowledge, some of those families that at that time are still being taken care of, that I know of. And we expected this. We were not surprised, let us say, that this situation would come to pass. However, there was a doubt in my mind at that time to the effect of what did it mean? What did national security mean as above FBI or CIA? And that question has still not been solved in my mind. If it was a CIA operation, only the CIA would admit this, not I. I did not need to be told what it was. I knew the persons involved. Mr. Hunt had been my superior in the Bay of Pigs invasion, and I would assume that Mr. Hunt, who was counselor at the White House, had the authority to order me at that time or to request from me to become involved in a matter of national security for which my training and my disposition was available at that time.
Did you ever have any discussion with anybody about the possibility that if you went to trial and entered a plea of not guilty, that the Ellsberg break-in would be exposed?
This has never been discussed. The Ellsberg break-in would never have been exposed by me.
Not by you, but in the course of the trial, either by the prosecution and their case in chief, or a cross-examination of any of the other defendants, or in any manner. Was that a consideration that you had in entering your plea of guilty?
A while ago, I explained that the methods of operation we used were the same as those we had learned. It's a matter of discipline, of compartmentation, and of habit. We do not discuss these operations with anyone or even amongst each other. This was a rule between our team, and it is the type of training we have received. We have never discussed this, even amongst ourselves.
Even with Mr. Hunt?
Even with Mr. Hunt.
So you never discussed it with, excluding your attorney. I'm not speaking about your attorney now, of course, attorney-client privilege that might be present, but anyone else. You never discussed that possibility with anyone else?
Not to my knowledge, no.
Let me ask you this. Do you recall a trip you took in a taxi to Mr. Bittman's office after a day at trial with Mr. McCord and Mr. Alch?
Yes, I recall.
What's your recollection of that?
I can only say to my best recollection that I was in Washington at that time. To the best of my recollection, I had come up for a meeting of attorneys, some new motions that were going to be put in, and I had been asked by Mr. Rothblatt to meet him at Mr. Bittman's office. I saw Mr. Alch and Mr. McCord hailing a cab, and I asked them if they would drop me off at Mr. Bittman's office. I said Mr. Bittman's office because this is how I thought of the office. Mr. Rothblatt, my attorney, had an office in a lower level of the same building where Mr. Bittman's office was. And to the best of my recollection, I went there to meet Mr. Rothblatt. And to the best of my recollection, nothing was discussed, nothing was told to me about the meetings that the attorneys had that I can remember at this time.
Did you ever go to Mr. Bittman's office that particular day?
Did I ever what?
Did you go to Mr. Bittman's office that day?
I don't remember going to Mr. Bittman's office.
Did you part company with Mr. McCord and Mr. Alch and Mr. Shankman when you entered the building, or when?
No. As soon as I arrived, there had been no conversation in the cab. And as soon as I arrived, I thanked them for giving me the lift, and I just went up to the office by myself.
Where did they go?
The last I saw them, they were in the cab. I don't know. When I reached the elevator, they weren't there.
Let me ask you this. Go ahead.
My recollection of that meeting was that it was a pre-trial.
Pardon me. Would your attorney identify himself, please, for the record?
Daniel Ellsberg.
Thank you. Go ahead.
That this motion was a pre-trial motion that I am referring to at that time, as far as the time element is concerned. That I recollect being in the cab. I do recollect being in the cab. I am a bit confused as to the time. It was, to the best of my recollection, that the time that I got in the cab with them was to meet I remember it was to meet my attorney. It was when I came up for some pre-trial motions.
To the best of your recollection, it was before the trial had started and not during the trial.
That is to the best of my recollection.
All right. Let me ask you 2 or 3 more specific questions, Mr. Barker, and I will be finished. Let me ask you this. I don't know whether or not you've been listening to Mr. McCord's testimony, but he testified Tuesday morning to this effect in response to the following question from Senator Talmadge. He said, how did Mr. Barker or the other Cuban Americans ever come to you during the trial? He said, now, did Mr. Barker or the other Cuban Americans ever come to you during the trial and tell you that they had been offered executive clemency by Mr. Hunt? And Mr. McCord says, yes, sir. Is that true?
I don't know whether he was saying the truth or not, but I was never offered clemency by anyone.
The question is whether or not...
That is not my recollection at all.
The question is whether or not you came during the trial to Mr. McCord and told him that you'd been offered executive clemency.
I deny that.
That's not true.
Our recollections differ. I never discussed this matter with Mr. McCord, to my recollection. I would have no reason to discuss this matter with
You
Mr.
would remember that, would you not?
I certainly would remember if I discussed with him, but I couldn't remember something that I was not offered. I was never offered any kind of clemency whatsoever.
Also state that you told him that pressure was stemming from Mr. Hunt and other unnamed individuals to plead guilty and to go off to jail or prison and ultimately to receive executive clemency and to receive financial support for their families while they were in prison. And promises, he stated, promises were made that they'd be given help obtaining a job and rehabilitation. He says that Mr. Barker spoke to me several times during that week regarding that particular pressure upon him, which he described as intense. Is that a true statement?
The only pressure that I had at that time was a disagreement with my attorney, Mr. Rothblatt, as to the plea of guilty. Mr. Rothblatt did not want me to plead guilty at that time.
First of all, would you answer my question? Is this a true statement?
Not to my recollection. Mr. McCord and I have different recollections.
All right. Any further explanation you want to give, be fine.
Mr. Rothblatt refused to represent me if we pleaded guilty. At that time, I thought that the decision was up to me. I had to weigh whether pleading guilty and throwing myself at the mercy of the court, and at a time when I had been caught at the Democratic headquarters, when Mr. Hunt said that to me that the evidence against us was overwhelming.
Mr. Hunt told you that?
Mr. Hunt told me that he had been advised by his attorney that the evidence against us was overwhelming. Mr. Hunt had not been caught inside of the Watergate. I had. I consider him a very intelligent and still do capable man. And if Mr. Hunt at that time was going to plead guilty and I was caught inside, I think it would be ridiculous, and it has been proven, for me to plead anything but guilty. But this is a decision that I had to make. With all due respect to Mr. Rothblatt, and and I hope this does not reflect that any negation that he conducted himself excellently in the trial, that he was, in my opinion, an excellent attorney. This was my decision, and no one else influenced me in this decision. And I think that it was proven, time has proven that my decision to plead guilty was the correct one.
I have no further questions. Thank you.
Mr. Barker, you got involved in this at the request of E. Howard Hunt.
That is correct, sir.
You had served with E. Howard Hunt at the Bay of Pigs.
That is correct, sir.
He had been your superior.
That is true.
And all you did in this was at the direction and request of E. Howard Hunt.
Yes, except that I personally was convinced at the time, and I am today too, that what I did at that time was correct.
And Mr. E. Howard Hunt told you this was national security that you were working on, and it was above FBI and CIA.
That is correct.
And you have a code of ethics in work of this kind that you don't tell anything on anybody.
That is correct.
Yes. And so if Mr. E. Howard Hunt had pressured you into pleading guilty, you could not tell us that under your code of ethics.
I don't think that this applies to anything like that for this nature. It was my decision. I think that Mr. Howard Hunt respects me too much to ask me to make that kind of a plea. This is my decision, not Mr. Hunt's.
Well, did you talk to Mr. E. Howard Hunt about this at all?
Yes, at the time, when I spoke to Mr. Hunt told me that in his position, in his condition, he had gone through a terrible ordeal with the death of Mrs. Hunt, that he was not up physically to that situation, and besides that the evidence by the district attorney's office against us was overwhelming.
Now, Mr. Hunt told you that?
That is correct.
Yeah. And he told you he's going to plead guilty?
No, he told me what he was pleading. I decided what I would plead. I didn't decide at that time.
But Mr. E. Howard Hunt told you that Mr. E. Howard Hunt was going to plead guilty, didn't he?
That is correct, yes sir.
And Mr. E. Howard Hunt told you the evidence against you was overwhelming.
That is correct.
Yes.
The fact that we were caught, Senator, in the premises in itself is indicative that this is overwhelming evidence, sir, to my way of
So you did consult with Mr. E. Howard Hunt before you pleaded guilty?
It was not a consultation.
Well, it was a discussion.
It was a discussion, yes, sir.
And he told you that he was going to plead guilty, and the evidence against you was overwhelming.
That is true.
And then you decided to plead guilty.
Yes, but this is not pressure. This is my decision, not his decision. Yes.
But you weren't influenced at all by Mr. E. Howard Hunt?
No, influenced?
Yes.
Well, perhaps it could be interpreted so. I consider Mr. Hunt a most intelligent person. He was pleading guilty because this was overwhelming. He hadn't been caught. I had. It did appear to me that this would be the advisable thing for me to do.
And your lawyer advised you to plead not guilty, didn't he?
That is correct.
And you took Mr. Hunt's advice instead of your lawyer's?
No, sir. I made up my own mind without Mr. Hunt or Mr. Rothblatt. This was my decision that I thought that I should
Did you make up your mind before Mr. Hunt told you he was going to plead guilty and the evidence against you was overwhelming?
I did not make up my mind at that time, no, sir.
Oh, I thought not.
No.
Yeah.
Mr. Barker.
Yes, sir.
You're 55 years old.
56.
You have a real estate business in Miami. You were previously involved in the Bay of Pigs operation for the CIA. You're a veteran of the United States Army in World War II, where you were a captain in the Army Air Corps. You were a German prisoner of war for 17 months.
16 months.
Mr. Barker, what on earth would motivate you at your station in life, at your age and with that background, to do something that surely you knew to be illegal?
Senator E. Howard Hunt, under the name of Eduardo, represents to the Cuban people their liberation. I cannot deny my services in the way that it was proposed to me on a matter of national security, knowing that with my training I had personnel available for this type of operation. I could not deny this request at the time.
Why?
Because I felt it was my duty to comply with Mr. Hunt's request.
Why?
Because it involved a matter of national security.
What?
Because this is a service to my country, sir.
What national security?
Discovering information about a person who I have been told by Mr. Hunt was a traitor, who was passing he or his associates to a foreign embassy.
Who?
Pardon me. Soviet embassy.
Who?
Who? I don't understand. Who, what, sir?
Who was passing the information to the Soviet embassy?
At that time, Mr. Ellsberg's name was not mentioned. Mr. Ellsberg's name was mentioned to me half hour before the surreptitious entry. Then is when I found out the name of the person involved.
What was the connection between the allegations of the Ellsberg situation and the imminent and impending break-in into the Democratic National Committee headquarters at the Watergate complex?
At that time, none. After that Ellsberg, we came up on a matter involving security at the death of Mr. Hoover. The third time
at the request of Mr. Hoover?
At the death of Mr. Hoover.
At the what?
At the death of Mr. Hoover, when he was at the Capitol.
Mr. Hoover. Why did you come up then?
I came up with about 10 Cubans to infiltrate this group for security reasons.
What group?
A group of persons that were demonstrating in front of the Capitol against the war in Vietnam. The group included Mr. Ellsberg, Mr. Kunster, and other persons that were not of the same age level as the persons that were there, which were long-haired hippie types.
Why? Why would you do that? What did that have to do with your business in Florida or with your loyalty to the United States or your concern for the freedom of Cuba? Why would you be involved in the infiltration of a group that was there to demonstrate either the war or in the presence of the last rites for J. Edgar Hoover? Why would you do that?
I was following Mr. Hunt's instructions.
Did Mr. Hunt say why he wanted you to do that?
As a matter of security. He said that there was, as the best that I can recall, there were information that these people would probably desecrate the tomb of Mr. Hoover. It was also told to me that these people would wave a Viet Cong flag, that if it was possible to get that flag away from them. But it was not my decision. At that time, I was assisting Mr. Hunt.
Mr. Barker, when Mr. Hunt spoke of Ellsberg and the leak to the Soviet embassy 30 minutes prior to your entry into the Watergate complex in the Democratic National Headquarters, you speaking of the first break-in or the second break-in?
No, the 30 minutes, the name of Ellsberg was given to me about a half hour before the break-in into the psychiatrist's office.
I'm sorry, I misunderstood you.
Yes.
May I go back then and ask you what What was your motivation? What persuaded you to enter the Watergate complex?
Senator, like I said, it started out with Ellsberg. Then it came to Hoover. Then we came up for these operations, which involved not only the break-in at the National Democratic headquarters, but the same type of a mission into the McGovern headquarters. And our mission at those times were only to obtain and to try to locate documents that would prove that the Democratic Party and Senator McGovern were receiving contributions, national and foreign contributions, from organizations that were leftist organizations and inclined on violence in the United States, and also from the Castro government.
Did you ever find any such documentation?
No, we did not find these documents. No.
Did you have any reason to believe that such documentation existed?
The fact that the Castro government was aiding the Democratic Party had been rumored and had been spoken of freely in Miami from different organizations and personalities that I had confidence in. However, I have no hard evidence at all that this was true.
Did this play some part in your motivation for making the entry into the Watergate?
Part, yes, part, not the whole motivation.
What other part?
As I explained before, we were assisting Mr. Hunt, who was a known factor in the time of the liberation of Cuba. We had hopes that Mr. Hunt's position in the White House would be a decisive factor at a later date for obtaining help in the liberation of Cuba.
Mr. Barker, are these reasons that you've just stated the basis for your previous statement a moment ago that you believed what you did was correct?
That is true, sir.
Are there other reasons?
No, there are no other reasons that I can think of.
When did you first decide to plead guilty?
During the, I hope this isn't funny, but to better place the time when I personally became convinced, I would say was it was after the Dolphin-Redskin game. It's the best I can put the correct time.
I'm sorry, I didn't understand. After what?
I said I hope it didn't sound humorous, but if I would place the exact time, I don't keep records of times or money. I would place it just about right after the Dolphins took the Redskins.
After the Dolphins and the Redskins game. Do you remember the score, Mr. Barker?
17 straight. Beat that.
Mr. Barker, what part did you play in the break-in of the Watergate complex and the Democratic National Headquarters on June 17th? What was your assignment or your responsibility?
My assignment and responsibility were, my principal assignment was location of documents. I entered as a unit with Mr. Martinez, who was the photographer. The first unit was Mr. Sturgis and Mr. Gonzalez. They were the entry and guard unit, and later on became guard unit. I followed with Mr. Martinez, and I understand that Mr. McCord followed later. In our entry, I dedicated my time to searching for these documents, passing them to Mr. Martinez. When Mr. McCord had finished and the time was over, we left.
Did you participate in the taping of the doors?
Never, neither in either one of the two trips.
Do you know who did tape the doors?
On the first or on the second?
Both.
Well, they were different on both.
Well, tell us, if you would, who taped the doors on what occasion?
On the first occasion, the entry team was supposed to tape the doors. Mr. Sturgis would be the person to tape the doors. I would enter with Mr. Martinez and leave the doors taped. Mr. McCord would be the last person in, and he would remove the tapes.
Did he remove the tape?
In the first one, I assumed. I don't know. On the second operation, it was handled differently. First, Mr. McCord went in and entered by, I don't know what means, and then he taped the doors.
Well, after everyone was inside, did someone then remove the tape as they did on the first occasion?
No. First, he went in and taped the doors. Then when we went to, this would facilitate the entry. Then when we went to enter, the tapes had been removed. Then we went into a conference to analyze this at the time. Mr. McCord was the opinion that this was just the mailman who had...
Was a mailman who had taken the tape off?
Who had taken it off. This was his opinion at the time. He stated
How many doors were taped?
We're talking about the basement entry door.
And what time in the morning?
At night.
But it was in the early morning hours, 1:57 in the morning of June 17th. And Mr. McCord said that he thought it was a mailman who
According
took
to
the tape
Mr.
off?
According to Mr. McCord, there was a stack of mail that had been brought down.
Was it Mr. McCord who urged you to go ahead, notwithstanding that obviously someone had discovered the tape doors?
Mr. McCord was of this opinion. I am just stating what his opinion was at the time. Then we proceeded to go back to where Mr. Hunt and Mr. Liddy were, and they were the information was given to them, and then after a while I was told to proceed. So I went down and I ordered the entry team to go ahead and enter.
Were you apprehensive, knowing that the doors had been taped and some unknown person not of your group had removed the tape? Were you apprehensive about continuing with the project?
I was against entry at that time, and to the best of my recollection, so was Mr. Hunt, my superior.
Well, who prevailed?
I have no, apparently somebody prevailed. I have no knowledge. This was not my decision.
But someone decided to go forward with the operation, notwithstanding that the tape had been removed, and you did not think that a wise decision?
That is generally correct.
Do you take any comfort in the fact that your judgment has now been exonerated?
Sir, I follow orders in that sense.
Thank you, Mr.
I am
Barker.
disciplined.
Thank you.
Then the team proceeded. To the best of my knowledge, Mr. Sturgis, after entry, taped the doors. I went in. There was some problem in the entry upstairs, so that, different from the last operation, we joined the entry team that had not been able to open the last door. After a while, Mr. McCord came. To the best of my recollection, Mr. Martinez asked him if he had taken off the tapes, and Mr. McCord replied yes. And after a while from there...
You mean Mr. McCord, this is the second entry?
That is correct.
And Mr. McCord said that he had removed the tape?
To the best of my recollection, this was his answer to Mr. Martinez, yes.
And this was after the doors had been taped?
The second
you
time.
Oh, I see, the second time. I'm
that
sorry.
That is correct.
Mr. McCord indicated on the second time that he had removed the tape. Did you learn later that that was not true?
I don't know.
Well, isn't it so that the police discovered the doors still taped?
All I can say is the facts as I remember it. I can't make no assumption on anything else.
Thank you, sir. That's all I have.
Mr. Barker, you're an American citizen, are you not?
I beg pardon?
You're an American citizen, are you not?
I was an American citizen originally by birth. Yes.
And you never had any other citizenship except American citizenship?
No. At one time I was citizenless.
One time what?
I was citizenless.
How did that happen?
At the time, I joined the Cuban Police Department in cooperation with Mr. Spears of the Federal Bureau of Investigation, who at the time was legal attaché at the embassy in Havana. This was before CIA. Then some problem came up of a group of Cubans, of which I was in charge, in the Cuban Police Department, in cooperation with the Federal Bureau of Investigation. I remember at that time Agents Anderson and Garcia, with whom I worked in cooperation with at that time. Then this was denounced to the embassy, and one day I found out that my American citizenship had been taken away from me. At that time, an attorney, a Cuban attorney that represented the Department of Justice in Cuba, Dr. Mario Lazo, took the case up as a matter of personal hardship, and Bennett Williams, attorney Mario Lazo, L-A-Z-O. Through Mr. Lazo, I came to the United States and saw the firm of Bennett Williams, and they put a bill in Congress for my relief. I never followed it up at that time because I couldn't afford to be coming back to the United States. At that time I was younger, I didn't have the money for this. Then I found myself in a position of being citizenless, which I was for some time, and then I became an American citizen again. But I have never been anything but an American citizen.
How long did you live in Cuba before you came to this country?
I was born in Cuba and registered in the American Embassy as a citizen by birth of American parents. Half of my lifetime was spent in Cuba, and half of my lifetime was spent in the United States.
When did you leave Cuba?
I remember going to grammar school in New Rochelle, New York, then going back to Cuba, then coming back here. I graduated from Farmingdale High School. I worked for Bethlehem Steel after graduation. I went back to Cuba, to the University of Havana, then I joined the Army Air Force. Half of my lifetime has been spent in Cuba, and half of it in the United States. Cuba, to me, is my second country.
How long had you been in this country before you joined the Air Force?
I was the first volunteer into the Second World War from Cuba. First American volunteer at the Second World War.
You signed up from Cuba and not from this country?
At the American Embassy in Cuba on Monday after Pearl Harbor.
And then after you were discharged from the Air Force, where did you locate?
I went back to live to Cuba.
And left there with the advent of the Castro assumption of power?
I stayed there, living there, until Mr. Castro took over the country. Then I had to leave Cuba.
And you went in the real estate business in Florida after you left Cuba?
After I came to the United States, eventually, after the Bay of Pigs invasion, I went to Chicago, where I worked for Zenith, a Zenith subsidiary, the Rowland Corporation.
Worked for who?
A Zenith subsidiary. And then I went back to Miami, and then I got a job as an assistant manager in G.C. Murphy stores. And there I studied at night until I got my real estate license. Then I became a salesman for E. Valador Realtor and another realtor, E. Valador. And then I became a broker and a realtor and opened my own office. At the time that Mr. Hunt returned, 10 years to the day of the Bay of Pigs invasion, I returned home and found a note and says, "If you are the same Barker I once knew, contact me." And it was Mr. Hunt. By that time, I had my own office, new business starting with 10 salesmen, and I was had part of 3 condominium buildings, which amounted to total sales. Those 3 buildings amounted to a total sale close to $3 million.
And Mr. Hunt recruited you for the Bay of Pigs?
That is.
You operate?
No, for the Bay of Pigs?
Yes.
No. I worked inside of Cuba.
Inside Cuba?
First.
How did you get involved in the Bay of Pigs operation?
The same way I got involved in the Ellsberg. I considered it my duty to help my country.
Mr. Hunt recruited
in Cuba? No.
Who recruited you?
At the American Embassy.
Now, did you ever work for the CIA at any other time except when you were with Mr. Hunt in the Bay of Pigs operation?
Not to my knowledge.
Not to your knowledge. Now, I believe you you were involved in the Ellsberg break-in in California.
That is correct, sir.
Have you pled guilty to that, and have you been sentenced?
No, that trial has not. That trial's in the future.
Trial has not been held.
That I know. No, sir. No.
Now, how many times did you attempt to break into the Democratic National Committee before you succeeded?
To the best of my recollection, there was 4 tries, 2 of which were successful.
2 were successful. The last one when you were arrested. First one, I believe, was over the Memorial Day weekend last year. And 2 previous attempts that were unsuccessful.
That is correct.
How did they happen to prove unsuccessful?
One was we had a banquet, and to the best of my knowledge, someone was staying late at the Democratic headquarters, and the mission was aborted.
In other words, it was occupied and aborted the first time. What about the second time?
The second time, an entry was tried on just walking into the building on the excuse we were going to another floor. It didn't work. We left.
Were there any other instances except 4 times you attempted to break in Democratic National Committee headquarters, 2 of which were successful, and the Ellsberg psychiatrist that you were involved in a break-in?
We had plans to enter McGovern's headquarters, but they were never actually attempted.
That was aborted also?
Yes.
Now, isn't it true that some lawyers showed up immediately after you went to the jail following the break-in in the Democratic National Headquarters?
That is correct.
And you did not send for them? Any other members of your break-in group?
That is correct.
Do you have any idea how those lawyers were alerted and came down to attempt to aid you?
I have no idea.
Were you surprised that they showed up?
No.
You anticipated that they would?
Yes.
How did you anticipate that if you had no previous knowledge they would?
On the philosophy that if you are caught by the enemy, every effort will be made to rescue you.
Who did you think would attempt to rescue you?
Whoever my backers were.
Did you know who your backers were?
No. I had no knowledge of anyone by first name other than Mr. Hunt, who I had known in a previous operation, but I dealt with in this operation as Eduardo. And Mr. Gordon Liddy, who I only knew as George Leonard.
Who did you think your backers were?
Sir, I wasn't there to think.
You wouldn't?
I was there to follow orders, not to think.
You wouldn't wonder who was giving you the orders?
I beg your pardon?
Didn't you wonder who was giving you the orders?
No, I had absolute confidence then, as I do now, in the people I was dealing with, sir.
Well, you knew you weren't working for Castro, didn't you?
That I do know.
But who did you think you were working for?
I was working for Mr. Hunt and those things that Mr. Hunt represents.
What did he represent?
Eduardo represents the liberation of Cuba, the anti-communist symbol. It represents the government of the United States in one form, in its covert form.
How did you think you could liberate Cuba by participating in a burglary in Washington, D.C.?
If we helped Mr. Hunt and this government in matters which I will further add I believed in, it would establish a situation in which, besides the right that the Cuban people have to be free and independent, it would establish us as having aided this government in this mission. I view that in the same way where hundreds of Cubans have been helping in Africa, in Vietnam, and in other areas of the world where the people in my particular association are extremely grateful to those sectors of this country who favor our liberation. Mr. Hunt represented this in the greatest degree.
Now, Mr. Sturgis was with you as a guard in this break-in operation, was he not?
Mr. Sturgis at that time had a mission of lookout and guard, an internal guard. That is correct.
You know where he got his CIA identification papers that he had on him?
The CIA identifications that Mr. Sturgis had was that of Edward J. Hamilton. This identification I was completely familiar with. It is the same identification that E. Howard Hunt, my superior in the Bay of Pigs, used at that time.
In other words, he got them from Hunt, and that was the identification papers he had in the Bay of Pigs. Is that correct?
That is correct.
Now, do you know what the source of the funds was that Mrs. Hunt gave you?
I do not.
Did she give you $100 bills like she gave everyone else?
I don't exactly remember the denomination of the money that Mrs. Hunt gave me, but I assume that it did include $100 bills, yes.
Did you ever wonder what the source of that money was?
No, it was, I didn't have to wonder the source of that money.
You made no inquiry as to where it was coming from?
No, sir, I did not.
You had no thoughts about the wisdom of passing around $100 bills without knowing what the source was?
This money was given to me to pay attorney fees for expenses and for bonds money. As I have explained before, this seemed natural to me at that time.
Now, is it true that both your daughter and your attorney urged you to plead not guilty?
Mr. Rothblatt was completely opposed to my plea of guilty. I respect him because this was his conviction. I don't see why my daughter has to be brought into this matter, but my daughter coincided with Mr. Rothblatt that I should not plead guilty. My daughter has her own mind. This was one of the things that weighed on my personal decision to a certain extent. But neither Rothblatt or my daughter or my wife or anyone or Mr. Hunt or any offer of any kind made any dent on my decision. This was my decision and no one else's, sir.
Did Mr. Hunt ever talk with you about whether you ought to plead guilty or not?
Mr. Hunt never told me what his opinion, even his opinion, was that I should plead.
He never suggested one way or another, is that
Never
right?
suggested one way or another.
But
Mr.
your
Hunt
lawyer-
only told me what his position was, and never even hinted what my position should be.
He told you he would plead guilty, did he?
That is correct.
And your daughter and your lawyer both urged you not to plead guilty.
That is correct.
My time has expired. I yield, Mr. Chairman.
Mr. Barker, I wonder if we could...
We are hearing from the second of the 5 men who were caught inside Democratic headquarters. Miami realtor Bernard Barker said he actually took part in 4 attempts to get into the party headquarters, but only 2 were successful. Barker said he also took part in the break-in at the offices of Daniel Ellsberg, psychiatrist in California, and he was told it was all a matter of national security. In a moment, he will add even more details to his clandestine activities when Impact's coverage of the Watergate hearings continues after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
As the hearings resume, convicted Watergate burglar Bernard Barker is being questioned by Senator Gurney.
Begin at the very beginning of this Watergate affair, or the beginning of your contact with Mr. Hunt. When and how did he contact you?
On April the 17th, 1971, exactly 10 years after the Bay of Pigs. This is the day they commemorate the Bay of Pigs in Miami. There was, I think it was the day before, when I arrived home, there was a note on my door. The note said, "If you are the same Barker I once knew."
A note pinned to your door, was that it?
That is correct.
Door where?
In my home, sir.
And it said again what?
"If you are the same Barker I once knew, contact me at such and such hotel."
And signed by anybody?
Howard.
Now what did you do?
I immediately contacted him.
Where?
I don't remember the name of hotel. It could have been Trade Wind. I know it was in Miami Beach. I'm not too familiar with Miami Beach. Close to, could be 135th Street area.
Well, how did you know the name of the hotel?
It stated it in the note where I could contact me. I'll contact him.
It gave the name of the hotel in the note?
Yes.
You contacted him by phone?
Yes, originally by phone, and then I immediately drove over there in person.
Well, give an account first of the phone conversation.
Greetings, and how are you, and so forth. And be nice to see you again. Well, I'm a lot older and a lot fatter, and stuff like that.
Well, did he invite you to come over to the hotel?
Yes, sir.
And did he give any reason why?
No, sir.
And then you went to the hotel and met him?
That is correct.
In his room?
I don't recollect. I think Mr. and Mrs. Hunt met me downstairs.
And what transpired? What conversations did you have?
Old times.
Well, I'm talking now specifically about what he wanted you to do, of course.
At that time, nothing. It was just, he was there to go back to the 10 years after the Bay of Pigs. He would be present incognito at the celebration that was to take place. I beg your pardon? Incognito at the Bay of Pigs. Would I go with him? I said I would like to.
Why didn't he want to be known?
I don't know. The nature of the operation at that time, Mr. Hunt was only known to very few persons in Miami. And we did go to this meeting. We did speak to 2 or 3 persons that were in the old Consejo Revolucionario de Cuba, Dr. Maceo, several other people. The Cuban Revolutionary Council in Spanish. I'm sorry.
So
then,
this would... Go on, excuse me.
Mr. Martinez joined us. I presented him as Eduardo, and he immediately recognized who Eduardo was, although I don't think Mr. Martinez had met him previously. Then Mrs. Barker, myself, Mr. and Mrs. Hunt, and Mr. Martinez went to lunch in a red Cuban restaurant. Nothing was spoken at that time except...
This was just a visit about old times?
Yes, sir.
Well, now, when did he contact you next?
We kept in contact after that without anything special being brought up. I, quite frankly, waited until Mr. Hunt would tell me if there was any other reason other than social reason. In the hierarchy, remember that he was my boss. I expected him to, in his good time, to tell me if there was anything else. And eventually he did.
And when did that take place?
I would say it was approximately, I would say to the best of my recollection, 2 weeks before the Ellsberg surreptitious entry.
And what did he tell you?
As I have said before, I think, would I be willing to help him on a matter of national security?
Now, was this by a phone call?
No, personally. He went down to Miami personally. And then after, I would repeat what I said before.
I don't know that we need to go through that.
No. And then he said that I should recruit 2 persons for this operation. And then I said I would, and he left. And then I proceeded to sound out 2 persons, and both of them accepted. The 2 persons that I had sounded out were Mr. Martinez and Mr. De Diego. I selected them too for their qualifications, not that they were salesmen in my organization. Mr. Martinez had in his record over 300 infiltrations into Castro Communist Cuba, including the obtaining of hard evidence during the missile crisis. I thought he was perfectly justified for a mission of this nature. I consider him one of the greatest heroes of that time. Mr. De Diego had been a member of Operation 40, which had been specially trained to capture documents of the Castro government if the operation was successful. He had received further training as an intelligence officer in the Army of the United States. He also, in my concept, was perfectly qualified for a mission of this nature. I submitted their names and records to Mr. Hunt over the phone, long-distance phone. And sometime after that, I don't remember, he called me and said that the 2 men had been cleared for the mission.
Did he say who and how they were cleared?
No, he did not.
And then go on about the mission and be as brief as possible because I want to get to Watergate.
Mr. Hunt then called me one day and said to proceed with my men to Los Angeles and to stay at the, I think it was the Beverly Hilton Hotel, where he would contact me. I bought the tickets, alerted the men, and we took off and went to Los Angeles. I registered in the hotel, and Mr. Hunt contacted me. He gave me a brief, he gave me the address of the place where we were to make the entry. The following day I went with my men, familiarized myself with the area. I had the exact address at that time. Then a general plan was given to us. We proceeded to the area and eventually made the entry. I personally searched for those documents.
What documents?
A file of Daniel Ellsberg at his psychiatrist's office. This file was not there. I would distinguish file from file cabinet. I searched his desk and his file cabinet. The men also helped me in the search. The only thing that I found in connection with him was an address book which had his name. This we photographed. We also photographed the file cabinet to prove that which had been forced open. And then we left.
Now then, let's get to Watergate. When and where did Mr. Hunt contact you about Watergate?
I don't remember whether, I believe it was in one of the trips down to Miami that he told me that of an impending operation, double operation, which would take in length about a week. When we
Did you say double operation?
I beg your pardon?
Did you say double operation?
That is correct.
What does that mean?
At that time I didn't know, but I knew the time it would involve. After that, it was quite evident it was an entry into the McGovern's headquarters as well as an entry into the Watergate headquarters.
But tell us now very carefully what his instructions were.
I would like to explain that Mr. Hunt was our immediate superior in this operation, that we were involved only in the documents that we were to obtain. We have no connection with the electronic part. It is to the best of my recollection that the electronic part was not even under the direction of Mr. Hunt, much less of myself. Mr. McCord appeared to be quite capable of that. He handled that. I had no knowledge of what bugging he was going to do. All that my mission, that our team mission was the documents to which I have referred. And this was explained to me by Mr. Hunt at that time.
But that's what I want to know. I mean, now, he went to Miami, as I understand it, and he got in touch with you, and he must have said, Bernard, I have another mission for you.
That is correct.
Well, what did he say? What was the mission?
No, he said it was a double mission, and he would explain to me when we got there. He gave me general information as saying, get your men in training to going up and down stairs. They must be in good physical condition. This I passed on to my men. I think he mentioned it involved surreptitious entry similar to one that we had done in California. But he didn't say anything else specifically to me at that time, nor did he have to give me any further explanation.
Did he say to you it was going to be the National Democrat headquarters?
No, he did not, sir.
Did he say to you it was going to be Senator McGovern's campaign headquarters?
No, he did not, sir.
Now then, at some point in time, you went to Washington, is that right?
That is correct.
Tell us about that.
I arrived with my team in Washington. They went to the Hamilton Hotel. I met with Mr. Hunt at his company. I think it was the Marlin J company. And there was when Mr. Hunt gave me the general description of our double mission. And I then had the mission. Then this I did not communicate to the men until just about entry time.
Now, did he tell you at that time it was the Democrat National Headquarters and Senator McGovern's headquarters?
To the best of my recollection, this was the time when he said this to me.
And
previous to this, the only information I had is that we were going to have some kind of a banquet at the Watergate.
A banquet?
Yes. And we did have that banquet at the Watergate. Then, at that time, it was explained to me that the banquet in itself was a cover for the entry.
Well, did he tell you at that time what documents you were going to look for?
That is correct.
And what did he say?
He said to look for any documents involving contributors, both foreign and national. If I had any doubts as to the documents, I could contact him over our communicators.
Now, the first and second entries, of course, were unsuccessful. A third entry was. And what documents did you photograph then?
It was quite evident when I searched the documents that this was not the right place for the type of documents that we were searching.
Where did you think was the right place?
I didn't think which was the right place. I just analyzed from the type of documents that I found in the files of the offices that were available to me that it would be very doubtful that these would be the documents we were searching. So what I did was I took only documents where names of persons were involved, where there might be notations of numbers, and I also came across one document that involved the security of the Miami Convention, and I considered that this document would also be was welcome, so I also photographed that document.
Just one or two other questions because my time has expired here, but I do want to complete this reason why you went in there. Now, on the last and fourth attempt, why did you go there again if you realized that the documents you were looking for were not there? Didn't it occur to you at this time that perhaps you were doing something that was political rather than national security-wise?
It was then evident that we were not in the office of the chairman. In our second entry, we finally came to the office of the chairman of the Democratic National Convention. I believed, honestly, that there we might find the type of information that we were searching.
And then that's when you were discovered.
That is correct.
I have further questions, Mr. Chairman, but I've used my time up.
Mr. Barker, you have testified that you were recruited by an FBI agent to work for the police department in the government of Fulgencio Batista. Is that correct?
No, sir. It was during the government of Dr. Carlos Brio Socarrás, who was the last constitutional president of Cuba.
What was your function in the police department?
I entered the police department with a group of veterans returning from the Second World War. My mission was mostly a liaison mission of nature. I worked with the Treasury Department in cooperation with the Treasury Department on drugs and on a kidnapping case, on an postal case.
Was it covert-type operations?
No, I was a regular member of the Cuban police force. Some of them were covert. I also escorted VIPs, included a visit of Mrs. Truman and Margaret Truman. Then I did regular police work in the Cuban police department.
Mr. Barker, you have testified that you're very familiar with CIA discipline and procedure, and that you have applied this discipline and procedure in all of your covert activities. Is that correct, sir?
This experience was much later after this had nothing to do with my time in the Cuban police department.
I'm talking about the Bay of Pigs and later, sir.
That is correct, sir.
You're aware of the CIA procedure and discipline? In fact,
yes, those were the methods that we utilized in this operation, yes, sir.
And so you were under the impression that this was a CIA operation and was carried out in behalf of the government of the United States?
I don't know the real answer to that question.
Do you think this was a private job of Mr. Hunt?
No, sir. Mr. Hunt...
You've testified, it's on record, that you felt that this was a CIA operation and that you were working for the government.
I have not testified that I felt it was, that it could or could not be a CIA operation, that CIA was under national security.
Didn't you testify that you were not surprised when expenses for your family were provided and when lawyers appeared?
I have testified, I believe then and I believe now, that...
Because this was part of the CIA procedure?
That this is part of the same procedure, not necessarily that this was a CIA. I surmise that if it was national security or any other organization of the covert type, that the same rules would apply.
And under the CIA procedure, you are sure that everything will be done to rescue you?
That is correct.
And so when the lawyers appeared, you weren't a bit surprised?
No, frankly, I was not surprised, no.
Was clemency part of the rescue?
No, sir. This clemency, the word clemency was unnecessary and had no application in our case whatsoever.
You mean you were told as a CIA undercover operative that once you were captured, you were forgotten?
No, if your families are taken care of, you're not forgotten, and if attorneys are supplied and bail bond money, this is not being forgotten.
And every effort would be made to get you out?
That is correct, yes.
Did that include executive clemency?
I don't see why that should include executive clemency, no.
As part of your discipline, you've indicated that you never asked questions, you just followed orders. I'm quoting you.
Yes, in the spirit of how we worked. Compartmentation means that you do not speak of these matters with each other. You work on a need-to-know basis. If I do not need to know certain information as to who is above Mr. Hunt, I do not only do not need to know, I do not want to know.
So if your leader...
If something goes wrong, I can't be suspected of this. If they would have told me who was above them, I would have not had the confidence I am supposed to have in these people. This would be unnecessary information in the compliance of a mission. This is the way also that the underground worked, and that this was common to us. This is the way it should be.
Under this discipline, if a leader told you something, you would never question him.
Within reason.
He did not have to direct you. He could have suggested something, and you took that as an order.
In an operation?
Yes.
That would be correct.
So if Mr. Hunt suggested that you plead guilty, this was an order?
This was not an operation. Pleading guilty was not an operation. Pleading guilty was something that I decided and not Mr. Hunt.
I thought you said that Mr. Hunt had come to you and said that he was going to plead guilty because they caught us with the goods?
Because of the overwhelming evidence that there was against all of us. And may I further observe that, in my modest way of thinking, if this was Mr. Hunt's plea and he had not been caught inside of the Watergate, it seemed to me intelligent. It seemed to me at that time that this was an intelligent decision for me to take. But it does not necessarily indicate that he told me what to do or what not to do in that matter. This was my own decision, sir.
And an important part of the discipline and procedure of covert operators would be silence. Isn't that what you told us?
Would be what, sir?
Silence.
That is correct, yes.
Much more important than any other discipline.
To a certain extent, yes, I would say so. Silence was part of the very nature of a covert operation.
And the
when you're captured by the enemy, you don't talk. Perhaps, sir, that if I explained the nature of the men that work with me, I could better explain that.
May we come to that later,
yes,
sir? The second most important discipline would be not to squeal on your fellow operatives. Would that be correct?
I don't think that the word squeal is applicable to a paramilitary operation.
Not to implicate.
I consider that as more as a criminal.
Let's use a better word, not to implicate.
Yes, but this is not the case, because to implicate someone, sir, you have to know who these people are. The very discipline under I worked, this was not necessary. I did not know.
Would you, under the code of ethics or code of conduct or code of discipline, implicate members of your team?
No.
And you looked upon Mr. Hunt as a great man. You respected him highly.
Yes.
One of the key leaders in the Cuban liberation movement.
That is correct.
And would I be correct to assume that under those circumstances you would never implicate Mr. Hunt and you would forever keep silent?
This is a hypothetical question.
Oh, it's not a hypothetical question. I'm asking
In this
you.
particular case, the answer, sir, respectfully, is negative, because this was no need to implicate him. Mr. Hunt was pleading guilty by his own thinking. I was pleading guilty because it was proven correct. The events that took place after that proved that I was correct in my decision, sir.
But you're a wise man. You know that if Mr. Hunt did, in fact, tell you to keep silent, he would be guilty of the crime of obstructing justice?
Pardon me if I smiled, Senator. If I was a wise man, I wouldn't probably be sitting right here. I hope this carries no disrespect, sir. Sincerely, I mean none.
Well, I'm not trying to be disrespectful to you, sir. But you've also testified, and I quote you directly, sir, that you had, quote, personnel available for this type of operation, end quote.
Yes, sir. I had personnel available for this.
In other words, you're in this covert business?
Not for the past 10 years.
And how do you have this personnel available all this time in the 10 years?
Sure. I was Eduardo's practically executive arm in the Bay of Pigs invasion. I was his principal assistant, whether I want to or not. I am a bilingual American, Cuban, who is dedicated to the cause of the liberation of Cuba. I have not changed my mentality since that time. I had no need to give any explanation to any of the old teams in Cuba as to what my position was when I called them on these matters. Not because I am a leader, which I am not, but because I was part of Mr. Hunt's image.
Would you, under the discipline that you have followed, say anything or do anything that would injure the government of the United States?
Although in this case that is not applicable because I had no information, I would state that I would never commit an act of that nature.
And you've also said that you will not help the enemy, whoever that enemy is.
Yes, in general statement, yes, I think I would say that is correct, sir.
I ask this hopefully in good graces. Do you consider us your enemy, this committee here?
Sir, of the team that entered the Watergate, Mr. Gonzalez and I are Republicans. Mr. Sturgis and Mr. Martinez are Democrats. I do not consider anyone here an enemy of this country, no more than I consider Mr. Martinez or Mr. Sturgis my enemies because they are Democrats.
Did you consider Mr. McGovern and Mr. Muskie your enemy?
I have the greatest respect for Mr. McGovern as a senator and as a presidential candidate. I disagree personally with the type of philosophy that I saw in a similar circumstance turn Cuba into a communist state.
However, you are willing to place Mr. McGovern in jeopardy, didn't you? To injure him.
If we were successful in obtaining documents that implicated a foreign government of Cuba in the operation, if this hurt Mr. McGovern, it would be the nature of the evidence, not I. Mr. McGovern, to me, is as impersonal in that aspect as it would be when I was a bombardier in the Second World War in Germany and bombed a town. I have nothing. I don't know Mr. McGovern personally or any of these people. There is no personal grudge in any way, as I interpret it.
He is not your enemy.
No, the man is
my final question, sir. In the testimony you have presented to us this afternoon, have you attempted to protect Mr. Hunt?
I have attempted to protect no one in that respect. I wouldn't have to protect Mr. Hunt, sir. I don't understand the question. If by this I meant, if by this you mean, I would like to be clear that if I am saying that Mr. Hunt asked me to plead guilty, and I say that he didn't, if by this is what I am being asked, I am saying that Mr. Hunt never asked me this. I would not have to protect him this. I am merely stating the truth.
Did Mr. Hunt ever tell you to remain silent?
No, sir. Not in relation to anything concerning the Watergate.
Isn't this part of the discipline of your organization?
To remain silent on matters regarding operation and so forth? Yes, this is part of the discipline.
In other words, you were supposed to give name, rank, and serial number. False name, that is.
Yes, sir. That would cover it. False names in the sense that when you do a covert operation, it is part of the system not to do it under your own name.
Thank you very much, sir.
Yes, sir.
Mr. Barker, just a very few questions. In the course of the Watergate operation, did you have in your possession a walkie-talkie?
That is correct.
Were you in communication with anybody over that walkie-talkie?
Yes, I was.
Can you identify who it was that you were in communication with?
One station was ours, one was Mr. Hunt's, and the other one was some headquarters.
So actually, there was you, there was Mr. Hunt with another walkie-talkie and a third station. Is that correct?
That is correct.
Can you identify the third station?
I cannot.
All right. Now, just two last questions. Do you look upon your present jailing as an honor?
I would like to say that I don't consider my being in jail for this matter or anything else that I have done a dishonor.
And the last question, Mr. Barker. You say that in 1972 you were doing these things in the name of national security. Is that correct?
This is the way it was originally given to me.
And you say that in 1972 you justified these acts in the name of national security.
I don't understand what you mean by justifying these acts. This original situation was never changed. I had no reason to think one way or another on that matter. This was never discussed.
Well, now, Mr. Barker, it's 1973. Do you still feel that national security is a proper justification for Watergate?
I feel it was a proper justification for Ellsberg. And although not in the same degree, I feel it was a justification for Watergate. But quite frankly, I am just a human being. I get confused about all these things too. I just, sometimes, I don't know the answer to these questions. I don't pretend to have all the answers, sir.
Thank you, Mr. Barker.
Thank you, Mr. Chairman. Mr. Barker, how long had it been since you had been in touch with Mr. Hunt prior to the time that he went down to Florida and left you a note?
I beg your pardon, sir. I can't see your face. And
how long had it been since you had seen Mr. Hunt or communicated with him prior to the time that he went to Florida and left you a note?
In the 10 years that passed between the Bay of Pigs invasion and the time that I had this note, I had occasional communications by mail from Mr. Hunt, mostly from Spain. These were all of a personal nature.
And since that first visit to Miami, how many times did he go back to Florida to visit with you?
Could have been anywhere between I would say a dozen times at least in Miami, or perhaps maybe between 1 dozen, between 10 and 20, 12 or 24.
All right. Now, did you, during any of those visits, discuss the probability of going into the Democratic National Committee headquarters or the McGovern headquarters or anywhere else other than the Ellsberg psychiatrist's office?
I don't recall that in any visit in Miami, Mr. Hunt discussed with me either the McGovern or the Democratic headquarters. To the best of my recollection, Senator, this took place in Washington.
All right, then why, when he invited you to lunch, did you take Martinez with you and Rediego? You mentioned a luncheon that you had.
In April of 1971, when I went with Mr. Hunt to the area where they were commemorating the Bay of Pigs invasion, they had a statue down there that they were unveiling. Mr. Martinez at the time was with me as salesman in my organization. He had been in the Bay of Pigs invasion, played a very prominent part in the naval activities. I presented him to Mr. Hunt at that time.
And
to Eduardo at that time.
What about Mr. Rediego?
No, Mr. De Diego was not at that. I don't remember presenting Mr. De Diego to Mr. Hunt. I don't even know if Mr. De Diego.
You mentioned him as one of the people who was at lunch.
No, Mr. Martinez was at lunch.
All right, who was the other one?
Mr. and Mrs. Hunt, my wife, and Mr. Martinez.
All right. Now, when did you go to Mr. Martinez and Mr. Rediego and recruit them for the Washington operation?
Mr. Martinez and Mr. De Diego were originally recruited for the Ellsberg operation. Subsequently, they participated in the Hoover security operation, and they were brought up with me for the double operation over the weekend of the Memorial Day weekend.
Now, I believe you mentioned that up to that time, Mr. Hunt had not paid you any money.
That Mr. Hunt never paid me any money.
Well,
nor was I ever hired, nor any of my Cubans were ever hired or paid money in that sense of the word.
How did you pay for your expenses, and how did the other individuals who came in from Florida pay their expenses, and how were the expenses paid when they went to California?
In some cases, I received money before an operation to pay for these expenses. In other cases, I arranged for the tickets for the trip out of my American Express card.
Well, I'm speaking of this trip. Did you receive any expenses for the two people who went to California, or any expenses for them and for yourself to come to Washington?
Well, like I said, in the California operation, to the best of my recollection, these expenses were covered after we got to California, and a part of it was sent by mail to me in Miami. This differs from other operations. I believe that, to the best of my recollection, in the Washington operation, I had been giving an amount of money previously by Mr. Hunt, and I went with Mr. Martinez to some agency and took out the tickets before. But
how much were you given by Mr. Hunt?
I don't remember what I was given for at that time. I imagine it covered a certain amount of expenses. I have no...
Was that before the California trip?
No, in the California trip I was not advanced any money. To the best of my recollection, all I did was buy the tickets out of my American Express, and then I was refunded.
Did you buy the tickets for Mr. Martinez and Radiego and the other people who came in from Miami to Washington with your American Express card?
No, I don't believe so.
Who paid their expenses?
These expenses came out of the operational money, the accounting of which I would do with Mr. Hunt at the time. Senator, I would like to explain to you that, and to the people who may believe that this seems strange, when you are doing a covert operation, a budget or expenses are cleared up at one particular time. They are taken care of, and then they are forgotten about that. You don't speak about that again. You don't remember them. You don't specify them, except that at that time you give an accounting. To try to remember the exact detail after 2 years, which was the operation where the money was given before that or later, I cannot recall that, sir.
The question I'm asking you is, did Mr. Hunt give you any money for yourself or for these other people prior to going to California or prior to coming to Washington, D.C.?
In the case of California, to the best of my recollection, I was given no money prior. In the case of the trip to Washington, I believe that a certain amount of money, that I do not remember what amount, was given to me, because in those particular cases when we came to Washington, there's so many, it was a larger number of people involved, and I don't remember.
Now, did Mr. Hunt tell you who he was working for at the time?
Yes. At the time, Mr. Hunt was a counselor at the White House. On one occasion, I remember that I had met Mr. Hunt at the executive building and went home to lunch with him.
And he mentioned the internal security aspects of the Ellsberg case, and it was with that motivation that you got into that. Now, what did he mention to you about the Democratic National Committee headquarters and the McGovern headquarters, other than the simple objective of going in there to find out what foreign governments had made contributions to either the Democratic National Committee or to Mr. McGovern?
To the best of my recollection, Senator, the motivation aspect was never discussed after that first.
Well, didn't he mention to you that the reason that he wanted to go into the Democratic National...
For the tickets for the trip out of my American Express card.
Well, I'm speaking of this trip. Did you receive any expenses for the two people who went to California, or any expenses for them and for yourself to come to Washington?
Well, like I said, in the California operation, to the best of my recollection, these expenses were covered after we got to California, and a part of it was sent by mail to me in Miami. This differs from other operations. I believe that, to the best of my recollection, in the Washington operation, I had been giving an amount of money previously by Mr. Hunt, and I went with Mr. Martinez to some agency and took out the tickets before, but...
How much were you given by Mr. Hunt?
I don't remember what I was given for that time. I imagine it covered a certain amount of expenses. I have no...
Was that before the California trip?
No, in the California trip I was not advanced any money. To the best of my recollection, all I did was buy the tickets out of my American Express, and then I was refunded.
Did you buy the tickets for Mr. Martinez and Rodiego and the other people who came in from Miami to Washington with your American Express card?
No, I don't believe so.
Who paid their expenses?
These expenses came out of the operational money, the accounting of which I would do with Mr. Hunt at the time. Senator, I would like to explain to you that, and to the people who may believe that this seems strange, when you are doing a covert operation, a budget or expenses are cleared up at one particular time. They are taken care of, and then they are forgotten about that. You don't speak about that again. You don't remember them. You don't specify them, except that at that time you give an accounting. To try to remember the exact detail after 2 years, which was the operation where the money was given before that or later, I cannot recall that, sir.
The question I'm asking you is, did Mr. Hunt give you any money for yourself or for these other people prior to going to California or prior to coming to Washington, D.C.?
In the case of California, to the best of my recollection, I was given no money prior. In the case of the trip to Washington, I believe that a certain amount of money, that I do not remember what amount, was given to me, because in those particular cases when we came to Washington, there's so many, it was a larger number of people involved, and I don't remember.
Now, did Mr. Hunt tell you who he was working for at the time?
Yes. At the time, Mr. Hunt was a counselor at the White House. On one occasion, I remember that I had met Mr. Hunt at the executive building and went home to lunch with him.
And he mentioned the internal security aspects of the Ellsberg case, and it was with that motivation that you got into that. Now, what did he mention to you about the Democratic National Committee headquarters and the McGovern headquarters, other than the simple objective of going in there to find out what foreign governments had made contributions to either the Democratic National Committee or to Mr. McGovern?
To the best of my recollection, Senator, the motivation aspect was never discussed after that first.
Well, didn't he mention to you that the reason that he wanted to go into the Democratic National Committee was to find out whether or not some foreign governments had contributed to the Democratic Party?
That is correct. Yes, sir.
All right. And it was your assignment to look at the documents as you went in, and for Eugenio Martinez to follow as you gave him the documents with a little photography.
That is correct.
Now, you stated in response to Senator Baker's question that you found no evidence in those documents that you saw of any contributions to the McGovern campaign or to the Democratic National Committee from any foreign governments, and still you pursued the photography of the documents, did you not?
That is correct.
Why did you?
Because the documents that I that I read included names of persons, and in one particular case there was a series of notations that appeared to be money notations, and another document involved security
now,
of the convention.
Did it have the name of any foreign country?
No, sir.
Well, how did you connect it as being something very instrumental with respect to internal security?
I don't understand the question. documents that I photographed or had photographed were only photographed for the reasons that I believed at that time was the judgment as to what I had explained. I have stated that it was evident that the type of information that we were searching was not available at that particular office. So I just did the best I could under the circumstances.
Well, as a matter of fact, Mr. Barker, you went in there for the general purpose of political espionage and not internal security.
Sir,
isn't that right?
That is not my honest interpretation.
Well, in view of the subsequent events and the subsequent disclosures, would you agree with me now that it was, in fact, political espionage?
I would respectfully disagree with the senator.
Why do you? Now, give me your reasons.
Because if my motivation was that which I have stated, and it was, there's no reason now to change that motivation, sir.
All right, now, let us go into Mr. Hunt's employment at the White House.
Yes, sir.
Now, what led you to believe that because Mr. Hunt was working at the White House, that this was a covert operation under CIA?
This is stating that I thought this was a covert operation for CIA. I have never stated that this was a covert CIA operation. I have stated, sir, that it could or could not be a CIA operation since it was a national security matter. And the reason that I believe that Mr. Hunt had authority was first by association, my previous association with him as the highest government representative in the pay of pigs, and the fact that he was at this time a member of the staff at the White House. I had no reason to think anything else in this matter.
Well, were you ever told by Mr. Hunt that the CIA would provide technical equipment for the operation?
Mr. Hunt, during this operation, used equipment that was quite evident the same type used by the CIA. The documents that he had, the certain type of the equipment, he informed me at the time that was obtained from CIA sources. But this did not mean to me that he was a CIA man. This was explained in the fact that the National Security Organization was above CIA and FBI. To the best of my knowledge, I am not saying that this is true or not. I am just saying to what my thinking was in regarding to the things that were said to me.
Now, when you had a meeting with Mr. Hunt at the Hamilton Manger Hotel in Washington, D.C., preliminary to going over to the Watergate operation, did you at any time, when he mentioned the McGovern headquarters and the Democratic National Committee, ask him any specific questions as to what the entry into these two places would have with, what relevancy it would have with internal security?
No, I never asked him those questions.
Did you think about it? Did you speculate in your own mind about it?
At that time and place, I had no reason to speculate on these matters, and I see no reason to change this at that time. I have tried to explain to the best of my ability, Senator, how we conducted these operations, that in my concept they were as paramilitary operations as any previous operations I had been involved in. And it is not customary in a hierarchy to question your superior. You either do it or you don't.
How can going into a political party's offices be construed as a paramilitary operation? Now, by what stretch of the imagination do you reach that conclusion?
The paramilitary operation is the procedure that was used.
got put on today because we had to get him excused from testifying in the court in Connecticut, so we could get him. We tried
I just want
to
one final
try to
question,
finish.
Chairman. Now, is it still your opinion that what you did was in the interest of national security?
Today I am confused by all the information, but I see no reason to condemn the nature of the assignment as was given to me at that time.
Thank you, Mr. Chairman.
Your phone and my number is your area code in Miami 202?
No, it's here.
It's here. Let's see,
I think it's 302.
That's the number 4.
Yes, but he doesn't.
But 305.
Yes, he does.
I think it's 305, sir.
Did you make 1, 2, 3, 4, 5 calls to creep the phone here 202 area code 333 0360, the committee to re-elect the president officers? In April and May and June of 1972?
To the best of my recollection, I think I couldn't say definitive, but I think that yes, that those to the best of my recollection, those are phones that were included in that.
Now, every time that you broke into anything, your commanding officer, Mr. Hunt, stayed at a distance. So if anybody was caught in the break-in, he would not be one of them.
I didn't understand that quite.
Mr. Hunt arranged for the break-ins, and then when the time came for breaking in, he decided that discretion was the better part of valor, and he sent somebody else into danger and stayed away himself.
Senator Ervin, I have the highest concept, personal concept, of Mr. Hunt and of Mr. Liddy, sir. I say this with all respect to you and with the respect that I owe my superior.
But he stayed at a distance, didn't he?
Every
time. When you broke in the Watergate, every time, and when you broke in the psychiatrist's office, Mr. Hunt arranged for the breaking in, but he never endangered himself, never placed himself in a position where he'd get arrested in the break-in. Isn't that so?
Yes, sir, I guess in a way that is correct, yes,
Well,
sir.
I've always heard discretion is the better part of valor. Any other questions? Wait a minute. Now, you say that Mr. Hunt had not told you to keep silent. Had Mr. Hunt told you to keep silent, would you have kept silent and not told us about it?
Had Mr. Hunt told me to keep silent in what, sir?
If he had told you to keep silent, would you have kept silent and not told us that he told you to keep silent?
That is a very confusing statement, sir. But
okay. Any further questions? If not, the witness is excused. Thank you, Mr. Barker, for your testimony. He's excused. Wait. Did you have something further you want to say?
yes, sir. I think it is only fair, before I leave here, to say that in a certain way, the things that I have said do not represent me as a person. I am part of a team of men of whom I am very proud to have been associated with. Mainly, I am speaking of my 3 associates from Miami. I think I have given a general description of Mr. Martinez. It is only fair now to state that Mr. Frank Sturgis, who by birth was Frank Fiorini, is a devoted anti-communist fighter who has fought against dictatorship, not only of the left but of the right, that he was the first person to turn against Castro after helping him with his revolution, that he has made innumerable raids over Cuba, that he had been captured in a Honduras government, by the Honduras government trying to infiltrate Cuba, that Mr. Gonzalez was the member of the OA, Organización Auténtica, which, with an extensive background in the underground in Cuba, that all of these men are devoted family men who feel very deeply in a cause, and that I am not here as a person, but as a part of a team, and that it would be unfair, in my concept, that these men were considered in anything but in the true light which of the things that they believe in, that we all, outside of reprimands by, in some cases, of Mr. Fiorini for having acted in these matters, our greatest previous crime before the Watergate were just simple traffic violations, that we are not criminal elements, that the word, as a newspaper recently said, we are the world's best known burglars. The word burglar we'll have to live with. That we resent very emotionally the word that we were hired. That there was no need to buy our silence. We are not for sale. And that this must be said because this represents our feelings. By this I don't mean that we are perfect, that we're not full of all sorts of defectious persons, that we consider ourselves superior beings to anyone. We're just plain people that very deeply believe that Cuba has a right to be independent. Thank you.
Witnesses accused subject to be recalled later by the committee in case the committee sees fit to do so. Thank you very much, Mr. Barker.
That's the first round of testimony by Bernard L. Barker. As usual, the committee reserves the right to recall the witness. The next witness is Alfred C. Baldwin III, the former FBI agent who observed the Watergate break-in from a motel across the street. We'd like to thank those of you, more than 25,000, who've taken the trouble to write us to express your opinions on this kind of experimental coverage of these hearings. If any of you would still like to write us, and it will affect our decisions on whether to do this kind of coverage in the future, you can do so by dropping a note to NPACT, Box 300, Washington, D.C., 20044. Our coverage of the hearings will continue after we pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
The hearings continue with testimony from Alfred C. Baldwin III, who says he hoped that doing a good job on his intelligence operations might win him a permanent job in the White House.
Counsel, call the next witness.
Would Mr. Baldwin please take the witness table?
Mr. Baldwin, hold up your right hand. Do you swear that the evidence that you shall give to the Senate Select Committee on Presidential Campaign Activities shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Now, you are accompanied by an attorney. The attorney will please identify himself for the record, giving your name and your place, your office address.
I am Robert Gerald, practice law at 377 Main Street,
All right. Just for the record, Mr. Baldwin. Excuse me.
The last name is spelled M-I-R-T-O.
Just for the record, Mr. Baldwin, would you give your full name and address?
Yes, sir. It's Alfred C. Baldwin III, 90 Mountain View Terrace, North Haven, Connecticut. We use a mail address of Hamden, Connecticut, 06517.
Mr. Chairman, I have no questions, but I understand that the witness has a short statement to read, and then I would like to waive questions and move on. Would you read your statement, Mr. Baldwin?
Thank you. To make a part of the record my understanding of my status in this total affair, I wish to read the following memorandum into the record at this time. This memorandum was a memorandum prepared by my attorney, Robert Murdo. It's titled Memo to the File of Alfred C. Baldwin III. It's written on 7/6/72 at 4:40 a.m. On 7/5/72, Robert C. Murdo, Esquire, J. Terrence O'Grady, Esquire, attorneys known to the government to be representing Alfred C. Baldwin III, a suspect in the Watergate incident, met with Earl Silbert, Don Campbell, and Seymour Glanzer, all assistant United States attorneys, and represented to us to be the assistant United States attorney handling the Watergate incident. A meeting was held at the United States District Courthouse on the morning of 7/5/72, at which time it was represented to us by the government that Baldwin would not be a defendant in the Watergate matter if he cooperated. The government attorney stated that if they were satisfied with Baldwin's information, he would not be indicted. Negotiations ceased at 12:30 p.m. so that O'Grady and I could talk to Baldwin. At 5:45 p.m., we notified the government that Baldwin would cooperate. He identified 2 photographs from a photographic spread and generally told of his Watergate knowledge. He was again told, as we were, he would be a witness, not a defendant. He and O'Grady and I relied on this representation by the government, and plans were made for formal statements in the future. The conference terminated at 7:40 p.m. At the last show-up conference were Campbell, Glanzer, Silbert, FBI agents Lanzo and McKenna, O'Grady, Baldwin, and 2 or 3 other persons not known to me by name, but whom I assumed to be either agents or members of the staff of Assistant United States Attorneys handling this matter. Signed, Robert C. Murdo, dated in the lower left-hand corner, 7/6/72, 4:36 a.m. And then right below that, this is an accurate account of the happenings of 7/5/72 at the United States District Courthouse, room 3600K, and again signed Robert C. Murdo.
Mr. Chairman, I have no questions.
I have one further thing, sir.
Oh, sorry.
I'm still relying on that promise today as I testify here, and from the very beginning of my decision to cooperate on June 25th to now, I have attempted to tell the whole truth of this incident to the government. I believe then, as I do now, there is only one government, and I have talked truthfully to the United States Attorney, as I will do to this committee. I do not regret this decision, although my life was that time shattered. I cannot now find employment, and I have been without funds. My family has been disgraced. I believe that since I was working for the former Attorney General and White House officials, I would not question to do what I was asked to do. Now I regret only that decision. Regardless of this, I shall now follow through with my commitment to tell the government and the American people the truth.
Mr. Chairman, would the witness read the first sentence of that statement again?
To make a part of the record my understanding of my status in this total affair, I wish to read the following memo into the record.
Would you continue?
And then I read the memo, sir.
Yes, I know you did, but you made a statement about the same agreement still obtains. Turn to that part of it.
Yes,
Read that again for me.
I am still relying on that promise today.
What promise?
On the promise of the United States attorneys that if I cooperated, I would be a witness and not a defendant.
You conceive then that you are here as a witness before a committee of the United States Senate,
Yes,
and
sir,
that
I
any
do.
testimony you give us, you will in effect have immunity from prosecution by reason of the quote agreement made by the U.S. Attorney?
If I may answer that, Senator, we were not given formal immunity. It was our feeling at the time of the conference with the U.S. attorneys that they promised not to prosecute, on which we acted, would be sufficient for our purposes. We do not feel that there is any exposure, since Mr. Baldwin has already spoken and testified on the facts which he will testify to today.
Well, I just want it clearly understood that no promise by the U.S. Attorney is binding on this member of the committee.
We realize that. We just, our statement, we feel that there is only one government, and a promise from the United States Attorney would bar any prosecution by the government of the United States. That's our position, and that's why we read the statement into the record.
You understand my position?
Yes, I do, Senator.
Your position is that since the government promised that if you would cooperate, that they would make you a witness and not a defendant, and that was the reason why you cooperated on the trial and the reason you're still cooperating.
That's correct, Senator. And I've also cooperated with other Senate committee members.
I'd like to defer present time, Mr. Chairman.
Well, I will waive. Mr. Chairman, Senator Weicker has had an opportunity to interview with this witness on more than one occasion. He's from Connecticut, and I'd recommend, if we may, that we defer to him at the outset.
I certainly agree with you. That'd be advisable course.
Thank you, Senator Baker. Thank you, Mr. Chairman, members of the committee. Mr. Baldwin, on May 1st, 1972, you were contacted by James McCord with regard to employment. Is that correct?
That's correct, Senator.
When Mr. McCord called you, did he say how he had obtained your name?
I don't recall if it was during the first conversation or the subsequent conversation the following day, but he told me that he had obtained my resume from the Society of Ex-FBI Agents in New York City.
And did he describe the work that he wanted you to do?
On the initial phone call, he didn't go into explicit details. He said it was a matter of urgency, that if it was possible to come to Washington where he would like to interview me. But he did basically inform me that it would involve security work for the committee to re-elect the president, and at that particular time, in specific, some services with Mrs. Martha Mitchell, the wife of the Attorney General.
And did you go to Washington then on the next day, May the 2nd?
No, I went to Washington that night.
That evening?
That evening, yes, Senator.
And you met with Mr. McCord on May the 2nd?
I met with him the following morning on May 2nd. That's correct.
Now, on May the 2nd, did you visit the committee to re-elect the president?
That's correct, I did.
And as a result of that visit, were you employed by the committee?
Yes, I was.
Would you describe to the committee then your visit of May the 2nd to the committee to re-elect the president?
Well, the early morning hours, I did not know at that time, but Mr. Hoover had passed away that morning, and there was some confusion at the committee to re-elect the headquarters. What I had been told by Mr. McCord was the fact that Mrs. Mitchell would be departing that day for a trip to the Midwest. For approximately 2 hours or so, it was undetermined whether or not she would make the trip. After it was determined that she would, Mr. McCord then took me to the office of Mr. LaRue. He stated that I would...
Could you speak into the microphones more directly, Mr. Baldwin? I can't hear.
After it was determined that Mrs. Mitchell would make the trip, I was taken to the offices of Fred LaRue, who I was told would have the final say whether or not I was hired.
Did you meet Mr. LaRue?
That's correct. I had a very brief interview with Mr. LaRue that lasted approximately 2 or 3 minutes.
And was the decision to hire you made in your presence? Or in other words, at the moment that you had met Mr. LaRue, or did you leave the room and were informed of the decision later?
No, it was not in my presence. Mr. LaRue asked if I would mind waiting outside of the office. When Mr. McCord joined me in the outer office, he said, "It's all set. You're all set to go." I believe he might have even mentioned you're on board, something like that.
Would it be fair to describe then your hiring as having been accomplished by a combination of initially Jim McCord with a final say-so by Mr. LaRue?
Well, I was interviewed by Mr. McCord, but Mr. McCord, in the presence of Mr. LaRue, it was obvious that Mr. LaRue was making the decision.
Now, at the time that, or after rather, you were hired, on that particular day, were you given a weapon?
That's correct. I was issued a .38 snub-nosed revolver from Smith & Wesson.
Would you describe to the committee that particular incident? Was this on the same day of May the 2nd?
That's correct, after we left Mr. LaRue's office. This occurred in the security office adjacent to the main reception room on the 3rd floor of the Republican headquarters there on Pennsylvania Avenue. Mr. McCord went over to a file cabinet and removed the weapon either from the first or second drawer of the weapon, of the file cabinet, and stated, "You will need this while you're with Mrs. Mitchell. You know how to use one of these."
So, in other words, it's your testimony to this committee that Mr. McCord gave you the .38.
That's correct, he did.
Now, can you tell me what eventually happened to that weapon?
I retained possession of that weapon through the trip. When I returned to Washington, I had possession of that weapon. There was another trip scheduled on the Thursday of the week we returned. I believe we returned on May 8th, and I believe Mrs. Mitchell was scheduled to go out on another trip that Thursday. I was told that the decision whether or not I would go with her hadn't been reached yet, but in all likelihood I would be going with her to keep the weapon in my possession. I had to leave to go back to Connecticut to get more clothing, so the weapon stayed with me back to Connecticut. When I returned from Connecticut, Mr. McCord advised me that Mr. LaRue would be going with Mrs. Mitchell, and he had other work for me to do. And at that time he said, I believe it was, "You still got the weapon?" I said, "Yes." We went downstairs of the Roger Smith Hotel, and outside the barber shop he took it.
So the weapon was returned then to Mr. McCord?
That's correct.
All right, on that May the 2nd, were there any others that you were introduced to, any other individuals that you were introduced to at the committee to re-elect the president?
Yes, Mr. LaRue's office is in a cubicle where I believe Mr. Magruder's office is, and I also believe Mr. Odle. As Mr. Magruder passed from his office, I was introduced to Mr. Magruder. I don't believe I was formally introduced to Mr. Odle, but I believe Mr. McCord pointed him out, and Mr. McCord pointed out several other individuals. I was being introduced mainly to the security force that was present at the headquarters. I met some people in Mr. Mitchell's law offices. I was taken around to Mrs. Mitchell's office and introduced to different people at each one of these offices, as I would be going with Mrs. Mitchell as her bodyguard, and I was coming aboard. But several individuals were pointed out to me, but...
Was it indicated to you at that time as to the terms of your employment specifically, as to how you would be paid?
That question came up originally, Senator, on the night Mr. McCord telephoned me, because on the resume that was submitted with the Ex-Agent Society, I had listed a general salary for a year. Mr. McCord, I asked him about the salary. He told me that because of the fact I mentioned to him that there would be no sense in wasting your time or my time if the employment wasn't in the salary range that I was seeking. He did say there would be a discrepancy, that it would involve a matter of approximately $70 a day while I was with Mrs. Mitchell, and there would be a different rate when I was not working with Mrs. Mitchell. However, I was paid the same way at all times.
Did you believe at that time that your employer was the committee to re-elect the president?
Absolutely.
Do you have any documents in your possession which you believe to be supportive of that opinion?
No, I have documents in my possession that are contradictory to that position. It was my understanding prior to the criminal trial that efforts were being made to disown me from the committee, and as a matter of fact, I have a...
No, I intend, I'm just trying to keep this in logical sequence, Mr.
No, I have all the application forms.
Do you have in your possession a check from the Finance Committee to re-elect the president, or rather a Xerox copy of a check issued by the Finance Committee to re-elect the president?
That's correct. I received the check and cashed it, and I did make a photostat of the check. That's
Would
correct.
you go ahead and present that to the committee, please? Is there any other document that you have in your possession which again would indicate your employment by the Finance Committee to re-elect the president?
I have what is titled a Schedule D, itemized expenditures, personal service loans, and transfers, and then underneath that it says Finance Committee to re-elect the president. It's an itemized listing for a period of, I believe it's August 1st, 72 through August 9th, 72, and on that my name appears.
All right, and what is the amount listed beside your name?
It's listed $429.84.
For travel expense?
That's what the purpose of the expenditure, under the column purpose of expenditure, that's correct.
What travel expense do you believe that to refer to?
Well, I was told this was reimbursement for travel expense incurred while with Mrs. Mitchell. This figure coincides with a figure that I submitted regarding her expenditures spent on the trip.
So in other words, you believe this figure listed on Schedule D and also set forth on the check from the Finance Committee to re-elect the president as coinciding with a voucher which you submitted for travel expenses attendant to your trip with Mrs. Mitchell. Is that correct?
That's correct. A combination of her expenses and my expenses.
Have you presented your copy of Schedule D to the committee? And I would appreciate, Mr. Chairman, if both these items would be...
Records show that the two Xerox copies of checks are made exhibits and appropriately numbered, whatever the numbers would be in consecutive order of the previous exhibits.
Thank you, Mr. Chairman. Now, as your first assignment, did you make a trip to Detroit in Westchester County as a bodyguard for Mrs. Mitchell?
That's correct.
And did you return from that trip on May the 8th?
That's correct, we did.
On your return on May the 8th, or at any other time, were you informed by anyone that you had been fired by the committee to re-elect?
I've never received any official notification from anyone up to this date.
Did you at any time return to the office of Mr. LaRue and receive from him notification of termination of employment?
No, I did not.
Now then, to move to May the 12th, Mr. Baldwin, did you return to Connecticut at that time? Or rather, did you return to Connecticut after the 8th?
I returned approximately the 9th to Connecticut, yes.
And come back to Washington on May the 12th?
That's correct.
All right. Could you briefly describe your assignments between May the 12th and May the 23rd when you again returned to Connecticut?
Upon my return to Washington, I was advised that Mr. LaRue would be going with Mrs. Mitchell on the trip to Nebraska, and that Mr. McCord wanted me to perform other functions in the Washington, D.C. area, which would cover surveillance, activity. At that time, I don't believe there was any specific organization, but on a day-to-day basis, he would give me instructions where to go and what type of activity to perform.
Where were you housed? Where were you housed at this time?
On my return back, I stayed at the, I believe it's the Roger Smith, a block up from the committee headquarters. Mr. McCord advised me that he would like me then to move to the Howard Johnson, where he had obtained a room, and that to cut down expenses, I should stay at the Howard Johnson.
I don't want to have us get ahead of ourselves here. On May the 12th, you were still at the Roger Smith Hotel, is that correct?
On my return from Connecticut, I stayed at the Roger Smith, that's correct.
And Mr. McCord would come to the Roger Smith Hotel and give you instructions?
Yeah, that's correct. We had a breakfast meeting the following.
All right. And what did those instructions consist of?
Well, the first instructions were to move to the Howard Johnson, and from there he would brief me on the activities that were upcoming. There was a planned news conference on that Friday where Renee Davis was due in town, and he wanted me to go to the news conference and obtain any information I could.
Would it be, in order that we don't take overly much of the time of the committee, would it be fair to state that during the period between May the 12th and May the 23rd, you were principally engaged in surveillance activities of various activities, organizations, and occurrences in the Washington, D.C. area?
That's correct, Senator.
Now, at any time were you sent to the capital area to conduct these surveillances?
I believe it was the day after Governor Wallace was shot that I was assigned to go to the Capitol Rotunda where there was planned sit-ins.
During this period of time, were you sent to areas outside the offices of various senators and congressmen to observe persons in those areas?
That's correct.
Now, Mr. Baldwin, would you try to the best of your ability to recall these areas or the specific offices to which you went in order to observe persons in those areas?
I'm going to do some great injustice to some of the representatives, I'm sure, with their names. But I know I went to Senator Kennedy's office.
Why did you go to Senator Kennedy's office?
Well, on one particular day at the Capitol, a large number of demonstrators had been receiving Senate passes to the gallery area. This was also the day that the 3 astronauts appeared. And the information circulating amongst the different security officers up there was the passes were being issued by, I believe it was Senator Kennedy's office, and I'm not sure, I might have been Senator Gravel's office at that time. On one of my phone calls to Mr. McCord, I advised him of this, and he then advised me to go to the senator's office to determine what groups were in the area, how the passes were being handed out or distributed, who was doing it, obtain any literature that was being handed out, and basically try to determine what groups were in the area of the senator's office. That's how that particular incident.
Now, you mentioned Senator Kennedy's office and possibly also Senator Gravel's office. Are there any other representatives or senators whose offices you recall going to in order to observe persons moving about those areas?
Representatives from New York, I believe it was Bella Abzu, am my pronunciation correct on that, and Representative Chisholm, and I believe it was Mendel, Gravel.
Did you visit the office of Senator Muskie?
To the best of my recollection, I don't recall being in the area of Senator Muskie. No, those names I would have recalled.
Senator Javits?
That's correct, because it's Mr. Javits on the door.
Senator Proxmire?
That's correct.
Congressman Koch?
I believe that's, if he's the gentleman from New York, I believe that possibly is one of the other gentlemen from New York.
All right. Aside from that type of surveillance, did you also engage in the surveillance of demonstrations in the Capitol area?
I participated in the demonstrations in the Capitol. That's correct. Oh, I'm sorry. Just my attorney reminded me, there was also Representative McCloskey.
And Representative McCloskey's office was another, which
That's
you
correct.
Went to. You've already mentioned the Ronnie Davis news conference, the surveillance on the Hill. At any time, did you leave Capitol Hill to engage in surveillance activities?
There was a planned demonstration at the Air Force Base the day that the President was leaving for Moscow on a Saturday morning.
And who instructed you to go to Andrews Air Force Base?
Mr. McCord.
Did you receive, in other words, your instructions from Mr. McCord as to your surveillance activities, where they should take place?
That's correct.
Now, at the time of your return on May the 12th, you've already stated you moved to room 419 at the Howard Johnson's on Virginia Avenue, across from the Watergate. In whose name was the room registered?
I didn't know that McCord had just advised me that he had a room there, but subsequently when I went downstairs to ask for mail, I was told that it was under the name of McCord Associates. And I gave the desk clerk my name and asked if any mail was received there to put it into McCord Associates' room.
Now, there have been reports that, in fact, you were not employed by the Committee to Re-elect the President. And you've stated here already that you believe you were employed by the Committee to Re-elect the President. Did any events during this period of time serve to confirm that belief in your mind?
Well, I was instructed that if any time I was stopped by any government agency or law enforcement body regarding the weapon or regarding my presence in a particular area, that I was to do two things. Number one, advise them that I worked for the Committee to Re-elect the President, that I was in the security office of that department, and if that didn't work, to go on and then say that I was working for the former Attorney General John Mitchell. And then as a last resort, I had Mr. McCord's business card that said James McCord, Director of Security, Committee to Re-elect the President, and a telephone number. I was to give the person that card and that they would call and verify. So on at least 3 or 4 occasions, that process had to be followed where I had to identify myself.
When you say 3 or 4 occasions, can you state to the committee several of those occasions when you had to use Mr. McCord's card and telephone number as a means of identifying yourself?
I had no authority to carry the weapon, so when I flew home to Connecticut, I would declare the weapon. And I was flying Allegheny Airlines, so that every time I would fly, I would have to declare the weapon. And they would verify the fact. They would call right in front of me. The ticket agent and the manager would come out, usually of the office. They would make a call, and they would say, no problem. They would hand the gun back to me. Another time I was questioned by the FBI liaison officer on the Capitol Hill. He verified it, and then the day at Andrews Air Force Base, I was stopped by the Air Security Police, and they had a call down to the committee headquarters and verify it. On all occasions, I was told everything's okay. All my items of identification were returned to me, and I was on my way.
Were you given any sort of an identification pin as to belonging to the Committee to Re-elect the President?
Yes, I was. I was issued a lapel pin. It was red and white in appearance. It had an eagle on it. This pin allowed me to...
Where is that pin now?
That was turned over to the United States Attorney prior to the criminal trial.
Now, Mr. Baldwin, to keep on giving the continuity here, you interrupt me or state if I'm incorrect, but you returned to Connecticut on May the 23rd and came back to Washington on May the 26th. Is that correct?
That's correct, Friday.
And you returned to room 419 at the Howard Johnson's on May 26th. Now, when you entered room 419 on May the 26th, what did you see?
When I entered the room, there was numerous items of electronic equipment in the room. When I entered the room, it was approximately 2 p.m. in the afternoon, I believe, about that hour. And Mr. McCord was in the room and operating one of the receiver units. At that time, I didn't know what it was. He explained it.
In other words, this was the first time that you had seen electronic equipment in room 419 of the Howard Johnson's.
This particular piece of equipment that he was working on, that was the first time I had seen that. On the couch, there was a piece of electronic equipment which was contained in a briefcase that had been described to me that I had previously seen at the Committee to Re-elect the President Headquarters. This was called a debugger and a monitoring unit.
In other words, you've seen a portion of the equipment.
A portion I had seen previous.
At the committee to re-elect
That's
the
correct.
president.
That's correct. But the equipment that he was working on when I entered the room, I had never seen that before.
And as you entered the room, Mr. McCord was in the process of what? Experimenting with this equipment? What did he indicate to you at the time that you entered the room?
He was tuning the equipment. The unit was operating, and he was working the tuning dials. There are several tuning dials on the piece of equipment.
Did you have any questions of him as to exactly what was going on at that time?
No, I had just driven approximately 6 hours, and he said, as soon as you get unpacked and relaxed, I'll explain this. And I said, all right, I'll take a shower and shave and join you.
Now, Mr. Baldwin, was there a sequence of events leading up to a visit by other persons to the room that afternoon?
Well, I was told that some other individuals would be coming to the room that were part of the security force, and that in view of their position, they would be introduced under aliases to me, and that I would also be introduced. And Mr. McCord said, don't take this personal. It's no reflection on you, but because of the nature of the work we're involved in, I'm going to use an alias for you, and I'll use an alias for them. I'll be introducing them as...
What was the alias that he gave to you?
He asked me to use the alias of Bill Johnson, the alias I had used calling in on my reports while on the surveillance operation. It was the same alias I had used.
All right, then would you continue your narrative to the committee as to what happened that afternoon?
Are you asking regarding the introduction to the individuals that came to the room, Senator?
Well, I gather from what you've already told the committee that you were told that there was to be a visit by certain individuals connected with the security operations.
That's correct. They came
and
to
that and that you were given an alias.
That's correct. 2 individuals came to the room, and when they entered the room, Mr. McCord turned to me, and at this point, he said, Al, I'd like you to meet, and I believe he said, Ed, and he got all confused because he hadn't used the alias.
He hadn't used the alias, which you were
correct.
supposed to use in your conversation.
That's correct. And he was introducing him, I don't know if he said at that point Ed Gordon or how he did it, but he had a retrack, and then he tried to introduce me under my alias, and he couldn't remember it, and then he just introduced us under first names.
Right. Now, subsequently, have you identified who those 2 men were that came into the room?
That's correct. In the FBI photographic display, they were identified as Mr. Liddy and Mr. Hunt.
Now, that same evening of May the 26th, was there a trip to McGovern headquarters?
That's correct, there was.
Would you describe to the committee that trip and the evening's activity at McGovern headquarters?
Well, the purpose of my returning from Connecticut was to work that weekend. Mr. McCord advised me that there would be, we would have to work that weekend. I didn't know we were going to McGovern headquarters until we arrived at the scene. Prior to arriving there, we stopped. He had to buy some batteries. He sent me in to buy them. Then we proceeded to McGovern headquarters, and as we drove by the headquarters, he pointed to a building and he said, this is what we're interested in. We've got to meet some other people here. And then he proceeded to explain that we have to find our individual. One of our men is here. We'll be in a yellow Volkswagen. Keep your eyes open for the Volkswagen and for the man sitting in it. I think he even mentioned boy. I don't think he said man. There's a boy in the Volkswagen. He said, we have one of our people is inside the headquarters. The problem was that there was an individual standing outside of McGovern's headquarters, which was a second store headquarters above, and I believe they were stores. There was a chain across them. And this individual was there. This was late in the evening, approximately 1 or 2 o'clock in the early morning hours, and Mr. McCord was quite upset the fact this individual was standing in front of the store. He had no business being there, according to Mr. McCord, or he shouldn't have been there.
Did you meet any other individuals at that particular address?
That's correct. Mr. McCord had been in communication over a walkie-talkie unit with some other individuals, and at one point, as we proceeded on the same street that the McGovern headquarters is located on, we stopped adjacent to a light-colored car. Individual alighted from the car, and came into the front seat of Mr. McCord's car. I slid over, so I was between Mr. McCord and this individual.
Can you tell me who that individual was?
It was Mr. Liddy.
And did you succeed in getting into the McGovern headquarters on that evening?
No, they drove around. Mr. McCord and Mr. Liddy did all the talking, and they drove around. I don't know the exact length of time, but it was over a half hour. As a matter of fact, we drove up the alleyway adjacent to the buildings. They discussed the problem of lights. There was a discussion of whether or not their man was still inside. There was several discussions, and finally Mr. Liddy said that we'll abort the mission. That was his terms.
Now, Mr. Baldwin, what was your primary job then during the first 2 weeks of June? We've now moved from the end of May to June. What was your primary job during that period of time?
I was instructed to monitor all telephone conversations that were being received over these units that were in the Howard Johnson room, and to make a log of all units.
With reference to overheard telephone conversations and excluding anything to do with personal lives of those who were overheard, can you tell the committee the content of any conversations of a political nature?
I'm afraid we made a mistake when we passed the Omnibus Crime Act. It may be illegal to bring out yes. Anything about the contents. I think maybe we were very foolish when Congress passed that law, but I believe it is the law.
Well, I would decline to answer that respectfully, Senator, based on 18 Section 2515, prohibition of use of evidence of intercepted wire or oral communication, which specifically states under this federal statute that if I divulge those contents, I'm subject to possible prosecution.
On reflection, I think we were very foolish when we passed a law like that, but we apparently did.
About how many calls did you monitor?
Approximately 200.
Will you describe how you recorded these?
Initially, the first day, it was on a yellow legal pad. Mr. McCord took the actual longhand copy that I had made. Subsequently, he returned to the room, I believe it was on Labor Day Monday, with a electric typewriter. He asked me to transcribe my notes into typewritten form, making up duplicate copies, an original and an onion skin, and that's what I proceeded to do.
And then who would you transmit those logs to? Mr. McCord?
Mr. McCord received both the original and onion skin. That's correct.
At any other time, at any time, did you hand those logs to an individual other than Mr. McCord?
The one incident where I was telephoned from Miami and told to deliver the logs to the Republican headquarters, the Committee to Re-elect the President on Pennsylvania Avenue, which I did.
Now, during these first 2 weeks in June, did you engage in any other activities? Specifically, did you go over to the Democratic National Committee?
That's correct, I did.
Would you describe that particular incident?
Mr. McCord appeared in the room on Monday, I believe it was the 12th of June, and advised me that, well, he furnished me a $100 bill and said, you're really going to have a ball this week. You're going to go over to the restaurant. I want you to hang around in the cocktail lounge, the restaurant, do visual surveillances of anybody from the Democratic headquarters. I would also like you to, he gave me a pretext to take a tour of the Democratic headquarters. I didn't agree with his approach, and I asked him if I could do it a different way. I followed that way, and I was given a tour of the Democratic headquarters that day.
Prior to the weekend of June 16th, did Mr. McCord discuss the plans for the rest of that weekend and any subsequent plans? In other words, what was the schedule of events for the weekend of June the 16th?
Well, after the tour, Senator, of the McGovern headquarters, it was obvious that Mr. Lawrence O'Brien was not in the Washington area, and that he had been in Miami and had been working in Miami. So
may I ask you this question, Mr. Baldwin? Do you mean the McGovern headquarters of the Democratic National
I'm talking
Committee?
about the Democratic National Committee headquarters. After my tour there, part of the information I received was the fact that Mr. O'Brien had not been in Washington for the past month or so or longer. He had been in Miami. And Mr. McCord was quite pleased to hear this. And it appeared to me that it called for a rescheduling of the timetable because he got quite upset to the fact that he would try to make some arrangements for me to go to Miami. He had already discussed with me the fact that I would be going to both the Democratic and the Republican conventions. But in view of this information that Mr. O'Brien was in Miami, this seemed to change his timetable, and he, for the rest of that week, at several different points, told me he would like to get my identification sewed up and get me down to Miami. He had to confer with some other individuals regarding this, and as soon as it was approved, I would be going to Miami.
All right. Now, on June the 16th, at around 4:30 p.m., did Mr. McCord appear in the room at the Watergate?
Yes,
in the room at the Howard Johnson's?
Yes, he appeared at the Howard Johnson.
And what were your activities and his activities between 4:30 in the afternoon and 10 o'clock in the evening?
Do you want every detail, Senator?
I'd like you to tell in a broad narrative sense the committee as to what occurred.
Well, he gave me several instructions to buy some items for him, which I did. I tried to obtain some batteries, some regular flashlight batteries, and some what he called speaker wire, which is regular wire. I couldn't get the wire, so subsequently he left the room and went out. Part of the activities, he tested some type of a device on the phone. He tested a freestanding device next to the television. It had on it fire alarm unit, I believe. So and he had me soldering some batteries together during the course of that time. He made phone call, I believe, received one or two phone calls in the room. It was that general activity up to the point where he decided the difficulty was there was a gentleman working in the Democratic National Committee.
Did you know at that time that he had planned to go into Democratic National?
No, not until he was on the phone at one point, and he said, we still can't go over there because there's somebody working. And then I looked across, and there was somebody working in the Democratic headquarters. He then told me, we don't know whether we're going to abort. Approximately a half hour or so later, this individual left, and the decision was made to go across the street.
At 10 p.m. then, is it your contention that Mr. McCord left the room?
I don't know the exact time. Oh, no, he left the room later than 10 p.m. You mean to go to the Democratic headquarters?
Mm-hmm.
He left at one point to buy some equipment at a radio discount store or someplace, and he returned. Then subsequent to that, he again went across. Then he left to go to across the street to the Democratic National Committee.
Did he give you any instructions as to what your role would be on that particular evening?
The only instructions that I received was just prior to him leaving, he removed a walkie-talkie unit. I believe it hooked onto his belt, or he had it inside a belt loop. He put it on the table next to the television set, and he said, I'm going across the street. We've got some people over there. I want you to watch. If you see anything at all, any activity, get on this unit and let us know. That was it. He didn't tell me any type of a radio call to use. He didn't tell me any type of code name. That was the sum extent of his instructions.
In other words, would it be safe to say that he asked you to report over the walkie-talkie any unusual activity, but without specifying what it was that he was going to do, or what
he just said any
operation
activity
in the Watergate was going to be?
He said any activity anything you see, any activity across the street, you just get on this unit and let us know. And he walked out of the room.
All right, now, Mr. Baldwin, in your own, again, narrative way, why don't you describe to the committee your role and also what you observed in the early morning hours of June the 17th?
The first thing I observed was while I was on the balcony, just standing on the balcony, it was a beautiful night. and I was out
Is this
there.
balcony, Mr. Baldwin, as we take a look at the chart or the picture, this balcony is on the 7th floor
Room 723, that's correct.
of the Howard Johnson's Motel.
That's correct.
Please continue.
And I observed there was a guard standing in front of the building at 2600 directly across the Watergate complex. And I was watching this individual when a car stopped and 3 men alighted and proceeded inside the headquarters. I didn't really pay any attention. The gentlemen weren't
Mr. Baldwin, again, if we can, in a narrative sense, I don't want to get you ahead of yourself. You were out on the balcony.
That's correct.
Following the general instruction.
That's correct.
Of Mr. McCord to observe anything unusual. Is that correct?
That's correct.
The walkie-talkie was inside the room.
That's correct.
All right. Now, did you hear any conversation? This is prior to the arrival of
No, sir.
Any car or any individuals.
No, sir, I did not.
Did not. Did you observe anything across the way that was unusual?
No, sir.
In the way of lights going on or off?
No, sir.
Did you see any individuals?
I saw lights go on, but I believe it was just at about the same, subsequent to or just around the time of the arrival of the 3 gentlemen. I do remember observing the 3 gentlemen leave the car and go into the building.
All right, now pick it up from there. In other words, there were no observations up until the point in time when this car arrives and 3 individuals get out. Is that correct?
The first thing that really struck in my mind was the 8th floor of the building. The lights went on the entire 8th floor. And when the lights went on of the 8th floor, I went inside and I picked up the walkie-talkie, and not knowing whether to say Unit 1 or Base 1 or how to call, I just picked up the walkie-talkie, and I believe I used both designations, Unit 1, or I might have even said headquarters, I might have said Base 1 to any unit. Do you read me? And then a voice came on it back, I read you, go ahead, what have you got? And I said, the lights just went on the entire 8th floor. He said, oh, we know about that. That's the 2 o'clock guard check. I said, okay. And they said, all right, let us know if anything else happens. I put the walkie-talkie down and I proceeded out on the balcony again. I noticed the lights flicker on the 6th floor of the Democratic National Headquarters to the extreme right. They just went on briefly and went off. I went back inside, picked up the walkie-talkie, and as I was standing in the doorway when I observed these individuals coming out on the balcony of the Democratic National Committee.
Which individuals are you referring to?
There were 2 individuals. Do you want me to describe them?
I want you to describe to the committee what you saw that night.
One individual had on what I would call a windbreaker that appeared to have a university emblem and a university written across his one of the chest area. The other individual had a weapon out, and they were both of them were casually dressed. And one individual sort of had long blonde hair, a stocky built individual. As I observed them, I called over the unit again, Base 1 or Unit 1. Are our people in suits or are they dressed casually? And the call came back, our people are dressed in suits, why? And I said, well, you've got some trouble because there's some individuals out here that are dressed casual and they've got their guns out. And the guy on the other end went a little bit frantic.
Well, all right. Now
I put the walkie-talkie down and he continued to yell over it, are you reading this? Are you getting us? Come in, hello, anybody there? Well, I knew he wasn't calling me. So I went out on the balcony and I just stood there and watched these individuals as they proceeded to search the balcony. A third individual had also come into the office area, turned the lights on, and was searching in that office area. So there were 3 now on the scene searching.
Were you able to observe anyone else on the street below?
I don't directly recall at that specific point, Senator, of time right then.
Why don't you continue your narrative then?
Well, the individuals then went into the office and proceeded to the left of the building, and as they passed through, the corridor light was on, and as they passed by various office doors, eventually they went out of sight, and I didn't see them. I believe it was about this time that a voice came over the unit that said, they've got us, a whisper, something like, "They've got us." And then what I believe was Mr. McCord's voice in the distance saying, "Are you gentlemen Metropolitan Police?" or something to that effect. And then another voice came on. He said, "Are you still across the street?" And I thought, if somebody's listening, you know, I didn't know what was going on. I just said, "Yes, I am." They said, "Well, we'll be right over." Subsequent to that, I saw two individuals walking out between the Watergate building directly across and the one closest to the Capitol building here. They came out an alleyway.
Can you identify those two individuals?
One of the gentlemen looked up at me. I was still on the balcony. He was just looking at me. That was Mr. Hunt, the other individual. He was dressed in a windbreaker, sort of windbreaker, and I believe a casual shirt. The other gentleman was dressed in a suit, and from my observation, he didn't look up, but I had the belief it was Mr. Liddy.
All right. Did you see Mr. Hunt go over to the Howard Johnson's motel?
No, they walked up in front of this far complex, almost directly in front of that lobby, got into a car and proceeded up the street. And as soon as they were in the car, another voice came over there, walked in and said, "I'm on my way." And approximately 2 or 3 minutes later, Mr. Hunt came into the room.
All right. Mr. Hunt came into the room. Would you describe Mr. Hunt's entry into the room?
Everything?
Everything.
Well, he proceeded over, and I was standing there in the balcony area, and he crouched down behind a table. He said, "What's going on? What's going on?" And just about this time, they were leading Mr. McCord and the other gentleman out of the front of the lobby, and there were all kinds of police cars there. And I was standing on the balcony. I said, "Well, come on out. See?" And he said, "I got to use the bathroom." And he went into the bathroom, and he came out, and he said, "I've got to call a lawyer. Where's your phone?" And I said, "It's right there." And he went over and he dialed a direct dial number, because in the motel room, when you want to place a long-distance call, you have to go through the desk. So he dialed 8, as I would do when I dialed a local number, and he dialed a direct dial number. And he proceeded to talk. I paid no attention to the conversation. I went back on the balcony and continued to watch. I did hear him state that I've got $5,000 cash on me now for bond or bail if we need it. And then something to the effect, "Will you go right down, or should I go down?" And I don't remember. That was it. He then proceeded to give me instructions what to do with the equipment.
And what were those instructions?
Well, he removed a walkie-talkie, put it on the bed, and he told me to pack up everything. I believe his expression was, "Get it the hell out of here. Get yourself the hell out of here. Go somewhere. Where are you going to go?" I said, "Well, I can go to Connecticut." And he said, "Well, go." And he said, "We'll be in touch. You'll get further instructions."
Now,
he said, "I want you to take all this equipment to Mr. McCord's house." And I had a little debate with him about that, because I said, "Well, there's 2 of you, and there's only 1 of me. Why can't you drive it, and somebody can drive you back? If I get out there, I have no way to get back." He said, "Mrs. McCord or somebody will drive you back. You work that out." And he proceeded to go out the door, and he went down to the elevator.
Now, he went out the door, and was he running down the hall or
Yes,
walking?
he was. No, he was departing.
And did you say anything to him as he went running down the hall?
Yes, I did.
What did you say to him?
I asked him if this meant I wasn't going to Miami.
Now, Mr. Baldwin, did you accidentally, in the course of cleaning up the room, did you accidentally pick up certain memos from Mr. McCord's bag? And if so, could you describe the nature of those memos?
That's correct. After I was given the instructions to pack up everything and get out, which meant putting all the electronic equipment away, Mr. McCord's briefcase was open. He had left his wallet. I didn't see him leave his wallet. He had put his wallet, all his change, his car keys, all his personal effects were on the bed. I proceeded to put those inside his briefcase, inside his briefcase, attaché case. And then I proceeded to collect all of the logs, not the logs of, I believe there was one, might have been one call that day that was still in the room on the log sheet. And I put that with all the yellow pad into his briefcase. And at the time I did, I took everything off of the table area that was the work area. And along with that went a insurance book that had the dates in it different that I had been keeping for myself. And I threw all that material into Mr. McCord's briefcase. And when I realized I had put my own personal notebook in there and the yellow pad, I proceeded to remove those. And I didn't stop to separate the papers. I just threw them into my attaché case. And when I arrived back at Connecticut, I had some memorandum that belonged to Mr. McCord. I immediately wrote him a letter telling him that.
Do you still have these memorandum?
That's correct. I have those memorandum.
All right. Would you care to turn those over to the committee at this time? Mr. Chairman, these are memoranda, I would say, in most instances, a rather routine nature. By way of identification, just in order that nobody feels that anything is being kept from them by this committee, I would identify them as follows, and the originals are now being given to the committee. And I would very much like to have them marked for identification and numbered as exhibits. There are two memoranda which are personnel reports on individuals who had made application to work at the committee to re-elect the president. There is further a memorandum which is on committee for the re-election of the president heading. It is to Mr. Robert Odle from James McCord, and it describes or relates to security at the Republican convention. Then also there's a group of papers. Which I would best describe as relating to Jack Anderson. The memorandum, the top memorandum, is confidential subject Jack Anderson, and it's signed James McCord. This group of papers relates to Mr. Anderson. Yes, indeed, Mr. Chairman.
Let the record show that each paper writing identified by the witness will be appropriately numbered and received as an exhibit. The reporter assigned an appropriate number to each.
The committee can retain them. I have no use for them at all.
Now, am I correct, Mr. Baldwin, am I correct that these are all of the memorandum which you accidentally took from Mr. McCord's effects and have held in your possession? Is that correct? Are there any others aside from the ones that I have mentioned here?
No, sir. There are no others.
Now, recently there have been suggestions, Mr. Baldwin, I'm almost through, to turn the remainder of the questioning over to the committee. Recently there have been suggestions that you were a double agent working for the Democrats.
I believe that Counsel called my attention that the memorandum related to Jack Anderson. He doubts whether it should be made public.
I have not tried, Mr. Chairman, to reveal the contents of any of these memoranda, but just for identification purposes, I've turned them over to the committee.
Mark them for identification rather than exhibits, and then we can see them later.
Mr. Chairman. Recently, there have been suggestions.
They're not going to be printed in the record unless we have the committee orders at the subsequent time.
I've tried. I think what I've tried to do here, Mr. Chairman, is to make sure that names are protected, but that whatever memorandum this man had in his possession that came from that room on that night has been turned over to the committee, and not for any purpose of embarrassing anyone.
They'll not be publicly released or printed in the record, but they will be marked appropriately for identification purposes rather than as exhibits.
Now, again, to repeat, Mr. Baldwin, recently there have been suggestions that you were a double agent working for the Democrats. I want you to describe to this committee, first of all, any incidents that may have led to such comments being made.
Well, I believe the Number one incident may be the fact that I was not a defendant in the criminal action that preceded this incident. There have also been incidents in the paper that Mrs. Mitchell has attributed to the fact that I had stated to her on different occasions that I was a Democrat.
What is your...
I do have Democratic friends. I wouldn't deny that, but I have been a registered Republican since I've been old enough to vote, so I don't know if that makes any difference. And at the time of the trial, the criminal trial I'm speaking of the defendants, during the course of the days that we were roomed at the United States Attorney's Office, the conversation was initiated on several occasions by one or two of the detectives that the only way I could have gotten away was the fact that I was a double agent. There was some kidding back and forth amongst the police officers, and that, to the best of my knowledge, is the only indication that I have of, and other than the fact I've heard statements made by different individuals that I was a double agent on television and in the newspaper.
Was there not one additional incident which actually came to the attention of Mr. McCord?
I believe, Senator, are you referring to during the course of my employment in Washington where I had a date with an individual, a young lady that happened to work for the for an official of the Democratic Party? I don't believe that would have led Mr. McCord to believe I was a double agent. As a matter of fact, he wanted me to exploit that and to obtain all the information I could obtain from her, and I kind of refused to go along with that.
But just so that your entire story is set on the record, Mr. Baldwin, it is true that you were with a young lady who was in the employ of an official of the Democratic Party. Is that correct?
Well, she was in the employment of an attorney who had an affiliation with a Democratic Party organization in the Washington, D.C. area. I don't mean to imply that he was an official working at the Democratic National Committee offices. No, he had a law office in the Washington, D.C. area, and she worked for him. She was going to the convention for the Democratic Party in Miami. She told me that and thought we might see each other down there.
Right. But in other words, these are the only three incidents that you can bring to mind that might have given rise to any speculation as to your being a double agent in this matter. Is that correct?
That's correct.
Now, would you state to would you please go ahead and state to the committee your own feelings on this matter? Have you received at any time any payment of promise, any promise of payment, any income from anyone associated with the Democratic Party?
Absolutely not. As a matter of fact, I have 3 weeks of pay from the Republican committee that I haven't been paid for either.
And lastly, Mr. Baldwin, would you just give the committee a very brief description of your professional background prior to being employed by the committee to re-elect the president? Specifically, did you work for the Federal Bureau of Investigation?
That's correct. I graduated from Fairfield University in 1957. I entered the United States Marine Corps. I was a member of the Marine Corps Reserve with the rank of captain. I'm no longer a member of the Reserve. I then entered law school in 1960. Upon graduation from law school, I entered the Federal Bureau of Investigation as a special agent. I resigned from the Federal Bureau of Investigation. I worked for the circuit court system in the state of Connecticut, and at the same time, I was also an instructor in police science at a local university.
All right. Now, you've testified here today that you took an active role in what you must have known was an illegal phone tap and a break-in. And as you just stated, you're a former FBI agent, graduate of law school, employee of various law enforcement agencies, and my final question is, why did you, with this type of background, take part in such activities?
Well, with this background, Senator, I have been in organizations where I've always taken orders. I didn't question the legality of the operation because of several factors. I had come down from Connecticut to work for the committee to re-elect the president, and that was the president's organization as far as I was concerned. Mr. Mitchell was heading the organization. Every individual that I was introduced to or that was pointed out to me, I was advised, this is a White House consultant, this is a White House aide. They're on loan as soon as the election's over in November. They go back to the White House, Al. If we do a good job here, my sole goal was to obtain permanent employment. And Mr. McCord had been, I knew that he was an ex-FBI agent. They had been in the CIA. Based on the credentials of all these people, I didn't question, possibly that was a wrong assumption on my part, not to have questioned, but I didn't, the legality. I've been asked if it entered my mind whether I thought it was illegal. I realize that there are wiretaps that are illegal, but I also realize that under certain conditions, such a wiretap can be ordered or authorized by specific individuals. And I felt that I was in no position to question John Mitchell or anyone else under his command, including Mr. McCord.
But it's also true, Mr. Baldwin, that you never received any direct order from John Mitchell, is it not, relative to that phone tap operation?
Other than the references to Mr. Mitchell, if I was involved in any difficulty establishing my authority for being in a certain place or the fact of the weapon, I was to mention John Mitchell.
With the exception of the time when you took the trip to Chicago and Westchester, or rather to Detroit and Westchester County with Mrs. Mitchell, you received all your orders from Mr. McCord, is that not?
That's correct.
Is that not correct?
That's correct.
And now, just to finish up on the time sequence, you left the Howard Johnsons on the early morning of the 17th of June, is that correct?
That's correct.
And where did you go to from the Howard Johnsons?
I proceeded to Connecticut.
Did you first go to the McCord home?
Oh, I assumed, Senator, you had covered the fact that I had delivered the items of equipment to Mr. McCord's home. Mrs. McCord drove me back to Washington. I then took my own personal car and returned to Connecticut.
All right, Mr. Chairman, this is all the questioning I have for Mr. Baldwin. There are events of which counsel know that transpired after Mr. Baldwin's arrival in Connecticut, and this is something that the committee should go ahead and develop. I have no further questions.
I may have followed Homer's example and nodded, but did you ask Mr. Baldwin about what he did with the information he got from the wiretap?
Mr. Chairman, I could have possibly missed such a question. I'll ask Mr. Baldwin again in any event as to who you gave this information to, the information on the wiretaps. As I understand it, who did you give it to?
Other than the time I delivered it to the committee to re-elect the president, I gave it to James McCord at all times. The onion skins were still in his briefcase the night I locked his briefcase. And some of them, I can't specify that every single copy of the logs were in his briefcase, but the night I delivered the logs to his home, the copies of quite a few of the conversations were in his briefcase.
Every time it is your testimony then that you gave these items to Mr. McCord with the exception of one time when you delivered them to the committee to re-elect the president.
That's correct.
And who did you give them to on that occasion?
I left them with a guard that was in the lobby. I arrived after 6 o'clock, and the guard was stationed in the lobby. The offices had been closed.
I don't know whether he brought out what form he put them in. How did you take these things, the information you gave to Mr. McCord with the exception of that one occasion? What form was it in?
I'm sorry, Senator, do you mean the actual way I transcribed
the information that you got while you were at Howard Johnson from the Democratic headquarters, what form was it in when you gave it to Mr. McCord?
The initial day, the first day that I recorded a conversation, it was on a yellow sheet. On Memorial Day, I believe it's on the holiday, May, I believe it was 28th, when he returned to the room, he brought an electric typewriter. He instructed me in the upper right-hand corner to print, or to type rather, unit, the date, the page, then proceed down into the body, and in chronological order put the time and then the contents of the conversation. In my error, I used as unit, I used the exact frequency that we were monitoring. And after about 2 days, Mr. McCord came back and said, change that. Anybody reading these things is going to know the frequency.
And you typewrote a summary of the conversations you overheard.
Well, they weren't exactly as I would say they were almost verbatim, Senator.
Almost verbatim. And then you gave them to, and the names of the people that, who, as far as you could identify them, they were using the phones.
Well, that's correct. Initially, it was very hard to establish names, maybe the first day or two. But subsequent to that, you see, the problem was I had never worked one of the units before, and then after Mr. McCord instructed me on how to operate it, I could tune it so that the minute the call was either going out or coming in, I would then be in on the beginning. But prior to that, I would receive the little indication on the scope, and I'd be into the conversation. So I don't know who they asked for or who was calling out. But eventually, that was corrected.
And then you gave all of the typewritten transcriptions of what you heard to Mr. McCord, except on the one occasion you mentioned.
That's correct,
You
Senator.
didn't keep any carbon copies or anything.
No, Mr. McCord had the onion skins, and they were still in his briefcase the night I locked it.
Mr. Baldwin.
Yes, sir.
It's 10 minutes after 5 in the afternoon, and rather than proceed much further with the questioning, I'm going to ask you a question or so on, or rather a few questions about a topic or so. Counsel and other members of the committee necessarily will defer their questioning to later, so I assume you're agreeable to returning at the committee's pleasure to answer questions. You're the first witness we've had in a long time who's been able to smile. On the night in question, the morning of June 17th, 1972, when you were standing on the balcony of Howard Johnson's, you testified that you saw the lights come on the 8th floor. You saw 2 men on the balcony of the 6th floor. You called on your walkie-talkie on the second occasion and said, "Are your men dressed casually?" Someone replied, "No, they're dressed in business suits." You know who you were talking to?
No, I didn't, Senator.
Who had you been talking to previously inside the DNC?
With the walkie-talkie? Well, I had used the walkie-talkie with anybody. Mr. McCord had the walkie-talkie at all times, as I say, just prior to him going across the street.
Could you distinguish by the quality of the transmission who you were talking to? Did you recognize the voice?
McCord's voice I could recognize. My assumption that I had to make was that there were 2 other units beside mine in operation. One unit that was turned on and the other unit that was turned off, because it was very obvious that one of the units was not on at a particular point.
All I'm striving for is to know whether you can identify the person you communicated with when you ask, "Are your men dressed casually?"
I would be taking I'm not positive of it, but this question, I wouldn't want to implicate somebody without being positive, but I would recognize the voice subsequently as being Mr. Hunt, since I've heard it on several occasions.
Hunt was inside the Democratic National Committee?
Senator, I didn't know where any of the individuals were other than Mr. McCord when he walked across the street. I had no knowledge how many or who were across the street. They didn't. The actual way I transcribed
the information that you got while you were at Howard Johnson from the Democratic headquarters, what form was it in when you gave it to Mr. McCord?
The initial day, the first day that I recorded a conversation, it was on a yellow sheet. On Memorial Day, I believe it's Memorial Day, on the holiday, May, I believe it was 28th, when he returned to the room, he brought an electric typewriter. He instructed me in the upper right-hand corner to print, or to type rather, unit, the date, the page, then proceed down into the body, and in chronological order put the time and then the contents of the conversation. In my era, I use as unit, I use the exact frequency that we were monitoring. And after about 2 days, Mr. McCord came back and said, change that. Anybody reading these things is going to know the frequency.
And you typewrote a summary of the conversations you overheard.
Well, they weren't exactly as I would say they were almost verbatim, Senator.
Almost verbatim. And then you gave them to, and the names of the people that, who, as far as you could identify them, they were using the phones.
Well, that's correct. Initially, it was very hard to establish names, maybe the first day or two. But subsequent to that, you see, the problem was I had never worked one of the units before, and then after Mr. McCord instructed me on how to operate it, I could tune it so that the minute the call was either going out or coming in, I would then be in on the beginning. But prior to that, I would receive the little indication on the scope, and I'd be into the conversation, so I don't know who they asked for or who was calling out. But eventually, that was corrected.
And then you gave all of the typewritten transcriptions of what you heard to Mr. McCord, except on the one occasion you mentioned.
That's correct,
You
Senator.
didn't keep any carbon copies or anything.
No, Mr. McCord had the onion skins, and they were still in his briefcase the night I locked it.
Mr. Baldwin.
Yes, sir.
It's 10 minutes after 5 in the afternoon, and rather than proceed much further with the questioning, I'm going to ask you a question or so on, or rather a few questions about a topic or so. Counsel and other members of the committee necessarily will defer their questioning to later, so I assume you're agreeable to returning at the committee's pleasure to answer questions.
Sure.
You're the first witness we've had in a long time who's been able to smile. On the night in question, the morning of June 17th, 1972, when you were standing on the balcony of Howard Johnson's, you testified that you saw the lights come on the 8th floor. You saw two men on the balcony of the 6th floor. You called on your walkie-talkie on the second occasion and said, "Are your men dressed casually?" Someone replied, "No, they're dressed in business suits." You know who you were talking to?
No, I didn't, Senator.
Who had you been talking to previously inside the DNC?
With the walkie-talkie? Well, I hadn't used the walkie-talkie with anybody. Mr. McCord had the walkie-talkie at all times, as I say, just prior to him going across the street.
Could you distinguish by the quality of the transmission who you were talking to? Did you recognize the voice?
McCord's voice I could recognize. My assumption that I had to make was that there were two other units beside mine in operation. One unit that was turned on and the other unit that was turned off, because it was very obvious that one of the units was not on at a particular point.
All I'm striving for is to know whether you can identify the person you communicated with when you ask, "Are your men dressed casually?"
I would be taking I'm not positive of it, but this question, I wouldn't want to implicate somebody without being positive, but I would recognize the voice subsequently as being Mr. Hunt, since I've heard it on several occasions.
Hunt was inside the Democratic National Committee?
Senator, I didn't know where any of the individuals were other than Mr. McCord. When he walked across the street, I had no knowledge how many or who were across the street. They didn't.
But the voice you heard reply, "No, our men in business suits," was not McCord's voice?
Absolutely, I would know Mr. McCord's voice.
And it's your best judgment that it was Mr. Hunt's voice?
Hearing the voice subsequently, yes.
Have you subsequently learned that Mr. Hunt was not inside the Democratic National Committee, but rather was in the Howard Johnson's motel?
No, I learned that Mr. Hunt was in the Watergate Hotel directly behind the Watergate
I'm sorry, that's what I meant to say, in the Watergate Hotel, but not in the Democratic National Committee headquarters.
That's correct. It's my understanding he was in the hotel, which is part of that building, but to the rear of the Democratic National Committee.
So, as far as you can tell, your inquiry about clothing never reached anyone inside the Democratic National Committee headquarters?
That's correct. The only indication I have of any communication was when a gentleman got in and said, "They've got us," in a whisper. And then what I would definitely describe as Mr. McCord's voice saying, "Are you gentlemen Metropolitan Police?" to that effect.
Do you know the officers who arrested the...
I didn't at the time. I do now.
Had you ever known any of them before?
No, sir. I had, as during the course of the trial, we communicated, Mr. Schaffner and I had observed each other at several of the demonstrations, I believe. Now, I remember observing him, and I think he remembers observing me. We were both using the same phone to call in.
What do you mean you were using the same phone to call in?
Well, you have to make reports every 2 or 3 hours, and Mr. McCord wanted activity reports, whether or not any groups were moving or what groups were there and who was there. And several times I was the only one there.
Are you speaking about Mr. Schaffler using the same phone?
No, at the day of the Capitol demonstrations, and I believe before the march to the Capitol, there were several days of preparation for the march, and there was gatherings around the Washington Monument, several campsites set out. And I think we crossed paths on several occasions because both of us were dressed in fatigue jackets, and we sort of remembered each other. And he finally said, "Oh, now I know who you were."
Did you recognize him on the balcony of
the night? No. He was the gentleman that, you see, when, at a subsequent date, I learned it was Sergeant Leeper, I believe, sort of stood, when he came out, stood there and observed Mr. Schaffner, Detective Schaffner. He was a gentleman that was proceeding along the balcony in a rather dangerous situation. So he was more or less looking around the side of the building, and he had a flashlight up, but I couldn't say for a fact at that time that it was the same man. We didn't realize this until we were at the trial, that we had been in demonstrations after we got talking together.
Mr. Baldwin, the hour is late, and I have other questions, as Senator Weicker probably does, and the chairman, but I'm going to stop now with your assurance already given that you'll return if and when we need you.
Thank you, Senator.
Thank you very much.
You are, as I understand it, it's satisfactory to excuse the witness with the understanding he will return when the committee needs him further. To that which we will adjourn till Tuesday morning, February the 5th, 10 a.m., where we'll meet again in this room. June the 5th, Tuesday, June the 5th, 10 p.m. in this room.
10 a.m.
10 a.m., yeah.
The hour's late. The hour's late.
Bob, when was...
And that's how it all ended today. 5 days of hearings are over. 3 additional days being added, beginning June 5th.
Despite the lateness of the hour, there are a couple of obvious things to talk about and try to digest. Specifically, what was accomplished today, and more importantly, what had these 5 days produced that was new and startling or old and significant? If you've watched it all up till now, of course, you can draw your own conclusions. But to help us all, we're going to ask our 2 resident experts of the day to add their perspectives. They are Alan Barth, longtime Washington journalist and author of the book Government by Investigation, and Dean Adrian Fisher of the Georgetown University Law School here in Washington. Gentlemen, where are we after 5 days? Alan?
I've been turning that over in my my overcrowded mind, which has received so many impressions that I'm not entirely sure what I think. But I'm pretty sure I think that that this has been useful and worthwhile. I think that it's been the indispensable means of giving to the American people a genuine basis for judging where the responsibility lies for Watergate, with all that term implies of moral decay and skullduggery and meanness. I think that the congressional investigation, with all its faults, and this one has been singularly free from them so far, is a great engine for the discovery of truth and for the presentation of it to the public, which will come to its own conclusions when it's heard the facts.
What do you think, Dean Fisher?
Well, I agree with all that Alan has said. Being much more short range, I think the last 2 days, and particularly this morning, represented the failure of an attempt to impeach McCord. He may have been impeached 5%, 10%, but they were trying to shoot him down. Now, I think the evidence showed that he perhaps said a little bit more about about Mr. Alch's relationships from the CIA than in fact existed, but the evidence did show that most of the things he talked about were sustained, particularly when McCord said that he felt that he was under pressure with an offer of clemency. You know, when you add everything together, I think it was not unreasonable for him to reach that conclusion. I think a reasonable man couldn't reach anything else. So the attempt to go after McCord, apart from the fact that he's a little bit more detailed on some things than I think the facts are, he sort of knows more about things than are so. You know, it's but the attempt to impeach him, I don't think failed.
And the importance of that being that McCord is the most significant witness so far, and the only important person who's come forward to tell all.
Because McCord is the man who has laid out the structure and substance of the plot.
And it was obvious, was it not, that the senators realized his importance, and that's the reason they kind of went at Alch a little more strongly than they had some of the other witnesses, as you said earlier.
I think it's fair to say, as Senator Ervin said, that for the most part there's been a splendid spirit of bipartisanship. It began to come apart at the seams just a little bit, didn't it? In that contretemps this afternoon about lie detectors. Senator Baker was in a disagreement with Senator Ervin about it. Perhaps he should have known that Senator Ervin has been a tiger about lie detectors for a long, long time, and for my part, I think quite rightly.
Speaking of the senators, have any of their careers been damaged or enhanced politically, do you think, as a result of these first 5 days?
Oh, I don't think anyone has been affected that much. I think this is strictly from a worm's eye view from a former Tennessean. I think Senator Baker has got a real chance to prove himself a statesman on this. But if he uses the lie detector issue in a political way, which he showed signs of doing about just a little bit before lunch, it seems to me that at least one person, even though only a former Tennessean, that's had rather high hopes for him will change those hopes.
What do you think, Al?
I think his status has been enhanced. I've been impressed with the kind of central casting quality of that row of senators up there. They look as though they've been picked for individual characteristics, and there's a nice range of diversity in there. Of course, several of them, it seems to me, have been playing the role of the country, almost bumpkin lawyer, have been talking in very plain country talk. They're about as naive and innocent.
Well, maybe it's real, Alan. Maybe.
Well, I
It's
don't
real
think...
with the country lawyers, you know.
I think that Senator Talmadge has taken the prize in that particular character casting.
Gentlemen, thank you very much. We hope you'll be back with us when we come back in June. NPAC correspondent Peter Kay talked with Chairman Ervin at the end of today's hearings and found that despite the committee's running a bit behind schedule, the senator was happy with the results so far. He was pleased that no partisan split has yet appeared.
This morning particularly, I noticed your questioning got a little sharper and a little more persistent. Is that because of the nature of the testimony, or is it because you feel that some partisanship is beginning to creep into the hearing?
No, I think there's been a surprising lack of partisanship in the committee. I think both the Democratic members and Republican members have shown a most commendable determination to try to seek out the truth. I've been highly pleased with the efforts of all members of the committee and the counsel, I think the counsel for the committee, Mr. Dash, has done a superb job in presenting the evidence, and I think his assistants, the legal staff, and those who are the investigators and everybody on it, including the clerical help, have done a magnificent job. They've worked long hours under trying circumstances, and I am highly pleased with the accomplishments of the committee thus far.
Are you still planning to follow the same game plan, if I can use the word, of starting out with more or less the smaller fish and working up to the bigger and more important people?
Well, that's not our objective. I think we had to go, since the most bizarre incident involved was the actual bugging and breaking of the Watergate, that we felt like we had to start with that incident, and then branch out, because you can't present all the testimony at one time, and you try to present it in an organized fashion. The objective of the committee is to try to deal with the first, what we consider the first phase of this, that is the bugging and the breaking of the Watergate. And then later hearings, we intend to go into the question of the collection and use of campaign funds on a considerable detail. And then as we are able to make investigations, the committee intends to go into the allegations tending to show that some persons attempted to organize a campaign to sabotage the campaigns of various candidates for the nomination, that is, Democratic nomination, who sought to run as the Democratic nominees in the 1972 election.
Well, right away you broke new ground and got into testimony that there was an attempt possibly to cover up, an attempt to keep the trial from proceeding as it should. Is that one of the startling revelations you mentioned?
Well, this first phase has a twofold objective. In the first place, the bugging and the break-in of the Watergate, and then that we, in connection with that, we go into the allegations that there were efforts made to cover up and hide what actually happened, and who procured the bugging and the break-in, and what their motivations were.
Can we look for any more testimony, such as the Caulfield-McCord testimony about a cover-up or a hush-up?
Well, I think we'll have a great deal more testimony on in connection with alleged efforts to cover up the responsibility of those who procured the break-in and entering.
You wouldn't speculate on how high it will reach?
I would not. I have I've spent most of my life, a large part of it, as a judging what Walter Malone called my fellow travelers to the tomb, and I have made it a practice, as a result of my judicial experience, not to conjecture or surmise as to what the evidence will ultimately show.
Senator Ervin, disciplined by years of legal decorum, declines to speculate, but the nation is speculating. Public television hearings like these can only invite people to speculate, as they invite speculation from stock analysts and international money dealers and the foreign governments dealing with the United States in a multitude of ways. Senator Ervin, in his interview there with Peter Kay, indicated how sensitive he is to the effect the disclosures may be having. Yet I wonder whether the 5 days of so much detail pouring out of the television sets of America have not begun to produce another effect. It was one that Senator Baker predicted when I talked to him last week before the hearings began. He thought that public emotions on Watergate had then reached their high point, and that there would be a calming effect as the real facts began systematically to emerge. Well, each one of you will have your own ideas on that. It's something to consider in the break before the hearings resume on June the 5th. We'll see you then. And as we end this second week of hearings, we'd like to thank the 25,000 of you who so far have written letters approving, or at least commenting, on our coverage, most of them approving. What you say has an influence on what we'll do for the remaining days of these hearings as they stretch on through the summer. And that's why we'd like to solicit comments from those of you who might still want to share your views with us. And is this the kind of coverage you think public television ought to be doing? You can send cards to NPACT, Box 300, Washington, D.C., 20044. For Jim Lehrer, Peter Kay, and the staff of NPACT, I'm Robert McNeil. Good night.
From Washington, you've been watching gavel-to-gavel videotape coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. This coverage is made possible by grants for special events coverage from the Corporation for Public Broadcasting and the Ford Foundation, and has been a production of NPACT, a division of the Greater Washington Educational Telecommunications Association.